leave to file an urgent motion dispensing with the Rule 26 of the Milord, in which I am myself is one of the petitioners, Milord. In an election is going to be held in our housing society in complete violation of the order passed by the competent authority government of West Bengal. Milord, if I file it today, Milord, 2 days will be taken for registration, then service, Milord. It will.
When the election is there.
Election is going to be held on 10th.
Why the writ petition? Why you're not going to the civil suit?
No, my lord, civil suit is not maintainable. The order is passed by the quasi-judicial administrative authority of this.
Already order passed.
Yes, in my favor. And my lord, everything is done by the private respondents in violation.
When the order was passed.
My lord, order was passed on 17th of November, my lord. Thereafter, I communicated. 2 applications I submitted before the competent authority for enforcement. They are simply sitting tight over those applications and taking no steps, my lord.
When they are holding the election.
My lord, 10th. My lord, process is on. No, candidates' name have been published. I have annexed everything, my lord, for you.
What you prayed in the writ application?
I am praying for setting aside the entire election proceeding and, my lord, stay of all further proceedings, and, my lord, direction upon authorities to dispose of my application in the meantime. Dispose of my applications in the meantime.
When the election is there.
My lord, 10th, my lord.
When the last date of the nomination. When
nomination has been completed. Nomination has been completed. Now finalization of the candidate is going. It's a large apartment, my lord, consisting of 2,000 voters.
When the last day of the verification of the nomination.
My lord, today itself. Today.
What can be done?
No, my lord, election is on 10th, my lord. There can be an order, my lord. Kindly consider.
The election can be stayed.
No, my lord, election can be stayed with a limited interim order, my lord. Pending hearing of this, my lord. Kindly consider. Kindly grants me leave to file, my lord. I am serving today itself upon all the parties, my lord. I am not going to move it unserved. My lord, let it appear on Friday at least, my lord, at a fixed time, my lord. In the meantime, I will complete the service.
Liberty to file. To mention on 4th as urgent motion.
Yes, urgent motion.
May I have my lords kind leave to mention a matter, my lord?
Not 4th, not 5th.
My lord, 4th.
5th.
My lord,
Much
may I have my lords kind leave to mention a matter? This is the writ petition where my lord lordship had directed payments to be made. Mr. Surojit Nath Mitra was appearing. I was appearing for DVC licensee. It was fixed, my lord, today at 1 p.m. My lord, somehow, my lord, it is not listed, my lord, because for compliance to see whether balance 5 lakhs is paid. Now, not only they did not pay the balance 5 lakhs, my lord, the regular, my lord, bills have also been defaulted. Well, this is lordship's last order. I'm mentioning upon notice.
My lord, I'm appearing on behalf of the petitioners in this matter, my lord. My lord, I have instructions from my client that they require some time to make the payment.
Let it be fixed as a supplementary at 1 p.m. I will pass an order for disconnection.
I'm very grateful, my lord.
My lord, may I?
I am giving one time till 1 p.m. If you paid, you paid.
Current
If
user
matter
also
will
not been
raise
paid.
before
My
this, I will pass an order for disconnection or not to restore.
My lord, I have.
About 45
My lord,
days.
I have instructions from my client that they'll make the payment by today.
My
My lord, may I be permitted to mention another matter?
No, today is not the mention. Call the
My lord, it's an urgent matter, my lord.
Sorry.
I'm seeking leave, my lord. Leave, my lord, for circuit bench at Jalpaiguri. Lordship, my lord, just for 2 minutes. My lord, I'm telling you, my lord, leave for circuit bench at Jalpaiguri. My lord, bench is not in session. My lord, what has happened, my lord, is very on the face. My lord, GST authorities have levied a penalty in the 129(1)(b). My lord, with respect to dry areca nuts. My lord, these are, my lord, these perishable goods.
So why here?
Why here, my lord, Jalpaiguri court, my lord, is not in session. My lord, they have given, my lord, because now the determination is with your lordship, my lord. Now what has happened, my lord? They give the penalty notice upon us, my lord, on Friday after court hours.
No, this is a indirect tax. No,
my lord. My lord, over here, my lord, this is not relating to taxation at all. This is relating to the penalty, which on the face of the act says that you cannot charge it in respect of dried areca nuts. 1, 2, even if you levy a penalty, it cannot go beyond 3.8 lakhs. They are charging a penalty of 79 lakhs. And they have retained my goods. My prayer is for release of these goods, my lord. That is my immediate prayer. Otherwise, this will be perishable goods. My lord, and they are completely against the statute.
What is the good?
Dried areca nuts. My lord, that is the problem. Now, day after tomorrow. My lord, it is already, my lord, they have detained it.
If it is getting dry, it will be out.
No, my lord, it is already dry. It is now, my lord. The problem is that from 21st of November, they have got it. Now, my lord, they have given me time till day after tomorrow to make the payment. That is it. My lord, I'm only seeking leave, my lord, if it could be kept tomorrow, my lord. That is my only respectful prayer, my lord.
Liberty. Fix on 4th.
My lord, under extremely compelling circumstances, my lord, I'm constrained to mention a matter, my lord. My lord, this is an My lord, this is a new writ petition that we filed, and the listing date has been given tomorrow. My lord, the threat is my petitioner, my client has an MSME which has become stressed because of the Bangladesh conflict, my lord. My lord, within time and as per all the instructions, my lord, my client has applied for the restructuring of the loan account. However, the banks, the NBFCs are not honoring that restructuring request. My lord, they are threatening.
You mentioned the tomorrow's date in the presentation.
My lord,
Let you wait if the
My lord,
tomorrow
they
is
are
not-
threatening. My lord, they are threatening
Okay,
to
if
mark.
it is not listed tomorrow, then you mention it.
Well, may I permit to mention
My lord,
restoration?
may I hand it over? My lord, may I hand it over?
You wait, you've given the date tomorrow. See if it's listed, it's okay. If not, come tomorrow.
No,
we'll
no.
see to
My
that.
lord,
May I
great.
permit to mention this matter? Hello, may I permit to mention this? My connection was failing for so many.
Come tomorrow. Now, today is not the mentioning, only urgent. Yes.
My lord, may I mention this matter?
Seniority, maintain seniority. Yes.
Sir, I was mentioning item number 340.
Hmm.
You know, there is some.
Report is very dangerous. Yes.
You know, the urgency is, despite me being the highest bidder,
Ah.
they are minded to cancel the entire process,
Ah.
despite me being successful in everything.
Ah.
And I have also already, the immediate urgency is, this tender is not being finalized, despite me coming out because they want to give their own men. That is the urgency. Any day convenient to the court, if it can be
Which one?
accommodated.
Which one?
C40.
Steve infrastructure.
Yes, Steve. Any day convenient to your lordship, I'll serve notice.
3 तारीख को रख दो 3 तारीख को अर्जेंट मोशन में
Great.
My lord, may I permit to mention one
What?
matter? My lord, this writ petition is pending for long time, and the petitioner belongs from a ST community, and the certificate of the petitioner has been cancelled suddenly. So there is a reasonable apprehension that the job of the petitioner may be cancelled. So my lord, can
So if you have a tribunal, you are recruited under the tribal quota. Tribal quota. If your tribal certificate
lord,
is
all-
cancelled, automatically your service will go.
my lord, already
What relief you prayed for before this court now?
just to
Staying the cancellation of your tribal certificate.
my lord, we have already
Okay.
filed this writ petition.
Huh?
We have already filed that writ
Okay,
petition.
wait. When your petition will come, then you mention. I will take the matter.
My lord, so can I give this slip for
No,
today?
come on, come. If
It's-
the when is the returnable date?
Uh,
See, when is the returnable date? If it is returnable date, it is not listed, then mention the matter. Yes. What for what?
My connection was failing so many years. And,
Oh, that's why tomorrow, today is not the mentioning date. Today only if there is an urgency. Come tomorrow, I will take all the matter.
Lordship, there's an urgency. This matter was already heard at the preliminary stage, and this matter was listed for hearing after the puja vacation. But due to change in the determination, this matter has not been listed for hearing. So kindly, Lordship.
Lordship, may I be permitted to mention? Lordship, I'm praying for inclusion of a matter. Lordship,
Come tomorrow. Inclusion come tomorrow.
Lordship,
Inclusion
please-
come tomorrow. Tuesday and Thursday.
I wouldn't be troubling your lordship otherwise, my lord. Your lordship was pleased to direct the matter to appear on 20th of November, my lord. Now, my lord, because I had mentioned the matter regarding the registration of marriage, there was no register of marriage. My lord, I had mentioned the matter was kept returnable on 20th of November. It has not come up.
Why not come? Why you not listed? 2 तारीख को रखो. कल नहीं, परसों 3 तारीख को रखो. Urgent motion.
Great.
Milord,
Milord,
I have
may-
can mention to Lordship, my lord. On Thursday, I have mentioned a matter of disconnection of electricity. Lordship,
Why you're not coming on a Tuesday or Thursday?
my lord, Thursday, I have mentioned the matter.
Ah.
Lordship was granted me the leave, my lord, to list the matter urgent motion on today.
Ah.
Matter has not listed.
Why it is not listed? What you persons are doing, sir? Yes.
Lord, I have a similar predicament, my lord.
Sorry, yes, call the list.
Very well. I'm so grateful.
Dismissed.
May I please your lordship?
The insurance company already paid the amount. So there is nothing in the writ application, and writ application is disposed of.
But we have paid for the interest, my lord.
Interest you are not paid. Where is the writ application? You have paid for only the consideration.
My lord, they have contended that we
Okay.
cannot, my lord, ask for that.
You take appropriate discharge. Yes. Next.
Grateful.
I prefer state responsibility is great for the submission of written submission. I am filing my written submission.
Yes. Written notes of argument.
Milord, Devojyoti Basu Milord could not appear as yet. Milord, kindly Milord praying for a Passover. He has prepared.
Notes of argument.
Milord, when he comes, Milord, let the leave be given to submit the written notes on argument, Milord.
Your written notes of argument is ready.
Milord, it's ready. It's with him, Milord. He is on the way.
Other matters also. When you file,
Milord, as and when he comes, Milord, hopefully, Milord, within half an hour's
give it
time.
to my court officer.
Lordship.
Parties have filed their written notes of argument. Let the same be kept with the record. CAV. Yes. Next.
But I am for the petition in this matter, my lord. The last occasion, my lord, a similar order has been passed. I already placed before your lordship.
I appear on behalf of the respondent number 5.
My lord, I pray for same order because it is a case of, my lord, blocking of the e-challan. And my lord has already passed a similar.
Yes. Where is the challan? Where is the blocking?
Order?
Blocking order.
Yes, my lord. My lord, kindly see, page 25 is the e-challan.
Page 25.
Yes, of the writ petition. The e-challan has been issued.
21st of August.
Okay. And thereafter, my lord, I made a representation.
22nd of August.
Page 27 is my representation, madam. But I have seen in the internet, my challan has been blocked. Therefore, I paid representation before the authority that it may be unblocked and I may be allowed to run the vehicles.
When your vehicle has been.
Here I have stated, the undersign has been done so. 21st August 2025.
Since then, what you are doing?
Well, I have filed a writ petition, my lord. It was
This
pending.
petition.
Yes.
When you file this?
I have filed.
September.
Yes.
And what is your condition of your vehicle? They are not yet decided.
No, my lord.
No, Lord, I am
And my lord has
the authority who is
and not only
maintaining
that,
the.
my lord, they have seized my vehicles, which they cannot, my lord.
No, Lord, I am representing a corporation who is operating the portal. Now, the order of suspension was issued by the additional district magistrate because the vehicle was confiscated. Since the sand which was loaded in the vehicle, it does not have the valid permit. I cannot say without permit, but the validity of the challan was for a particular period, and the vehicle, when confiscated, it was beyond that time limit. That's why the portal has designed in such a manner, unless the penalty imposed by the ADM is paid within.
That's why you have to issue. Where is the notice?
So
You
the
seize the
notice has
vehicle.
been issued by the additional district magistrate.
Where is that?
Lordship,
You
the
seize the
state.
vehicle August.
I have not seized. Lordship, kindly appreciate one thing. Lordship, I am representing a corporation, which corporation is dealing with regard to issuance of the challan through a e-portal. I am maintaining the portal. The order of imprison or confiscation has been passed by the additional district magistrate. The state responded. Now, unless that amount of fine is paid, and the ADM reported us that yes, fees have been paid, thereafter the portal will be operated and I would be able to download the challan. Now, Lordship, on the identical issue, the coordinate bench has passed an order. I believe your Lordship has passed an identical in such identical matter in passed by your Lordship, whereby the Honorable Court has directed the additional district magistrate to
I am not on that.
Yes.
I want to see if you have done something which is permitted under law.
No, Lordship, the state respondent would be able to
Why you
whether.
taking the shoulder of the ADM?
No, I am not. I am saying
Why
that.
why you are dictating the court?
I am not dictating, Lordship. From the case record, it appears.
Sir, you are appearing for the petitioner, you are appearing for the state, or you are appearing for the corporation?
I am from the corporation.
That's all.
Yes.
Why you are telling that yes, similar order may pass, the ADM
No,
has to
I
be done
said-
this?
Lordship, kindly excuse me.
Either you are appearing for the one respondent, you submit on your behalf, not to take burden of all.
I said that I am only operating the portal.
For the 5 minutes, I am telling who is IADM, how it has been challenged. No, I am not. Then you are starting arguing the matter. Who is for the state?
Well, Mr. Sen, I also serve copy, I serve notice, and I also file affidavit of service, madam.
Which
Everybody has been served.
Which area?
It is district Birbhum and Purva Bardhaman, they have issued this challan. Where are Purva Bardhaman is doing like this, madam?
The grievance of the petitioner in the present writ application that the concerned authority issued challan in favor of the petitioner on 21st of August 2025 at 6:04 p.m. and said challan is valid till 22nd of August. Road e-challan, issued road e-challan for transportation of sand of the riverbed materials on 21st of August 2025. Being e-challan number 1066/25-26/25-20202429/PS with respect of vehicle number WB19S5944 within bracket 18 wheels for the quantity of 850 cubic feet. Fully. The petitioner submit that the authorities have apprehended the vehicle and the challan has been blocked. No reason has been assigned why the vehicle of the petitioner has been retained. Until date, no decision has been taken. On 24th of August 2025, the petitioner has made a detailed representation to the additional district magistrate and district land and land reforms officer, Purva Bardhaman, but till date, the representation has not been disclosed. Submitted due to the it has been seized or kept.
Till now, they are in their custody, madam. They cannot, madam.
Vehicle is still in custody of the authorities since 22nd of 24. When it was seized, 22nd.
Yes, madam.
Since 22nd of August 2025. Full. Learned Counsel appearing for the. You are appearing for.
Respond number 5.
Respond number 5 submits that. The duty of the respondent number 5 only to issue the challan. With regard to the flying of the vehicle, whether the vehicle is being carried the proper load in terms of the challan is to be verified by the state authorities. He further submitted the respondent number 5 has not been connected for seizure of the vehicle, for retention of the vehicle of the petitioner and blocking of the e-challan. You are not connected with this.
No, Lordship, as soon as the ADM will lift that order, the portal will be operated.
He submitted. The respondent number 5 is only operating the portal, and as soon as the concerned authority will take decision, comma, the respondent number 5 will open the portal and will allow the vehicle of the petitioner to move. That is the thing. At the land counsel for the parties, counsel for the petitioner relied upon the judgment in the case of unreported judgment in the case of Tahir Ahmed Khan alias Johir Khan and another versus State of West Bengal, passed in WPA 8917 of 2025, dated 12th of September 2025. Submit that similar matter came before this court, and this court has passed the appropriate order, and he praised for the similar order. Party Learned Counsel for the respective parties. This court find that the concerned authorities have issued the challan, a road e-challan for sand of the riverbed materials on 21st of August 2025. At 6:04 p.m. and the validity of the said challan till 22nd of August 2025 at 6:04 a.m. But in the meantime, the authorities have retained the vehicle and blocked the challan of the petitioner, and not allowing the petitioner to take the vehicle. Police. The authorities have neither intimated to the petitioner with regard to the reason why the vehicle of the petitioner has been retained,
Number 5.
and no opportunity of hearing has been given to the petitioner. The petitioner also made a representation to the additional district magistrate, but the same has also not been. In view of the above,
My lord,
in view of the above,
I'm appealing for the state, my lord.
yes,
My lord. I'm led by Mr. HON'BLE Sen, my lord, learned additional general. My lord, my instruction is there is a, my lord, provision for appeal, statutory appeal. That, my lord,
but you have to show why the vehicle has been seized. Show the document that you are informed.
No
He has
information.
violated the order.
my
Where
lord,
is that?
but there is a
You have
For
blocked the
this-
challan on the portal. Where
That
is
is-
where is the communication? You have committed this is the offense. Have you communicated? Show me.
my lord, that is not there. My sole
Then
instruction, my
if
lord.
the
That
petitioner is not having any instruction, any knowledge, why your vehicle has been seized, why vehicle has been kept under you, why they are not considering the representation, why if you taken the consideration, you pass an order, this court can appreciate it, then you go to the appeal. Where is that? Nothing is in the writ application here. Only challan, vehicle seized, you have kept the vehicle in your custody. Where is the communication? Show me.
no, not seizure. This is not the case of seizure, my lord. That
Not
is
seizure. Why
But
the
he-
block? After the block, how the vehicle can fly?
Yes.
If your challan, you have blocked the challan, how the vehicle will fly?
vehicle naকি seize করে নিয়েছে ব্যাপারে।
Our livelihood also.
that is only that the challan has been e-locked,
No,
but
no.
seizure.
Correct. So challan has been blocked. Challan has been blocked. If the challan is blocked, this vehicle is only for the for running the transportation of the river sand or river bed, whatever it may be.
Since my lord, I am basically led by Mr. Learned additional advocate.
Okay, I am
general,
disposing of. Police stuff. क्या बोला? हाँ.
he ordered.
এটা কি সিজ করা হয়েছে সেই ইনস্ট্রাকশন আমি চাই না
No.
এটা সিজ করা হয়েছে
The petition is disposed of.
ভেহিকল কি করে সিজ
The
করা হয়েছে
petition is disposed of
গাড়িগুলোকে দাঁড় করিয়ে রেখেছে।
by directing the who is the authority? ADM.
Yes.
But my lord, so far my instruction is concerned, the seizure part, my lord.
I am not on seizure. You either you continue with the block after giving an opportunity,
Yes.
or you unblock the challan. That's all.
My opportunity, if they can
Correct.
satisfy, we shall.
Correct. I am not passing
My
with regard to the release of vehicle and all these things.
My
Only
lord,
with regard to the e-challan.
That is
You
my
give the an opportunity, he will appear within 2 weeks of within two working weeks.
My lord, that is. ঠিক আছে।
Respondent number 3, my lord.
directing the respondent number
3, my lord, 3.
3 to dispose of the representation submitted by the petitioner within a period of 2 working days from the date of communication of this order, after giving an opportunity of hearing to the petitioner and by passing a reason and speaking order in accordance with law. In accordance with rules. It is clarified that if the additional district magistrate and the district land and land reform officer Purva Madhman is not satisfied with the petitioner's submission of the contentions, instead authority shall be free to continue the blocking of the petitioner's facilities in respect of the previous submission or to impose fine upon the petitioner as may be permissible under is not correct. Full permission full stop. phone number জানি না within 2 weeks বললো ওই two working with the police WPA
যদি মনে করে যে justified reason নেই তাহলে it will continue. One similar matter is left out, my lord. It is not happening in the list, my lord.
Huh?
One similar matter is left out.
mention tomorrow will treat that.
Yes.
Yes, call them. Machu.
আমি অ্যাডভোকেট অন রেকর্ড বিচিতা
7, my lord, I am not pressing this application. This is my written instruction.
Not pressing.
Not pressing.
Record an order. Counsel for the petitioner submitted. He has received written instruction. From the petitioner not to proceed with the matter. Accordingly, on the basis of the written instruction dated, what is the date? Dated 29/11/2025. The petitioner prays for dismissal of the writ application. Prays for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner. Peruse the written instruction. WPA 22307 of 2025 is dismissed as withdrawn. Interim order, if any, stand vacated. Written communication be kept with the record.
I'm deeply obliged.
Next.
Eight.
My application coming up for extension of interim order of 11th of November. My lord, MSME Facilitation Council mediation that.
Yes, you are appearing.
We were directed to serve again because if your lordship sees the first order, we had served, then somebody had appeared in person and he wanted service again, so we had served him. This is that affidavit of service. We've served it to everybody again.
Nobody is appearing.
No, that day on 11th somebody had appeared in person.
Hmm.
And then now again today nobody is appearing.
Counsel for the petitioner file affidavit of service. Let the same be kept with the record. None appears on behalf of either of the parties in spite of service of notice. Counsel for the petitioner prays for extension of the interim order. Interim order is extended till 17th of December 2025 or until further notice, whichever one. Let the matter appear in the list under the heading urgent motion on 17th. If they will not come, I will dispose of them.
Very grateful.
Next.
Lordship, my application for restoration, Lordship, dismissed on and at page 10, the order is
Bench to chamber and bench. Yes.
at page 10, the order is there, being dismissed for default, and the justification is at paragraph 4, page 7.
Paragraph 4.
On the same date, it happened.
Who is for the other side? Nobody is there.
No, Your Lordship.
What is the writ petition for?
It is, Your Lordship, for basically, there has been the provisions of section 2065 of the Companies Act and 210 of section of the Companies Act 2013. It's the action which has been taken, Your Lordship, because once it has attained the finality, again reinvestigation has been challenged, which cannot be done under the law.
The petition has filed the present writ application praying for recalling of the order dated 4th August 2025, wherein this court has dismissed the writ application for default. Full stop. Counsel for the petition submitted on the date fixed when the matter was listed, the father of the advocate appearing in the matter was admitted in the hospital due to the said circumstances. The learned advocate could not appear before this court. Had the learned counsel for the petitioner perused the application, this court find that sufficient cause has been shown for non-appearance of the learned advocate for the petitioner on the date fixed. Accordingly, order dated 4th August 2025 is 4th August 2025 is recalled. Full stop. Can number disposed of. Writ petition WPA 25322 of 2023 is restored in its original file. The petition is direct. Let the writ petition be. The affidavits filed? No.
No, Your Lordship. It is yet to be moved, Your Lordship.
Let the writ petition be placed under the heading new motion on 10th of December 2025. The petition is directed to inform the next date of hearing to the respondents and to file the affidavit of service on the date fixed. Next.
DPM.
My lord, at number 10, I am the writ petitioner and petition of this instant application. My lord, this is the affidavit of service.
May I have your lordship and indulgence with regard to this matter, your lordship? In this matter, the original allotment was given to me. I appear for the state. But your lordship, as per the procedure, whenever a can is filed after dismissal, I am not supposed to take the brief. It has to serve to the GP office. But my learned friend has served upon me, your lordship. So I have came before your lordship. But your lordship, I cannot appear in this matter unless I have the GP's instructions.
My lord, may I submit one thing? The writ petition has been filed. In the motion stage, it matter was dismissed for default. Just a minute. Motion stage, my lord, matter dismissed for default. I have served the copies to the all parties in respect of the writ petition, the evidence service. I do not know who is the advocate record on behalf of the state. Anyway, this is the restoration application. The matter is very small, my lord. My lord, kindly hear me for a moment. Section 5.
What you have prayed for?
For restoration, my lord, matter was.
No, what is your original writ application?
Original writ application, my lord. I made an application to the government.
RCDS?
To RCDS to for gifting my land, because in the locality there is no permanent office. According, then my lord, kindly see annexure P2.
Now, what you have prayed for in the writ application?
My lord, I have gifted a property for the purpose of a project of the government for constructing. But they have, as per the instruction, I have gifted the property. They have received and accepted the property, but they are.
You have gifted the property to whom?
To the government.
Ah.
But they are doing construction elsewhere. After receiving my property on gift by way of deed of gift. My respectful submission before lordships to kindly to construct in my land which I have been gifted for the purpose.
What the authority says?
authorities, he's not started, but trying to construct the project elsewhere, not in my land, which I have been given to the government for project. Yes, my lord. So this is my respectful submissions.
Yes.
In this matter, I have came before your lordship just to make this clear that I cannot appear in this matter because they have probably not served in the.
To whom you have served?
I have served. I have served the evidence service. My lord, kindly see for a moment.
Government feeder.
Yes.
So the government feeder.
Yes.
Because my name was there in the writ, so I came before your lordship.
I have served to the GP, my lord, office of the GP, government pleader. I have served. And to the other concerned, my lord, through speed post, according to postal tax report, they have received the copy. To the London government pleader, I have also served. Acknowledgement is there, my lord, in my evidence service.
The petitioner has filed the present application. Present application being can 1 of 2025, praying for recalling of the order dated 13th June 2025, wherein this court has dismissed the writ application for default for non-appearance of the petitioner at the time of call, when the matter was called.
আমরা তো ফোন করি
Counsel for the
আমরা করিনি কেউ আমাদের কারোর নাম্বার নাই
the
আমি জানি
petitioner
না আপনার নাম
overlooked the list
ভেরি স্যার আমরা
of
তো
this
করিনি
court dated 13 June
This is my
2025,
number.
and as such, the learned advocate appearing for petitioner could not appear before this court, and accordingly, the petition was dismissed for non-appearance. Had the counsel for the petitioner perused the application, this court find that the petitioner has shown the sufficient cause for non-appearance of the petitioner when the matter is called. Accordingly, order dated 13th June 2025 is recalled. Cans 1 of 2025 is disposed of. The WPA 8371 of 2024 is restored in its original file. To list the WPA on 15th of December 2025 under the heading new motion. Affidavit be kept.
My lord, may I serve a press copy to my learned friend?
The petition is directed to inform the next date of hearing of the writ petition
Number.
to the corresponding authorities and to file the affidavit of service on the next date fixed. Next.
I'm grateful, man. Evidence service be kept on record. Both of the evidence service.
Yes, next.
Lordship,
I
item
appear
number
for the respondent market committee.
Lordship, item number 11 is the application, my application for restoration, Lordship. Order
But
is
no
at
copy was served, my lord. Copy? Did you serve?
copy. Yes, yes. Affidavit of service is there, Lordship. We have already served them.
In the office or? আমাদের কি দিয়েছিল কেন না?
Lordship, order is at page number Lordship P1. Lordship, reason is mentioned at paragraph 6.
If you are appeared in, if you are engaged in the other court, that's a good ground for recalling of the order.
Lordship, matter came up for the very first time. Lordship, not admitted.
Maybe. This is a good ground. You are engaged in the other court. That's why the matter.
Lordship, that is not the sole reason, Lordship. Also,
That is the sole reason you saw.
List also collapsed on that day. It was listed on item number 410.5 of the monthly list. Lordship.
Correct.
And on that day, Lordship, monthly list was taken from item number 377 onwards.
And after 6 months, my lord, they are renewing their prayer for recall.
When these were dismissed, June 2025.
Lordship, we have
When you filed an application.
immediately filed within 6 days.
The petition has filed the present application being can number 1 of 2025, praying for recalling of the order dated 25th of June 2025, wherein this court dismissed the writ application for default for non-appearance of the petitioner. Counsel for the petitioner submit that the matter was listed in the command monthly list at serial number 48425, and the advocate was of the view the matter will not be taken up for hearing, and he was appearing in the other, he was engaged in the other court. But all of a sudden the matter was called and the petitioner could not able to appear before this court. Accordingly, the writ petition was dismissed. Learned counsel for the respondents raised objection and submitted that no sufficient ground has been shown for non-appearance of the petitioner and pressed for rejection of the application. Had the land counsel for the respective parties, this court find that sufficient cause has been shown for non-appearance of the petitioner and the matter is called. Accordingly, order dated 25th of June 2025 is recalled. Can number so is disposed of. WPA 14985/2024 is restored. It's in original file. Leave the matter on 16th of December 2025 under the heading new motion.
My lord, not 16th December, my lord, because I have an OT in the brain, my lord. Because kindly make it in the month of January.
Is the matter on 6th of January 2026 under the heading new motion. The petition directed to inform the next date of hearing to the respondents and to file affidavit of service on the next date.
And this order may be communicated to other respondents because I am representing all the three.
Next.
Gratefully, your lordship.
My lord, I was addressing your lordship on this point, section 95, maintainability, my lord, and I just said, my lord, I'll cite, my lord, just what I have done also. I have prepared a short preliminary of the things which I'll be submitting in this form. Now, my lord, your lordship may recall a writ petition has been filed and they are saying basically a stay of the section 95 proceedings. And I mentioned, my lord, the resolution, appointment of a resolution professional is completely different in part 2 and part 3. And we are concerned only with part 3. My lord, which talks about against personal guarantors. And there's a different mechanism of a resolution professional, my lord, under section 7, my lord, which is pending, where, my lord, adjudication, only after adjudication, there is appointment of, my lord, appointment of resolution professional. My lord, I will cover it, my lord, I covered it in my note, but which I'll submit a little later. They haven't got printout, my lord. I cited one judgment of Farooq Ali Khan, my lord, Bank of Baroda versus Farooq Ali Khan, which basically is the latest, one of the latest on the point. And my lord, I submitted, my lord, Farooq Ali Khan makes this clear distinction between part 2 and part 3. And my lord, the resolution professional appointed, nothing happens. My lord, he is sort of a registrar or who presents the facts before the adjudicating authority, and the adjudicator authority looks at the reports and sees, has he recommended against or has he recommended in favor? And if he says against, no, we think it should be favor. Even then it can be overturned. And if he says no, then if he says yes, then also he looks at it. Adjudicating and then takes a decision. It is only then, my lord, that the whole process under 100, section 100, this is what happens. My lord, all this, and I told your lordship, one thing I didn't say is that, my lord, section, I've clarified in my note, which I'll give to him just now, my lord, section 7, my lord, which has been filed, my lord, was filed by the principal borrower, the borrower, respondent number 1, that's my client. The 95 proceedings under the agreement has to be filed by the trustees to the agreement. The trustee agreement is, that is Mr. Thakkar's client, respondent number 2. Yes. And this has been so filed in the name of the respondent number 2. right, my lord? But the proceedings, my lord, it's a peculiar thing. So, my lord, I will cite also one judgment. The two are totally independent. One can proceed. Section 95 can proceed without a section 7. My lord, that is eminent from section I. For that, I will give you another judgment. My lord, just permit me now to just clarify the last day's point. I pointed, I won't repeat the judgment. I will only give you the constitutional, I told your lordship, constitutional bench judgment. And may I present our note? I will, yes, give him a copy, please. My lord, the কোথায় নোটটা দাও, নোটটা বার করো। Just give me a minute. Yes, my lord, it's a longish judgment, but based on this judgment, Farooq Ali's judgment was passed. And therefore, my lord, because it is the validity of section 95 was challenged. My lord, proceedings. My lord, please come to para. My lord, I'll just quickly, I mark the paragraphs. It's the longest judgment. Paragraph 2. My lord, in this bench, 384 petitions under article, my lord, para 2. My lord, it starts, my lord, Dr. Chandrachu's judgment, my lord, in that pattern form, my lord, para 2. In a batch of 384 petitions under article, the petitioners challenge constitutional validity of sections 95 to 100. My lord, kindly come to para 3. My lord, the aims of are mentioned, efficient measures, etc. Para 4, my lord, this is important. Part 3, we are concerned with part 3. IBC deals with bankruptcy individuals. Part 3, chapter 3 of part 3 is titled insolvency. I placed all this, my lord. I will not place it again. Para 6. My lord, by amending, my lord, this is important. Parliament introduced amendments to section 60, which says basically amendments comprehend the guarantor person as of a corporate debtor. My lord, that is under section 60. Now, my lord, 10. Please come, my lord, I've indicated the paragraphs for your lordship, my lord. Then chapter 3 says under chapter 3, debtor, creditor 94(1) enables, this is for debtor, we are not concerned. 11, we are concerned. This is what has happened. 95 enables creditor to apply for initiation of proceedings either by himself or jointly with other creditors. That's what I wanted your lordship to see. And it says, my lord, may apply under 1 relation to partner owed to him for initiating against one of partners. 95(4) stipulates requirements to initiate. And my lord, kindly come straight away to para 13. Para 13, my lord, in 98, provisions for replacement of resolution professional, 99 submissions of report before the added. This is what I am on. I pointed out each and every section to your lordship. My lord, kindly come to, my lord, 14. The scheme, my lord, this is important. The scheme of 99 is that resolution is required to examine application preferred and appoint, file a report. In other words, resolution professional under 99 has threefold functions. First, the duty to examine. Well, this has also not happened. Now, submission of report, incorporation of recommendations in the report. That's all, my lord. Then, my lord, kindly come to para 15, where application has been filed, resolution, say, may require repayment of etc., etc. Then 16, in terms of subsection, debtor is not entitled validity, etc., etc. The right at the bottom, application satisfies the requirements, etc. Then, my lord, 17,
my lord, this is important. After carrying out this process, resolution professional may recommend the acceptance or rejection of application is a reasoned report. And this is what can be challenged, my lord. A copy of report is to be provided to debtor or creditor. So you have a chance. Then, my lord, para 19. The interim moratorium, there's a moratorium also declared. Under section commences where the date you file this application, and then consequently contains a statutory that whether you will extend the moratorium, my lord, or not after adjudication. Then, my lord, 20 says the moratorium remains in force. My lord, straight away come to para 50. My lord, para 50.
Yes.
My lord, chapter 3 of part 2, that is under the section 7. Part 2 is section 7. Deals with distinct eventuality, namely initiation of liquidation broadly in situations where resolution has not been received or resolution is rejected for non-compliance of requirements. These provisions elicit the vital role which is entrusted to for initiating. The role has to be, this is important, distinguished from the role which is ascribed to resolution in part 3, which is appointed for the purpose of resolving insolvent individuals. Section 94, as we have noticed, provide for application by debtor, etc. Then in part 2, we have noticed earlier, adjudication authority is contemplated to have an adjudicatory role. In contrast, in chapter 3 of part 3, appointment is contemplated in 97. Under adjudicating has to appoint resolution who is either nominated by the board. My lord, there are two distinct functions in part 2 and part 3. That is what I was endeavoring, my lord. Side 51, the duties of resolution professional in chapter 3 of part 3 are contained in section. The resi is required firstly to examine the application within 10 days, etc., etc. 52, we will deal with impact of 99(3). Subsequently, evidently, the provisions of subsection operate alone and cannot be construed to be a bar qua adjudication under section 100. So adjudication begins under section 100. My lord, I'm sorry, my lord, for repeating, but it's all there, my lord. Para 53. The resolution profession is examined to carry the application to ascertain two things. Firstly, such and such, my lord, this is just what I've been saying. I don't want to repeat. And straight away, my lord, come to para 79 to 83, the concluding portions. My lord, challenge to constitutional validity. My lord, it has been said, it's draconian. My lord, that is why I am pointing out. It is draconian, my lord, I am lost. That resolution, if is right, my creditworthiness, everything will be destroyed. But that's the scheme, my lord, of the act. Nothing happens. My lord, in view of the above analysis, it has now become necessary to analyze whether there is substance in challenge to the constitutional validity of such and such, my lord. I don't want to repeat, just take a note. Para 80, 81. My lord, legislature has evidently made provision in section, as we have construed earlier, to allow engagement of debtor with the resolution before a report is submitted to the adjudicating authority. The process under section must be with natural justice. My lord, that's when it comes, the natural justice element. My lord, adjudicator is duty bound to hear against whom application is being filed. So, my lord, before he submits a report, resolution must hear him. Now, my lord, And para 81, the resolution professional in exercise of their duty under may not embark. These are the roving inquiry, etc., etc. These are the restraints. He cannot. He merely submits a report. My lord, in 82 and 83, for the reasons we have adjudicated, we have come to the conclusion adjudicating authority process of the nature which has been suggested would not be implicated under 19. So no adjudication. We accept the submission, etc., etc. My lord, that is what I wanted. I will give you, my lord, one more judgment. My lord, this is of Justice Ashok Bhushan as chairman of the NCLAT. For the proposition, my lord, the two are totally independent, even without the CIRP process being initiated under Section 7, you can independently file a Section 95 application. My lord, that follows, my lord, from Section 60. My lord, will you just have a look, my lord, at Section 60 once, my lord? My lord, it says, Section 61, the adjudicating authority in relation to insolvency liquidation for corporate persons shall be the National Company Law Tribunal having territorial jurisdiction. So for corporate, it must be the NCLT. Then, my lord, 962, my lord, it's misconstrued by many people, but kindly see 62. Without prejudice to the subsection 1 and notwithstanding anything contrary, where a corporate insolvency process or liquidation is pending, my lord, please note the words, before a company law tribunal. So, if a proceeding under Section 7 is pending in a company law tribunal, an application relating to insolvency resolution of a personal guarantor shall be filed before such national company law tribunal. Therefore, the section merely says that if you have filed a Section 7, then the subsequent application must be filed before that. Don't go to Coimbatore, National Tribunal, or any, for that matter, any. That's the meaning of the section. If your lordship wants a judgment for this proposition, my lord, is, I'm sorry, it's an NCLAT judgment. My lord, Justice Bhushan, my lord, is there.
Yes.
My lord, has your lordship found? My lord, a judgment was cited on behalf of my by my learned friend. My lord, may I deal with that judgment? My lord, let me tell you that judgment has no manner of application, because if you see from paragraph 3 and, my lord, paragraph, my lord, which, yes, my lord, paragraph, I've noted the paragraph. No, my lord, I'm not reading this judgment. Shall I read this judgment?
Not, I will go through.
My lord, your lordship may find, yes, para 8, 9.
8, 9, 10.
Yes, yes, my lord, it's there. 6, 8, 9, 10, my lord, it's there, my lord. Just what I was saying, my lord, that's the meaning. Now, my lord, they cited one judgment. My lord, Swiss ribbons. For the proposition, I believe, my lord, this is no manner of application with regard to Section 95 proceedings. My lord, that your lordship will find what the challenge really was. My lord, you see paragraph, my lord,
upon 105.
para 3. You see what was there? Sri Rohatgi assailed the legislature as contained in Section 7. We are not concerned with Section 7, which is part 2. We are concerned with, my lord, whether a resolution professional who is appointed, what role does he have? So they were dealing with Milord section 7, and Milord, they were also dealing with section 29 capital A, Milord, which basically, Milord, your Lordship will find that, Milord, Koto 101. Milord, I believe they relied on para 101.
No, they relied
Yes,
105.
Yes, my lord, it was a challenge to section 29 capital A. My lord, 29 capital A, if you see, just give me the act once. It is the act of the, I believe, resolution profession, 29 capital.
Who are ineligible to submit a resolution.
Yes. My lord, 29A, old one. Yeah, they gave a book. Amatta Purono. Because the amendment came in 2018.
Judgment set out.
কোন judgment?
Set out in
কোথায় আছে? কোন প্যারাগ্রাফে আছে? Anyway, my lord.
That is there, but kindly come to page 99 of the judgment. Paragraph 103 definition is
Yes,
given.
yes, my lord. I just wanted to, yes.
Persons not eligible.
Persons not eligible to be, it is falling under part 2. Those resolution professionals, completely different from resolution professional under part 3. My lord, you will find part 3 begins, I told your lordship, before section 78. My lord, if you take the book, my lord, you come to section 78. I showed you on the previous occasion, my lord. Just before section 78, it is part 3.
Yes.
Yes. And part 2, which contains is, my lord, just above section 4.
Correct.
So that's what that's it. So this is talking about resolution professional appointed under part 2 after adjudication. After adjudication, we are talking about resolution as a matter of course. Who has to submit? So this I wanted to tell you, and I have prepared, my lord, exactly what, my lord. I am not going into the merits of the matter. My lord, with regard to whether recall notice is bad, my lord, the division bench has held, it is you agitate before the, so I given you those orders. My lord, for your, if your lordship permits, for your lordship's convenience, exactly what I argued, I have, whether there are spelling mistakes I have not corrected. My lord, if there are any, I just, my lord.
Yes.
My lord, so my lord, the 95 proceedings have been initiated by Mr. Thakkar's client, the trustees, pursuant to the agreement, which is at page blank, which I've indicated, that empowers them to institute. The borrower, against the borrower, respondent number 3, I have initiated.
Correct.
That is section 7.
That's all?
Yes, madam. I completed within 10 minutes, madam.
Thank you.
My lord,
Mr. Thakkar, you are appearing for?
for the respondent number 2, my lord. Your lordship kindly takes the cause title once, please, my lord. I don't think an attempt has been made to trouble your lordship with the niceties of the insolvency and bankruptcy code. I don't think anything of that could have been called into question here.
You are for the respondent number 2.
2, please, my lord. Piramal Trusteeship Services Private Limited.
Yes.
My lord, kindly takes the cause title. The respondents numbers 1 and 2 Piramal Finance Limited, Piramal Trusteeship Services Private Limited. These are private entities. These are not state. I don't know, my lord, why this whole IBC angle has been brought in just to create a kind of a jurisdiction when none exists. So, my lord, 1 and 2 are, my lord, private respondents. 3, who is their group company, my lord, company promoted by these petitioners is 3, who is also, my lord, a private entity. Now, the only way the writ jurisdiction of this court is attracted or is sought to be attracted, my lord, is by impleading Reserve Bank of India. That is the only way. Now, kindly see the relief sought at page 41.
Yes.
Issue a writ of and or in the nature of mandamus do issue commanding the respondent numbers 4 and each of them to pass necessary appropriate directions to R1 and R2 for dealing with the personal guarantees of the petitioner in accordance with the RBI Master Circular and fair lending practices issued by R4 from time to time. That is the only relief, my lord, which has been sought against R4 and which does not attract writ jurisdiction. I'll show your lordship presently. Now, kindly see, my lord, what is the ulterior purpose of this writ? Issue a writ of and or in the nature of mandamus to the learned NCLT, commanding it to dismiss the personal insolvency petitions filed by respondent number 2. This is a 226. This is not a 227. Kindly see prayer 2, dismiss NCLT petition. Then kindly see 3.
No, writ in the nature of mandamus to London NCLT
Commanding it to dismiss the. This is the whole purpose of this writ petition.
Yes.
Then kindly see 3 is, my lord, certify records. I'm not troubling lordship with C. Kindly see D. Issue a writ of and or in the nature of prohibition to the Honorable NCLT, commanding it to abstain from entertaining and or proceeding with the personal insolvency petition filed by the R2. Then pass an order quashing and setting aside the personal insolvency petitions filed by R2 against the petitioners before the Honorable NCLT. Then G is what he is being arguing for all this while. Interim order we pass directing stay of further proceedings in the personal insolvency petitions filed by R2 before Honorable NCLT. This is the whole purpose. And to somehow create jurisdiction, respondent number 4 has been impleaded.
Yes.
And the only argument which is advanced apropos respondent number 4 is that the account could not have been declared NPA because these are the norms.
Period, yes.
Now, my lord, a writ filed against Prayer A, ostensibly commanding respondent number 4. Not one representation made to respondent number 4 before filing the writ. This is an abuse of process. And who has come forward, my lord? The promoters of the company who filed the suit. Sheer abuse of process. And that too of writ jurisdiction.
Yes.
Not one representation. Now, my lord, kindly see what the Supreme Court has to say. Why writ court should not interfere by filing these writs. Kindly see how the writ jurisdiction is abused. The Supreme Court deprecates. Kindly see 2025 SCC Online 177. This is, my lord, I am, my lord, a non-banking finance company or a scheduled bank. I am not a public sector bank. I am not a nationalized bank. Kindly bear that in mind. Now, in this context, kindly see, my lord.
Yes.
Kindly see paragraph 2. High Court in its impugned judgment has observed in para 5 as under. While the court examined the appeals and considered the controversy raised in the petitions, a conspicuous aspect surfaced that the petitions were filed against the company named Muthoot Finance Limited. Admittedly, the respondent company is a company registered under the Companies Act 1956. It does not answer the definition of state within the meaning of Article 12 of the Constitution, nor the transaction of loan by pledging gold between the petitioner and respondent could be said to be involving any public function or could to be said in the public realm. Also, the company is not discharging any function which has the trapping of sovereign function. Respondent company is a private company registered under the law. It is not a state. Once the above position is clear, the writ petitions would not lie against the respondent company. Learned single judge could not have therefore entertained the writ petition on that ground alone. Now, this was, my lord, kindly come to paragraph 3.
Yes.
they are not amenable to writ jurisdiction. Then counsel argued, the learned counsel appearing for the petitioner, that is before the court, would submit that although the finance company may not be strictly falling, and this is the argument today, my lord, may not be strictly falling within the ambit of state, yet being a non-banking financial institution, it is governed by the rules and regulations framed by the RBI. And if the statutory rules and regulations framed by the RBI are breached by a non-banking financial company, then as a statutory authority, such finance companies are amenable to the writ jurisdiction. And kindly see 5, we are afraid the position of law is otherwise. Then I'm not troubling your lordship with all the catena of decisions since 1986 which the Supreme Court refers to in this judgment. Kindly come to, my lord, the law is extensively noticed and this is nothing new. This has been there since ages. Kindly see paragraph 7. Applying the above test, the respondent herein cannot be called a public body. It has no duty towards the public. Its duty is towards its account holders, which may include the borrowers having availed of the loan facility. It has no power to take any action or pass any order affecting the rights of the members of the public. The binding nature of its orders and actions is confined to its account holders and borrowers and to its employees. Its functions are also not akin to government functions. A body, public or private, should not be categorized as amenable or not amenable to writ jurisdiction. The most important and vital consideration should be the function test as regards the maintainability of a writ application. If a public duty or public function is involved, any body, public or private, concerned or connection with that duty or function and limited to that would be subject to judicial scrutiny under the extraordinary writ jurisdiction of Article 226 of the Constitution of India. And we may sum up. For issuing writ against a legal entity, it would have to be an instrumentality or agency of state or should have been instructed with such functions as are governmental or closely associated with public importance, fundamental to the life of the people and hence government. Writ petition under 226 may be maintainable against all these. Although, then kindly see 3. Although a non-banking finance company like Muthoot Finance, with which we are concerned, is duty bound to follow and abide by the guidelines provided by the Reserve Bank of India for its smooth conduct of affairs and carrying on its business, yet those are of a regulatory measure to keep a check and provide guideline and not a participatory dominance or control over the affairs of the company. A private company carrying on banking business as a scheduled bank cannot be termed as a company carrying on any public function or public duty. Normally, mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. In exceptional cases, a writ of mandamus or writ in the nature of mandamus may issue to a private body, but only where a public duty is cast upon such private body by a statute or statutory rule only to compel such body to perform. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a particular thing, it does not possess the attribute of a statutory body. And then, my lord, the appeal was dismissed.
Correct.
So, my lord, this writ does not lie. Merely by including the Reserve Bank of India, the writ does not lie. Kindly see, my lord, now a decision of a coordinate bench of our court. Can you see paragraph 5? Here also the Reserve Bank of India was impleaded.
Yes.
A cursory perusal of the reliefs claimed in the writ petition indicates that no fundamental or legal right of the petitioner has been alleged to have been violated. As such, sufficient to invoke the jurisdiction of judicial review under Article 226 of the Constitution of India. In the preliminary reliefs, the petitioner has claimed that the respondent number 5 be recommended to strictly comply with the circular issued by the Reserve Bank of India dated so-and-so and so-and-so. The petitioner has also sought a writ of mandamus against R5 to grant the petitioner a one-time debt realignment against the loan accounts in terms of the directions issued by the Reserve Bank of India. Such being the preliminary reliefs, which undoubtedly fall within the discretion of R5, do not call for invocation of writ jurisdiction. In any event, as rightly pointed out by learned counsel for the respondent number 5, the said respondent being a private authority, the writ petition is also not maintainable on such relief. In the RBI, as it appears, has been impleaded without any relief being sought against. In fact, in the event the RBI is not impleaded, there would be no justification to invoke the jurisdiction of the writ court at all. And then, my lord, the writ was dismissed.
Yes.
Now, my lord, kindly see what is later. Kindly see the relief sought, my lord. Your lordship has seen the relief sought to quash proceedings before the NCLT. The entire argument which is advanced before your lordship is that under section 95, the resolution professional is directly appointed. It will cause me irreparable loss, prejudice, injury. In this writ, there is no challenge to the vires of section 95. And this has been settled to be constitutional intra vires by the Supreme Court. So these arguments are of no avail. That 95 is a draconian step. Why have they done this? They have done this because you have defaulted. Now, whether there's a debt or default, that the NCLT will adjudicate. There is a complete code. Your lordship has seen shown that Tanzania. Your lordship has seen the Supreme Court judgment in the case of Muhammad Farooq Ali. Your lordship has seen Farooq Ali. Complete code. Now, my lord, why I say this is abuse of process? Kindly see the lordship was shown these charts, my lord, as to how payments have been made, etc. My lord, this identical pleadings in the plaint. Kindly see the plaint once. Your lordship, remember, I'll just give your lordship the page number, paragraph numbers, identical. What failed there, now this is a second bite at the cherry by the same persons. My lord, and it's very unfair, my lord. Kindly see, my lord, the decision which was, another decision which was cited before your lordship, the Bombay Division Bench of the Nagpur bench. Bombay High Court in Nagpur. Division bench. Archana Vani was shown to your lordship, my lord. 20th June 2023. Archana Vani versus Archana Vani, Deepak Vani, Indian Bank. It appears the senior counsel who appeared before your lordship that day, my lord, had appeared before the division bench also.
Yes.
Now, my lord, this was cited to say that the writ court could direct stay of proceedings in the company petition. Paragraph 3 was perhaps shown to your lordship when the OTS offer, etc. Facts were not placed. No law in this. This is merely an interim order. But, my lord, perhaps in fairness, it should have been told to your lordship that this writ petition was dismissed at the final hearing stage. Perhaps he was not aware because I don't see his name in the final hearing stage. This was, my lord, when an OTS was submitted by the promoter directors. OTS was under consideration, and that is why, my lord, some leeway was given to them at that stage to pay off their debt.
Yes.
And ultimately, the writ petition came to be dismissed. Kindly come to paragraph 30. 29.
Page?
The last page, my lord.
Paragraph 29.
Yes, 29, 30, your lordship will get the facts here. This was a one-time settlement proposal which was given, and to force the bank into accepting that settlement petition, this writ petition was filed.
Yes.
Can you see paragraph 22 onwards, all the NCLT decisions were also cited.
Yes.
22, your lordship sees NCLT decisions cited as to stay of proceedings, etc. Can you see 23? Non-consideration of OTS. 24, all Supreme Court decisions cited, extensively argued. Ultimately, the division bench holds that this writ petition does not have any merit. Paragraph 30. So far as other prayers made in this petition are concerned, suffice it to say that any observations made here may affect the proceedings pending before the tribunal. Similar prayers were there. Thus, we are not passing any specific order as core issue is already answered in this petition. In view of the aforesaid discussion, we are of the opinion that exercising power under Article 226 of the Constitution of India would not be in the interest of justice. Petition is dismissed. At this juncture, a stay was sought. Since the stay was continuing for 2 years, a limited stay was granted. And so stay shall stand automatically vacated.
Yes.
So, my lord, the ad interim order was shown. In this order, my lord, the respondent was not even present. Can you see paragraph 4 of the order which was shown? Service was directed.
Yes.
It's an ex parte ad interim order which was snatched from court. And the writ ultimately came to be dismissed.
Yes, anything?
My lord, just one decision of the Delhi High Court, my lord, where such writs were dismissed with costs. Kindly see, my lord. Kindly see paragraph 2. The petitioner further seeks stay. This was under 226 and 227, my lord, which your lordship will get in paragraph 1. This writ petition has been filed under Articles 226 and 227 of the Constitution of India, invoking the supervisory jurisdiction. Even then, my lord, it was dismissed. Then kindly see paragraph 2, my lord. The petitioner further seeks a stay of the personal insolvency proceedings initiated against him under section 95 of the code, titled so-and-so versus so-and-so, pending before the NCLT, New Delhi. The petitioner contends said proceedings arising from the same date, transactions, and allowing them to continue before the DRT. NCLT would be multiplicity of proceedings. Then, my lord, I'm not troubling your lordship with the facts and the arguments which are there. Kindly see the analysis. Starts at paragraph 15, which is the ratio. Kindly see paragraph 20. 15 to 19 is, my lord, stay on DRT proceedings. 20 onwards, it's stay of proceedings before the NCLT. A similar position of law prevails. Your lordship has that?
Yes, yes.
A similar position of law prevails in respect of proceedings before the NCLT as well. The Honorable Supreme Court has consistently deprecated the practice of high courts interfering with proceedings under the IBC in Mohammed Enterprises, Tanzania versus Farooq Ali Khan. This is another judgment, my lord, which has not been given to your lordship. Your lordship will kindly see this. The jurisdiction and power of the adjudicating authority under section 65C has already been reiterated. It is important to note in the case of CIRP, in a recent order in so-and-so, this court has observed that unjustified interference with the proceedings initiated under the Insolvency and Bankruptcy Code breaches the discipline of law. In kindly see 21. It is therefore well settled and consistently a firm principle of law that the High Court should ordinarily refrain from invoking the extraordinary jurisdiction under Articles 226 and 227, where an effective and efficacious alternative remedy is available to the aggrieved party, and particularly when proceedings are already pending before the concerned tribunal. Judicial interference in such matters is justified only in narrowly defined exceptional circumstances, where the tribunal has acted wholly without jurisdiction, in patent violation of the principles of natural justice, or where the statutory remedy is illusory or inefficacious. Save in such exceptional cases, a writ petition impugning orders or seeking directions in respect of proceedings pending before statutory tribunals, including the DRT or NCLT, particularly in matters governed by the SARFAC, RDB, or IBC, may not be maintainable.
Yes.
Then, my lord, deals with the facts of that case. I'm not troubling your lordship with the facts. Kindly see paragraph 30, 29 and 30. Likewise, the petitioner's prayer for stay of the IBC proceedings pending before the NCLT against him is devoid of merit. No material has been placed on record to show the scope, stage, or nature of the proceedings, whether any corresponding prayer has been made before the NCLT itself. The mere allegation of possible overlapping contrary decisions between NCLT and DRT without substantiating facts or pleadings cannot justify invocation. We are also of the view that NCLT, being a statutory forum under the IBC, is fully empowered to take all necessary measures within its jurisdiction. If the petitioner was aggrieved by any step taken therein, he had an adequate appellate remedy before the National Company Law Appellate Tribunal. The petitioner, however, has failed to demonstrate that he has taken any steps before either of these fora, thereby rendering his present plea wholly untenable.
Yes.
And 32 again deals with the IBC. Then 33, 34, my lord. 34 notices Bank of Baroda, which is Farooq Ali Khan, which has been placed before your lordship, my lord. And ultimately, the writ came to be dismissed with costs. 35. Through the present petition, the petitioner seeks an interdiction by this court of proceedings pending before the NCLT under the IBC, which is a complete code in itself. Granting such relief is impermissible as it would amount to judicial interference with the statutory framework enacted under the IBC. On this ground as well, the petition is liable to be dismissed. I'm sorry, it says rejected, my lord. And then ultimately the conclusion, paragraphs 41 and 42.
Okay.
So, my lord, A, the writ is not maintainable in its present form. The relief sought, my lord, in a 226 jurisdiction, my lord, cannot be granted. B, it is an abuse of process. Allegations are the same as in made in the plaint. 3, in any event, the vires of the code is not under challenge before your lordship, and the vires has been upheld by the Supreme Court, my lord, in Jivrajka. And 4, my lord, for this abuse of process, the writ is liable.
Thank you.
Great.
Yes.
But now, blood. I'm sorry, my lord. I have the task now of my lord rejoining. My learned friend, my lord, who was here, my lord, for the petition, my lord, he couldn't, my lord, make it. So, my lord, since we didn't want to hold up the matter, my lord, my lord, I have very two short submissions, my lord. First, my lord, on the question of, my lord, that there being, my lord, similarity between the plaint and the allegations made here, my lord, I don't think that is denied. Because, my lord, now the invocation is in respect of the guarantors, where, my lord, our case has been that, my lord, we have paid in terms of the contract. And there's no default.
So why you are not placing the same before the tribunals?
95. That's what's been permitted, my lord, so far as the others concerned, my lord. This is not, because according to us, my lord, why we have come, my lord, with great respect, my lord, great, because we are not permitted to, my lord, place this before section 95. If, my lord, looks at, my lord, the division bench, my lord, if my lord looks at the division, that's exactly what's been done. And my learned friend, my lord, said that I was unsuccessful. I'm sorry, I've not been unsuccessful. I came, my lord, with 3 issues. One, my lord, is a challenge to the notices which were given for default. My lord was pleased to hold that, no, sorry, in terms of the contract, there's no default. Secondly, I said, my lord, there's a question of pledge and mortgage, which cannot be decided by any other forum, but by this forum. My lord said, yes, that is correct. So I'm retaining jurisdiction. My lord, initially, my lord, when they preferred an appeal, there was stay with regard to all proceedings. All saying we are going to decide the issue. And then, my lord, the order got modified to the extent saying I can raise this issue before that court, which means, my lord, before NCLT. I'm on that. My lord, I'm on that. My lord, kindly look at, my lord, the order. My lord, will appreciate, my lord, in even, my lord, sorry, my lord, I'm just taking, my lord, 2 minutes on this, my lord. Just kindly, my lord, look at my lord's order. My lord, which is at page. Oh, Downing?
Which order?
My lord's original order, my lord, which my lord passed, my lord, in the suit. Yes. That's 19th August 2025. I'm told. You must have given a copy.
Yes.
Have you? You've given it earlier.
Just check.
Down.
That you disclosed, no?
No, we haven't. No, my lord. In fact, my learned friend, my lord, are bringing it up. We came on the question saying that this is still an issue. And since then also, my lord, I paid all, my lord, the installment, whatever. They are, my lord, sticking to the original and say, no, sorry, now we have to proceed against you. And in this straight away, my lord, will kindly come to paragraph 35, my lord, will find, my lord, where, my lord, the issue is
45.
Sorry, my lord, paragraph 36.
Yes.
Section 7, such contemplates order to trigger an application thereunder. There should be in existence 4 factors. Debt, default. Debt should be due to financial creditor. Such default which had occurred should be by a corporator. On such application being filed with compliance required under section 7, 1 to 3 of insolvency, the duty is cast upon the adjudicating authority to ascertain the existence of a default. If shown from the records or on the basis of other evidence furnished by the financial creditors, contemplate section 7(4) of the IBC. Procedure according to IBC will indicate that before the adjudicating authority satisfies to whether the default has occurred or not, in addition to the material placed by the financial creditor, corporate debtor is entitled to point out the default has not occurred and the debt is not due. Consequently, to satisfy the adjudicating authority that there is no default, in such exercise undertaken by the adjudicating authority, it is found that there is a default. The process as contemplated in subsection 5 of section 7 is to be followed as provided under section 5A, or if there is no default, adjudicating authority shall reject the application as provided under subsection 5B to section 7 of the IBC. In that circumstances, if finding of default is recorded and the adjudicating authority proceeds to admit the application, corporate insolvency resolution process commences as provided under subsection 6 of section 7. In such event, it becomes a proceeding on date of admission, and from that point onwards, civil court has no jurisdiction. Therefore, the trigger point is not filing of the application under section 7 of the IBC, but admission of the same in determining default. Then, next, in view of the above, court finds that the respondent 1 has only filed an application section 7, not admitted till the date of hearing of the application. Thus, this court has a jurisdiction. Then, 39, suit has been filed, for declaration. Then, kindly see 40. On the question, submits that time is never the essence of the contract unless expressly provided by parties to a contract. Then, straight away come to 40.
39. 13 June is under challenge.
Yes, I'm sorry, kindly look at also paragraph 39. Kindly see, 13 June is also under challenge.
On the basis of which
is the invocation of the guarantee against the guarantors.
Yes, that was under challenge.
Yes. And that is also the subject matter. Then kindly straight away come to paragraph 42. It is the contention of the respondents that by way of an interim order, petitioners intend to restrain from initiation of proceedings under section 7 of the IBC, relied upon section 41B of the specifically fact, support of the submission relied upon a judgment in the case of Cotton Corporation. Then 43, prayers A to D, the petitioners have prayed for declaration that the alleged letters issued by the respondents 1 and 2 are illegal, and prayers E and F are for perpetual injunction, and the rest prayers are for damages and other reliefs. Considering the prayers of the petitioners, plain this court finds that because of 2 prayers, total claim made by the plaintiffs in the claim cannot be ignored. And considering the above, court finds that the petitioners have made out a prima facie case and balance of convenience and inconvenience in favor of the petitioners, and at this stage an interim order is not granted, petitioner will suffer irreparable. Then in view of the above, respondents 1 and 2, then men, agents and servants assigned the restraint from giving any effect or further effect to the notices dated 20th May 2025, and similar 20th May 2025, 8 June 2025, 13 June 2025, and 16 June 2025 till 17 September 2025. It is made clear that this court has passed the interim order as the application filed by the respondent 1 under section 7 of the IBC is not admitted till date. Learned tribunal is free to take decision with regard to admission of the application filed by the respondent 1 under section 7 of the IBC. Though the respondent are already appearing in Sansad. Then kindly look at the division bench. My learned friend said, we have lost. I'm so sorry, that's not correct. This is third. Have you given this?
We have 3rd November.
Yes, 3rd November. And kindly similar page
2, last paragraph.
Yes,
Advocate
correct,
appealing for the appellant draws the attention of
yes,
the
draws the attention of the court to the impugned order, submits that by reason of impugned order, appellant was restrained from giving effect to the recall notice as well as the follow-up notice in respect of the credit facilities. He submits the same tantamount to the NCLT, not deciding upon the section 7 application, since the foundational basis of the application under section 7 and IBC is the recall notice and follow-up notices. Learned senior advocate appearing for the plaintiff submits on instruction that the plaintiffs are anxious with regard to pledge and mortgage. That is still my submission. He submits that the issue of the validity of the pledge and mortgage cannot be decided by the NCLT. He submits an instruction that his client does not object to NCLT deciding upon the application of section 7 of the IBC in accordance with law. He contends that the entirety of the claim of the appellant was repaid, although belatedly. He also points out that so far as the belated portion is concerned, the same is governed by terms of the agreement, which allows the appellant to levy interest. Interest component was also paid. Contention of plaintiff that the entire amount stands repaid is disputed on behalf of the appellant, which is my learned friends. we find from the records that an application under section 7 of IBC is pending consideration before the NCLT Kolkata. Such application is prior in point of time. In the suit, the learned single judge proceeded to pass an ad interim order restraining the appellant from giving effect or further effect to the notice of recall and follow-up notices. Apparently, a portion of the notice, recall notice, as also the follow-up notice, deal with the pledge and mortgage that the appellant claims were created in favor of the appellant. It is accepted at the bar that NCLT will not decide on the issue of pledge and mortgages when deciding the issue as to the admissibility of an application under section 7 of the IBC. Then, Malad, kindly see. In such circumstances, it would be appropriate to modify the order impugned by permitting the appellant to press its application under section 7 of the IBC Code for NCLT. NCLT will note out and decide its application in accordance with law. Then all points raised by the parties with regard to the proceeding under section 7 of the IBC kept open to be decided by the NCLT. It is clarified that, kindly see, my lord, it is clarified that the legality, validity, and sufficiency of the recall notice and the follow-up notices may be decided upon by the NCLT if so raised to the extent of recalling. Accordingly, both the appeals. Now, my lord, kindly, my lord, contemplate a situation. While, my lord, section 7, this is going to be decided, and my learned friends say, my lord, on the same basis of the same default and debt, they will proceed, my lord, against the guarantors.
Okay. And we have no remedy.
And, my lord, we have, my lord, no remedy. That is, my lord, what their contention is.
Okay.
Today, my lord, that's why, my lord, the challenge, because, my lord, today, my lord, a challenge. My lord, I'm not saying, my lord, kindly state. I'm only showing, my lord, also the further facts. To show that unless, my lord, that issue is decided in terms of this, there's no question. There's no question about this proceeding.
Okay. 95.
And, my lord, 95, my lord, just one, my lord, just
95.
one, my lord, 95.4, my lord, will find. It is premised on a similar. My lord has already considered section 7. 95.4, my lord, will kindly see.
I would ask you to put that it has to be specified in this details.
An application under
Yes.
95.4, an application under subsection 1 should be accompanied with details and documents relating to, sees debts owed by the debtor to the creditor or creditor submitting the application for insolvency resolution process as on the date of application. The failure by the debtor to pay the debt within a period of 14 days of service of notice of demand and relevant evidence of such default or non-payment of debt. Then 5, credit shall also provide a copy of the application. Then, 7, it says 95.7, the details and documents required to submit it under subsection 4 shall be such as may be specified.
Correct. And 96.1 is no remedy. We don't immediate moratorium as soon as filed.
Yes.
So, my lord, those are, my lord, our submissions. My lord, kindly, my lord, protect us, my lord, so far as this is concerned, because of already, my lord, subsisting orders.
Okay. Thank you.
I'm grateful. I'm grateful, my lord. I think, my lord, those are.
Until Leonard counsel for the parties.
My lord, we have given a note on opening submissions. Would my lord require a final written note of submissions also encompassing Mr. Thakker's arguments?
My lord, the only difficulty is, my lord, we have, my lord, the matter now fixed on 3rd December. My lord,
December?
Yes.
One section 95 application is there on the 3rd of December. The rest are on the 19th of December.
So please have it adjourned till the 19th.
No. Why?
File a note, then. You are not going to help me.
Very well. I don't require to file a note. I have already
just
given
filed a note.
Leonard counsel for the respective parties. Counsel for the petitioner respondent number 1 has filed the written notes of preliminary submission on behalf of the written notes with regard to the preliminary submission. Let us then be kept with the record for order.
I'm so grateful, my lord.
Thank you. Much obliged.
My lord, I am appealing for HON'BLE. This is regarding the defreezing of account.
Yes.
On the last occasion, your lordship had already passed an order.
Lord, on the last occasion, if your lordship would recall, my lord, in this matter.
Yes, what is the situation of the
Yes, no, Lord, I'll tell your lordship 2 situations. That has been dismissed for default.
section 9?
Yes, that has been dismissed for default. This is the order. Now, my lord, the unfortunate part here, my lord, is that after this was dismissed for default, after your lordship fixed the matter on the 1st of December, the state, who was all along represented, did not indicate
that there was a criminal case purportedly filed after the Arbitration Act proceedings were filed. And after the order of dismissal was passed on the 29th of November, the very next day, the petitioner was taken into custody in connection with the case of Southport Police Station. No, not with regard to state, but Lordship can understand. So very well, my Lord, I would be praying for an adjournment. My Lord, why? Because, my Lord, your Lordship can understand. I have to, my Lord, the person has to first be released on bail. And, my Lord, the parties are also attempting to settle the matter. My Lord, but this is what has happened. The matter has been dismissed. The account, now with regard to that, police have started a case. I have been taken into custody the very next day. It was never indicated. It was never told. The state was all along there. I'll be praying for a week's accommodation, my Lord.
So after the order.
Counsel for the
30th arrest कर दिए थे.
the order passed by the London district, being order number 4 dated 26/11.
पूरी आमर domination जैसे.
Wherein the application
Arrest हो गया.
by the private
हाँ.
respondent under section 9 of the arbitration.
हम लोग लोग पे बिल करो.
for default. Let the order be kept beside and a counsel for the petition submitted. Unfortunately, in the meantime, the petitioner has been arrested by the police and is in
In a case started by the private respondent itself.
on the basis of the complaint made by the private respondent, and the petitioner is in
police custody.
Accordingly, prays for a week time. In view of the above, the case adjourned. Let the matter appear
No. Southport Police Station.
on 10th of December. 10th December.
My Lord,
10th December.
deep brigade.
Under the same heading.
Deep brigade.
Grateful to much.
But there is pool.
So you're denying his arrest.
Then it will be very good for me.
Denying the arrest, I am recording.
Then it will be very good for me.
Take instruction. Take instruction.
Should have been indicated, my Lord. That is what I was, my Lord, respectfully submit. Should have been indicated.
10th.
Deep brigade.
Grateful.
Thank you. Next.
My Lord, this is my petition, my Lord. This is a matter, my Lord, where
Item number
13, my Lord. This is my application, my Lord, for reconnection of electricity. My Lord, I have purchased. Kindly note the name of the petitioner, my Lord.
Which is the
Finance.
other side?
My Lord, BBSCDCL, Mr. Jishnu Chaudhary was appearing, my Lord, on previous occasion. Yes.
I am appearing for ACDC. For WBACDC.
The matter was substantially heard before the coordinate bench. What has happened here, my Lord, is the petitioner before your Lordship is a successful resolution applicant who has, through the mechanism of the Insolvency and Bankruptcy Code, my Lord, purchased a company by the name of India Pulp and Paper. Indian Pulp and Paper, my Lord, was enjoying electricity connection. There has been a disconnection. That is, my Lord, as far back as in 2016. Now, my Lord, after we purchased the company through the mechanism of the Insolvency Bankruptcy Code, my Lord, we write to the respondents, my Lord, on 29 January 2025 at page 137 seeking reconnection. They basically say, my Lord, that unless there are arrear dues, unless you cleared the arrear dues, we are not obliged to give you reconnection or fresh connection. Now, my Lord, the law is very well settled, as your Lordship knows, my Lord. Once the resolution plan under the Insolvency Bankruptcy Code is approved by the adjudicating authority, that is the NCLT, my Lord, as per the Supreme Court's decision in SR Steel and a spate of judgments that followed, my Lord, all pre-existing debts are extinguished. So that, my Lord, the purchaser of the company, the resolution applicant, can start from a clean slate and he is not hounded by old debts of the company. Then the revival would not be possible. So, my Lord, it is my humble submission that
When the CIRP was going on,
yes,
that this
yes,
was there.
yes, it was. I'll show your Lordship all of that.
View of the electricity was
Yes,
there.
yes, it was. It was raised. My Lord, what happens is the resolution amount, the amount that is being bid, that is 30 crores, 10 lakhs was apportioned for operational creditors. Operational creditors are creditors who have, my Lord, rendered some service or provided some goods to the corporate debtor company. Lordship sees, as per the plan, their allocation of the 10 lakhs was nil. So their claim was filed before the resolution professional. It was entertained, but ultimately they got nothing out of the disbursement from the payment that was tendered for the resolution plan. So that debt is extinguished. Now, my Lord, they cannot refuse to grant me reconnection on the basis of this past debt that they purportedly claim to be still existing. Now, my Lord, when the matter was previously being argued before the coordinate bench, Mr. Chaudhary, who was appearing for the WBSETCL, very fairly submitted that, my lord, the principal debt at least is extinguished. If your lordship will now kindly see the disconnection notice, my lord, that says that there are two components of the debt. At page 137, I have made my request for reconnection, my lord. Page 145 is the response by WBSETCL.
145.
Yes, my lord. Of the petition. The lordship will kindly see 6 May 2025. With respect reference to the above mentioned, subject it is being informed to you that on 27 February 2025, a joint inspection was conducted at your premises regarding your new LT bulk connection. During inspection, it is found that there was already a disconnected bulk connection, and as on 18 December 2024, OSD of the said connection is rupees, outstanding dues is OSD, my lord, of the said connection is rupees 2,56,74,644. Kindly see then the breakup. Principal OSD, my lord, is 1,29,73,806. Mr. Chaudhary had submitted, my lord, that this principal due stands extinguished with the resolution plan being accepted. So there was no dispute on that. Kindly see the next line. And LPSC, that is late payment surcharge of 1,27,838.30 paisa as on 18 December 2024. It was the submission of the WBSETCL that even if the principal due is extinguished by the resolution plan being approved by the NCLT, this LPSC claim will survive, because they had said that the bill for this was raised for the first time after, my lord, CRP had been completed and my resolution plan had been approved. That I will show your lordship is factually not correct. The last order also records that. So, my lord, they had said that until you pay this LPSC outstanding of 1,27,000.
So now the only dispute is 1 crore.
1,27,000. Now, if I may request your lordship to kindly see the last order passed by the coordinate bench, my lord. That is of 17 September 2025. An ad hoc interim arrangement was made, but I am not stressing on that. If your lordship will kindly see the first few lines, it appears. Yes, my lord, I have a copy. May I hand?
Order dated
17th September. If I may place it, my lord.
Yes.
It appears that the bill dated 2nd August 2022 includes late payment surcharge LPSC charges to the tune of 2,15,859. However, in the subsequent bill dated January 2023, the LPSC charges were shown as 0, while the net payable amount was reflected as 4,29,73,807. Mr. Chaudhary, learned senior advocate appearing for the respondent numbers 2 to 5, seek time to provide clarification in this regard. So, my lord, my humble submission is, if LPSC charge has been claimed for the first time prior to CRP and subsequent bills say it is 0, how can they now raise that claim? The principal due is extinguished, admittedly.
What was the total amount?
My plan, I am paying, my lord, 30 crores for the plan.
No, the claim which they have raised.
They have made their claim. I will show from the resolution plan the allocation of the amount that I am paying for the plan. They have got 0. The allocation to them is 0. So their entire claim is extinguished. May I show your lordship that, since the question has fallen from the tribunal, from the honorable court, my lord? Kindly see, my lord. The plan is approved on the 20th of December 2024. That is at page. Yes. Page 107, my lord. Yes. Yes, my lord. 107, the order of the NCLT starts approving the plan, my lord. Page 87 provides for payment of operational creditors' dues. Kindly see that, my lord.
Page 107.
Yes, my lord. If your lordship will see thereafter, my lord. The resolution plan itself that I have tendered, that is before that, page 87 of the writ petition is the portion of the plan that deals with the operational creditors' dues. If your lordship will kindly take page 87. That is paragraph 9.3 of the resolution plan.
87.
Yes, my lord.
Yes.
Kindly see
Payment
paragraph
of-
9.3.
Payment of operational creditors.
Yes, statutory dues also, my lord. RA, that is my client, my lord. Resolution applicant will infuse an amount of 10,272,000 towards operational creditors, statutory dues, as full and final payment, which also includes dues whether admitted or under verification of central government, any state government, and any other local authority, payments proposed against each claim has been more fully described under clause 8.4.1, which your lordship will find at page 73. If your lordship will kindly have page 73 of the petition. Page 73, my lord, clause 8.4. Here, my lord, again, resolution applicant proposes to pay 10,272,000 as full and final payment towards operational creditors, which includes dues of central government and state government and any other local authority. Payment towards the remaining operational creditors will be made within 30 days from the NCLT approval date. Here, thereafter, my lord, this table contains the bifurcation of the payments that the operational creditors are to receive. Kindly see, my lord, serial number 5 in the table. The claim of WBSEDCL is, my lord, reflected. They have made their claim, but from the money that I'm paying towards the total debts of operational creditors, my lord, the allocation that WBSEDCL is to receive is on the right, nil. So, my lord, they get nothing. And their claim is extinguished. This is the mechanism of the code. Now, my lord, my plan has been approved. Their debt is extinguished. My lord, kindly will note the judgments of the Supreme Court have been, my lord, discussed by the NCLT in its order approving the plan itself, which, my lord, says that past debts are to be extinguished. Your lordship will kindly see, my lord, page 130 onwards, that is the portion of the judgment of the NCLT, my lord, that deals with the law.
Yes.
Your lordship will
We
kindly
are
take
not quarreling with the propositions, so my learned friend need not labor into that.
lordship. So, my lord,
That
only
the past dues are extinguished is a settled law, my lord, we are not quarreling with that.
so, my lord, now
We have a different ground. What about the late payment?
Yes.
Surcharge.
Could I indicate that to you?
Yes.
Yes.
What about the late payment?
Yes.
Surcharge?
clarification was sought in the last order, my lord.
Lord, may I just indicate, my lord, the background of the concept of late payment surcharge? My lord, as per the regulations of, my lord, the West Bengal Electricity Regulatory Commission, late payment surcharge is only levied or leviable once payment of a defaulted amount is received. So, my lord, for instance, my lord, if I may give an example, if the bill for the month of January is outstanding, I am not entitled to levy late payment surcharge from the month of February onwards. That payment may be outstanding for years, for maybe 15 years. When they make that payment of that outstanding bill or a part thereof, then from the next bill, when they make the payment, I get the right, as per the regulations, to claim late payment surcharge. The incidence is not a default. That is a separate. This is incidence is the payment. So when they make payment of an outstanding bill, then only my right to claim late payment surcharge accrues. So it may be after 10 years also. And there are Supreme Court judgments also and judgments of the Honorable Division. I am led by Mr. Chaudhary.
May I have just 1 minute? Lord, we had already filed a notes of argument
As had
in the
we, my lord.
matter. My learned friends have also filed. If your lordship is pleased to take that note once, my lord. My lord, admitted position is that there is a resolution plan which has been approved. In today's situation, my lord, we cannot say that the clean slate theory does not apply to everything that has accrued till the date, my lord, of the approval of the resolution plan. My lord, I must start with this concession. So, my lord, as at the date of approval of resolution plan, my lord, there is, my lord, nothing which is due and owing, which I can say.
That are admitted.
Yes,
With regard
we-
to that, 2 crore.
My learned friend need not, my lord,
He
labor
talked
on
about that. Only with regard to the last payment surcharge.
So, my lord, yes, the difference in all these matters, my lord, we try and find a small loophole to get out of whatever little we can get out. Here, my lord, the loophole is, my lord, LPSC. Now,
That's why that's
that's
the only thing.
I'll just show your lordship. Note to the. My lord, kindly take your lordship has found my note.
Written notes of respond number 225.
225.
Yes.
My lord, please ignore, my lord, a capital A, which is, my lord, paragraph 3, 3 paragraphs, the background.
Yes.
Now, my lord, kindly come to late payment surcharge.
Correct.
So, my lord, here I had, my lord, invoked some bank guarantees. I had obtained, my lord, I won up to, my lord, NCLAT because it was a company under, my lord, CIRP. Now, pursuant to the NCLAT order, my lord, kindly see, my lord, paragraph B. On 18 December 24,
pursuant to directions of Honorable NTLAC, WBSEDCL received payment. Within 2 days, on 20th December 24, resolution plan was approved by an order of NTLAC and the moratorium under IBC 2016 came to an end. Subsequently, on 6th May 2025, for the first time, a demand was raised for LPSC by WBSEDCL. So this demand for LPSC, which accrues when I receive payment of the bank guarantee amount, is after, my lord, the resolution plan period. Now, kindly come to, my lord, paragraph.
Why you say that this you received after the payment of, why is, because you are the authority, you had the knowledge what is the last payment surcharge is lying pending.
And my lord, sorry, I don't want, mean to intervene.
That is the argument.
Just one factual correction I want to offer, my lord. Your lordship has seen the note that my learned senior friend has filed. Paragraph 2 at page 2, my lord. It is stated that subsequently on 6th May 2025, for the first time, LPSC demand was made. This is factually not correct, my lord, as noted in the order that is passed by the coordinate bench, the last order. So, my lord, the LPSC claim was first raised prior to, my lord, the NCLT approving the resolution plan in December 2024. So it is not correct that the first time LPSC claim has been raised in 6th May 2025. Only wanted to offer that correction.
That, my lord, I am not agreeing with my learned friend. That is for a separate LPSC. Say for example, in the month of January, I have 100 rupees outstanding. I receive payment of 5 rupees. So immediately, my lord, LPSC of 50 paisa becomes due. So on the 5 rupees which I have received. In the month of February, my bill will have a reflection of that 50 paisa.
Correct.
Now, my lord, I again receive payment in February of this 50 paisa.
Correct.
So then LPSC becomes 0. But bill of February again is, my lord, say 10 rupees.
Plus the 95 rupees.
Whatever, outstanding. Again, I receive, my lord, part payment. Again in March, my lord, there is LPSC which accrues. So LPSC accrues when I receive each payment. My lord, I want to start with a judgment, my lord. Kindly see paragraph 5 of my note.
So as per your contention, if the party or firm or person paid the bill amount that has not been paid in the due date.
Correct.
Correct. After the due date.
Yes.
Then the last payment surcharge will come.
Yes. Only after I receive that late
Correct.
payment.
Correct. We suppose
Yes.
the company raised the bill to you to X of rupees 1 lakh rupees, and the last payment for last due date is the 10th of December.
Yes.
The party has not paid the 10th of December.
Yes.
He paid on 15th of December.
Yes.
So 15th of December you have accepted.
Yes.
But January when you raise the bill, then you raise the
LPSC. For that 5 days.
For that 5 days.
Yes.
That is your contention.
Yes. And the fulcrum of that, my lord.
Why there is no provisions when you raising the bill, the last date and last date after the last date, there is a condition in the bill.
No. So only after I receive payment, I can't understand the logic, my lord. I couldn't. But this is as per the tariff regulations. Only.
What regulation?
Yes, my lord. Please have a look at my note now. Paragraph 5.
The regulation is in your report.
A learned single judge of this honorable court in such and such has held. Now, my lord, I'm just reading the quoted portion, my lord. Paragraph 20 of that judgment, we have filed the judgment. The chargeable event in the case of DPS is the payment of delayed payment surcharge, is the payment of legacy dues. Once a part payment of outstanding dues is made, only then DPS is to be charged on such payment or part payment, which is to be calculated with reference to the date when such dues were ascertained and communicated to the consumer for immediate payment. Appreciating from such perspective, clause 4.14 of Regulation 48 dated 25th April 2011 of the WBERC clearly stipulates the rates of applicable delayed payment surcharge arising from non-payment of electricity surcharge and also other charges for different time slabs. It is also stipulated the delay in payment shall be counted from the due date for payment. The above definition under clause 4.4 is very relevant in the present context. Taken in connection with section 56 subsection 1 and 2 of the 2003 Act, the above clause clearly indicates that the accrual of the liability to pay DPS arises not from the date when the bill was first raised for payment of the original principal amount, but from the first instance of non-payment of the concerned charges.
Then started the
Yes.
surcharge.
Yes. Milord, one, I confess, Milord, I was quite confused. When I asked, Milord, the WBSETCL people, Milord, they said that to make the calculation and to make the rate applicable, I must know what is the exact date of exact particulars of delay. So delay is 50 days, delay is 70 days. To reach that date or to have that computation, there must be a payment first. Otherwise, it continues.
That's correct.
So that is why this is the law that when you pay late,
Why there is no provision once you're raising the bill?
you can do it every month.
Correct. No, that's why you have giving the last date payment last date you have prescribed.
Yes.
And if you not pay the 5%, 2%, 1%, why you not?
Simple like my question, which I think is also, Lord, what is going through your lordship's mind, is that say bank interest. So 30, calculate 30 days and put it in the bill. Then next month again calculate 30 days.
Disconnection हो जाता है. Disconnection हो
So I'm told that there is some implication, but this is the ERC law. Milord, may I just read on, Milord? Paragraph 41, a distinction may be drawn in this context with regard to principal electricity charges due and the DPS payable. Insofar as the first is concerned, the same is a fixed cause of action which has to be taken to be the date when the amount became first due and payable. There is no scope of extension of the period of 2 years as envisaged in section 2 of section 56 in the event the said principal dues are not reflected continuously in the electricity bills for the next 2 years. However, in respect of DPS, the incidence is only on the instance of the delayed payment. Hence, in the present case, the liability to pay delayed payment surcharge for each tranche of outstanding dues paid by the petitioners arises on the date on which such delayed payment was made, as only on non-payment of electricity charges incident of DPS arises, and non-payment necessarily implies that the same has to be calculated up to the date of payment. Hence, for each of the installments of payments made by the petitioners with regard to the outstanding dues in respect of the supplementary bill of 2015, the liability to pay DPS would arise on and from the date of payment of such quantum calculated on the basis of the said quantum only. Hence, in the present case, the cause of action for imposition of DPS for the different installments of payment arose in a staggered manner, which is a concept somewhere in between a static fixed cause of action and continuous cause of action. For the purpose of each installment of delayed payment of the total outstanding amount, the cause of action for charging DPS would crystallize on that date and would not operate as a continuous cause of action. As regards the remaining outstanding dues, after each and part payment, etc. Now, my lord, this went up in appeal. In paragraph 6, my lord, is the appellate court order. My lord, kindly come to page 6. And my lord, I have, my lord, underlined a portion, which is, my lord, what we have underlined. It's not underlined in the judgment. My lord, it has been rightly held that a combined reading of regulation 4.1.4 with section 56 clearly indicates the approval of the liability to pay DPS arises not from the date when the bill was first raised for payment of the original principal amount, but from the first instance of non-payment of the concerned charges. Then the next underline, my lord, thus the liability to pay other charges, DPS, would arise as and when a default is committed. Now, my lord, what had happened? Special leave petition dismissed. In fact, in this judgment, my lord, I had appeared for the petitioner, and the issue was disconnection of electricity. So, my lord, disconnection you can only do within a particular time of default. So, my lord, we were trying to show that my default is beyond that particular time, and you cannot use my past dues, my lord, to effect disconnection. And my learned friend, my lord, appeared for the respondent, and my lord, he had, my lord, successfully argued that no, it is possible, and we lost 3 courts. So, my lord, we can't say that we have any. Now, next point, my lord, which
No,
is
but here he's not a continuous consumer of your WBSCDCL. He has came.
no, he's a continuous consumer.
Where's the continuous?
Continuous. Large default, company went into CIRP, huge amounts we had to forget.
Correct.
Now, my lord, in this writ petition, he's again asked for, we obtained an order, my lord.
The resolution plan, what has happened?
For I'm sorry, my lord.
In the NCLT, the CIRP, what has happened?
CIRP, my lord, past dues gone.
Correct. So who has the old company continues that?
Old company continues with.
Old company continues.
Old company
Yes.
continues, yes. Only the management of the own company will change, my lord. The shares will.
Are gone, but the striking feature is very interesting. I don't think we'll get this again with this timeline. 2 days before the approval of the resolution plan comes NCLAT's order by which, my lord, I am entitled to receive, my lord, bank guarantee amounts. And the date when I raise the next bill is after approval of plan. So after whatever accrues after approval of plan is not touched by the clean slate theory. And that's, my lord, accepted position. So LPSC arises this way: when I receive part payment,
then it continues.
In the next bill, an obligation to pay arises when he receives the next bill. So, my lord, this is saved. My lord, please see the next judgment, my lord. Paragraph C. My lord, date when LPSC first became due, if prior to approval of plan on 20th December to 2025, would be nullified. If after 20th December 2024 would be, I think both should be 24, my lord, that's an error. My lord, this is the judgment. Supreme Court. My lord, please see, my lord. Yes. My lord, please see, my lord, paragraph 10 and 11. This all follows, my lord, Rahmatullah Khan's judgment of the Supreme Court. Paragraph 10. In Rahmatullah Khan, 3 issues arose for consideration of this court. They were: what is the meaning ascribed to the term first due in section 56(2) of the Act? 2. In case of a wrong billing tariff being applied on account of a mistake, when would the account first become due? And 3. Whether recourse to disconnection may be taken by a licensee after lapse of 2 years in the case of a mistake. On the first 2 issues, this court held that though the liability to pay arises on the consumption of electricity, the obligation to pay would arise only when the bill is raised by the licensee, and that therefore electricity charges would become first due only after the bill is issued, even though liability arises on consumption. So this is how I get out of it. So even though, my lord, consumption is during, in fact, before CIRP, liability of my learned friend, which stands extinguished by the plan, accrues only after approval of the plan. So this doesn't get extinguished.
That is only the principal amount.
Only the LPSC.
Only LPSC.
Correct.
Principal is gone.
Correct. Only principal gone.
Yes.
So subsequently LPSC.
Only LPS. That's my claim. So, my lord, when he wrote to me saying I want new coverage, we agreed that you only have to pay LPSC.
But whether this was whether you have raised this, whether he has to pay the LPSC after the payment.
He can't touch LPSC. 6th May, after approval, everything closed in NCLT. After that is my bill of 6th of May, which has this LPSC. First time
Correct.
raised.
That's why you have given the LPSC bill after the resolution plan was
Approved.
approved and over.
Yes.
Correct.
And
subsequently you given this LPSC when the last payment was made by him before the resolution plan
before resolution plan
was
1 day before.
1 day before.
2 days before. No, yes, 18th December, 20th December. But his liability, not his obligation to pay and liability arises only as per Prim Court's judgment, only after I raise a bill.
Correct. That's what I'm telling. But that situation was not in the knowledge of the petitioner when the resolution plan was approved.
Second, my lord, could I have raised the resolution plan? Could I have raised the bill before resolution plan? Answer is no, because 1 day before approval,
that's
payment.
I am not telling on that, but how it can be justified, because he has paid 2 days before the resolution plan is approved. He has paid the all amount.
Yes.
Dues. Then the LPSC has come into picture.
Yes.
And the
after
that.
Can't be touched by the plan.
But that point was not before the resolution professional. Whether
That's why I succeed. My lord, there are 2 judgments. First judgment is of this honorable court, which says that if NCLT touches anything which is after the date of approval of resolution plan, it is void. And void, my lord, your lordship knows, can be ignored in collateral proceedings and said to be void. That judgment is in appeal before the division bench. But now we find that NCLAT is also saying the same thing. My lord, please see, my lord, the next 2 paragraphs of the... My lord, please see Sri Rajasthan Syntax Limited.
Where?
My lord, page 9.
Yes.
My lord, may I just hand up?
Yes.
Page 9 of the note.
Though, my lord, it's an NCLAT judgment, kindly give me leave to cite it. After all, a specialized tribunal. Page 6, paragraph 65.
Page 17.
Page 17 of the print. Again, electricity issue.
Yes.
This was, my lord, fuel surcharge. Please allow me to read paragraph 65. As we have seen earlier, though the liability to pay arises on the consumption of electricity, the obligation to pay would arise only when the bill is raised by the licensee. Hence, electricity charges would become due only after the bill is issued, even though the liability would have arisen on consumption. Fuel surcharge and SFS are not normal business debt, but statutory charges under the Electricity Act 2003, which would arise only after the bill is raised by DISCOM to the consumer. IBC does not allow prospective claims to be eradicated by approval of resolution plan. It is seen from the records that fuel surcharge and SFS charges have been paid up to April 2023. The appellant stopped paying the dues from May 23 onwards after obtaining the interim protection against disconnection from adjudicating authority on 25th May 23. The claim of the appellant for eradication of entire liability on account of SFS would not hold, as the bills for subsequent period were not issued by the respondent. Any amount which is due in future cannot be eradicated by including the same in resolution plan. The FS-SFS charges, which are statutory dues and become due only after the bill is submitted, cannot be eradicated by such resolution plan. We have also seen that the amount which has been paid by the CD as per resolution plan has met the existing liabilities of the CD and not the statutory dues which arise from the orders of regulator under Electricity Act. We have also noted, then let me not to save time, not read 65, 66, 66, 67. Now, my lord, please turn over the page to paragraph 68.
Yes.
Second part of the paragraph, this clearly shows appellant is attempting to misrepresent facts to evade payment obligations under Electricity Act, changing arguments and selective submissions. My lord, this is not applicable to this case. 69. The appellant has cited several judgments of the Honorable Supreme Court and the Appellate Tribunal in support of their claim. The applicability of these judgments to the present factual matrix has been examined. We now discuss the same. But I'm going to read this first, my lord, to show your lordship the purpose of the clean slate theory. Because, my lord, your lordship's conscience, my lord, must also be satisfied. My lord, this is why, this is the first judgment on clean slate theory, and this is why it came in. In Ghanshyam Mishra, decided by the Honorable Supreme Court, the matter related to financial claims that existed before approval of resolution plan and were either included in the plan or cancelled under IBC. In the instant matter, my lord, I'll just pause here for a moment. Justice Nariman, my lord, speaking for the Supreme Court, had said that these SRA or the successful resolution applicants invest monies on the basis of a list of, my lord, creditors.
Correct.
Now, after I take over a dead company wanting to revive it, this whole investment, this whole scheme of the act is lost if there are Hydra head claims popping up here and there subsequently. So, my lord, somebody...
That's what I'm thinking. Because that
Yes, your lordship is absolutely, my lord, correct. With humility, I say that Hydra head claim, my lord, somebody once told me, a friend, that Hydra heads, my lord, are expressions used in World War II. My lord, Hitler, my lord, devised a strategy of, my lord, defenses popping up here and there, which is what, my lord, was, that example was incorporated in the judgment. Hydra heads popping up. But this is, my lord, not a Hydra head. This is a known claim. Everybody, my lord, is presumed to know the law. The law is when you pay, in that case.
That's why I asked you. That's why I asked you.
Yes.
You have taken the simple plea because unless and until he will not pay, you cannot say what is the amount due. Only after the payment you can raise the LPSC.
Yes. But he knew. He knew. And why I say this, my
That's
lord?
whether the person knew what is the law with regard to the
My lord,
LPSC after the payment of the dues of the electricity on the
you know,
later
this is a presumption which I am battling against myself. Every person is presumed to know the law, but even then, I am in this condition. Now, here what has happened, three facts are important. Number one, NCLT Kolkata passed an order saying that bank guarantees have to be honored. Number two, a challenge was made by them before the appellate tribunal. So they always knew they had a bad case. And if they lost in appeal, bank guarantee payments would have to be made. And number three, they are presumed to know the statute. And in the bill itself, it is written that you have to pay LPSC upon delayed payments being made. So they can't, my lord, claim to be innocent, my lord, bystanders. And they have also, my lord, paid LPSC in the past. So this is something they are presumed to know, they are deemed to know, and they can't escape.
Okay.
Now, my lord, please see paragraph 69(1).
Yes.
This, what your lordship is asking, is the same logic used, my lord, to distinguish the clean slate theory. And I had stopped before that. In the instant matter, FS and SFS charges arise from the orders of the RERC and would become due only after the bills were issued by DISCOM. These are statutory dues under Electricity Act and SFS dues from the orders of the Honorable Supreme Court and is payable in future after the bills for the same are issued by DISCOM. Such prospective claims cannot be eradicated by IBC. Number 2, second judgment cited is Pioneer. Middle of the paragraph, remedies that are given to allottees of flats, apartments are therefore concurrent remedies, RERA overrides. But here there is no question of overriding. Third, my lord, your lordship will see all the judgments, my lord, which are usually cited are dealt with. Now, my lord, paragraph 70. Based on the discussion above, we note that if FS, SFS arise due to changes in power purchase cost beyond the control of DISCOMs, and the same is treated, DISCOMs is distribution company.
Correct.
And the same is treated as an uncontrollable parameter in tariff regulations. The fuel surcharge and the special fuel surcharge in the present case has arisen due to variation in fuel cost. Further, in case of SFS, due to change in law as decided by Supreme Court, it is due to peculiarities in the instant matter that the final decision about amounts payable to ARPL and subsequent manner of recovery of areas for consumers had to be decided such and such. Now, my lord, 71. We note that FS, SFS, though
What is
related,
SFS?
Special fuel surcharge.
special fuel surcharge.
Special fuel?
Surcharge. And the earlier is, my lord, fuel surcharge. We note that this is very important. Fuel surcharge, special fuel surcharge, though related to earlier period, could not have been claimed in one installment under PRIRP. As in this case, the obligation to pay arises only after bill is raised. We agree with the contention of the respondent in this regard that he could not have filed the claim for FS, SFS as it would be violative of such and such. The obligation for payment would arise in future as per directions of Honorable Supreme Court and tariff orders. And then 72, Mr. Gupta wants me to read. We have also seen that none of the judicial precedents cited by the appellant is squarely applicable to the facts of this case. In view of discussions above, we also hold that FS and SFS charges for which bill has been raised cannot be wiped out by the clean slate principle, as these are statutory dues which will arise in future and liability to pay would come after the bill is raised. Now, my lord, the regulations now. It's annexed to the notes. To the report, my lord. I'm sorry, that's like our affidavit. Right, it's not really, does your lordship want to see all, I'll just give the page numbers and the, my lord, first is, my lord, page 20. 3.3.9.
Correct.
Then, my lord, is page 4.1.4 at page 25.
1.1.4
at page 25. Then, my lord, 4.6.1 at page 27 and 4.6.1
4.611
Yes.
Demand and termination. Then
Then, my lord, this all, my lord, concerns how why bills should be raised later, etc.
yes.
Then, my lord, page 60. My lord, page 60. This is, my lord,
60.
yes, 60. This is, my lord, a part of page 59. My lord, I have given the first page and then, my lord, the 63rd page of the resolution and regulation. I've got the whole regulation for your lordship, my lord, if your lordship wants it. My lord, please take page 60.
Correct.
4.1.2. This is how it is calculated. And sorry, 4.1.4.
So that's why I'm telling, see, the rate of applicable delayed payment surcharge arising out of non-payment of the electricity charges. Also, the other charges by consumers shall be 1.25 per month. 1.25% per month of delay of pro rata for the
Yes.
part of up to 3 months of the delay, and 1.5 per month delay pro rata for the 3 months. So why it is not been indicated in the
So, my lord, the answer is, which found favor, my lord, with the earlier bench, my lord, the learned single judge and the division bench. You have to have the number of months of delay. Till you have that, you can't make this calculation. And to get the number of months of delay, you need the payment.
That's correct.
That's why. But
Mylord,
I
calculate all
totally agree, my lord. My lord, forgetting the law for the moment, I am entitled to a charge on delayed payment. Why can't I put it monthly?
Yes.
I can do it. As per, my lord, my thought, this is what I had argued also. Ratnanko Banerjee was leading me. We had argued that, but Mr. Gupta and Mr. Abratosh Majumdar were successful by citing this. Now, kindly see what they argued was 4.1.2. If your lordship sees, my lord,
The calculation system.
the calculation, I'm sorry, 4.1.4. Please see, my lord, two phrases. My lord, as also, second line, as also.
Yes, there are 3 slabs.
Yes.
First is 3 month 1.25, second 1.5, then third is the 2%.
Now, for all of this, all the 3 slabs, it's up to, first one is up to per certain such percent per month of delay.
Correct. Per month of for 3 months.
Yes.
Up to 3 months.
And then 1.5%
Pro
per
rata.
month of delay or prorated for per month
Beyond
up
3
to such and
months.
such.
So that is
Then,
4th month to 6th month.
yes. So, two things, my lord. Unless I know the total quantum of delay, I will not know the percentage to be applied. And
Each month the percentage will change.
What the
then,
percentage?
my lord, delay in payment, my lord, please read on. Delay in payment shall be counted from the due date for payment.
Correct.
This delayed payment surcharge is without prejudice to the provision of disconnection.
That's what I'm telling. See,
So
delay payment. So
yes.
how you are counting the delay in payment? You are mentioning the last date payment. If you are
Yes.
raising the bill,
First date of delayed payment.
correct.
First date of delay.
First, how from which date you count? Delay?
I count from the start date when the amount falls due and
You raise the bill. Suppose you raise the bill of December 2025 of 1 lakh rupees. So you have to mention the due date is 12th of
15
December or 15 January, whatever.
15 January.
Correct.
Yes.
So that 15 January, if we paid, so question of 4.14 will does not arise. So if will not pay on 15, subsequently for the 3 months he will not pay, he has to pay the 1.25.
Yes.
1.25.
Yes.
Then 6 months is not paid, 1.5.
Yes.
And after 6 months, 2%.
Yes.
Correct. So that's what I'm telling. So last date payment you are mentioning in the bill. So why the late fee is not been categorized?
That's Milord, a very, I'm no one to say this, but that also struck me once. But did not find favor. This interpretation.
Because the party can know. Yes, 1 lakh rupees, if today I will not pay on 15th of January, then 1.5% every month will come, then it will be so he can avoid that. Or then you can say, yes, he had the knowledge, but he has not paid.
Delayed payment surcharge, the basic
Milord,
nomenclature is
yes, that's true.
It's not interest, it's payment surcharge.
Correct. That's Milord. But the argument is, as Milord Mr. Gupta says, and he's right. He's now established to be right, and I'm established to be wrong.
It is already
But he says, Milord, it's delayed payment surcharge. So it accrues statutorily only after payment is made. That perhaps the thought behind
No,
it is
that even though take the delay after payment. So you already prescribed the
it
method.
can be. If you pay, this will apply.
Already applied, already prescribed what would be the penalty.
Yes.
So you cannot say unless he pay, we cannot calculate. Already it is applied.
I cannot give a quantum. I need to know the date of payment to give a quantum in the
That is
bill.
correct. I have said
Not.
so.
Percentage not.
No.
Need to give a quantum in the bill.
We've been having this discussion for 2 years now. Milord, I am more on your lordship's side, but law is on his side.
No, that's
So, Milord, he is.
I am also.
Milord, my mind.
Law is there.
My mind, very simple. It's like, say, a credit card payment. There is interest being applied. So why can't I add it to principal and put it in the bill?
Come and have
His answer to that is that this is statutorily delayed payment surcharge. So unless the delayed payment is made, the surcharge doesn't apply. It applies only after delayed payment, which is why it comes in later.
Payment
Have you defaulted?
yes. By পরের মাসে নিয়েছি।
This is
same thing. Payment করলাম তারপরের মাসে
there must be other reasons why this is there. Because this is not interest. This is not incidence of.
incidence is the payment.
No, the incidence is the payment. That's why it's not delayed payment surcharge. Once you pay, this attaches to you. If you don't pay, also, now speaking for him, if you don't pay, Milord, in that case, the books are clean. Maybe that's also a reason. Because you can't keep adding charges. There are so many. And now IBC has really created a problem with distribution companies. Because all Milord industries which have gone down, first thing they do is huge electricity dues, 20 crores, 25 crores, 30 crores. Then they go into CIRP. Everything gets wiped out. We tried for WBSEDCL, we argued Vasavi Industries lost up to Supreme Court. You can't get that back.
We had a 25 crore decree.
We had in Vasavi, we had a 25 crore decree of court. Mr. Mitra was leading both of us. We lost up to Supreme Court. And same is happening with Milord all other.
Okay. Yes.
So Milord, may I just summarize in one sentence, in just few bullet points. Number one, this is something I have not stressed on. Number one is, Milord, the Prem Kotex judgment which I have cited, which says no matter when liability on consumption, no matter when liability, obligation to pay is only upon bill. In this case, bill was raised, and rightly bill was raised the month after resolution plan is approved. So there is no obligation to pay before that. Number two, NCLAT judgment I have cited. This says that for the purpose of plan, it's a future liability. It's a future statutory liability, cannot be touched by resolution plan. It will be without jurisdiction. Number three, ethically, there is nothing wrong. He always knew that his bank guarantees would be invoked. He lost Milord before the NCLT Kolkata. He filed an appeal. that appeal was decided maybe 2 days before the plan. But for years before that, he knew he would have to pay this amount, and he knew from the reverse of his bill that he would have to pay, my lord, LPSC. So this is not a Hydra head also. Now, this apart, my lord, I have shown the judgment of this honorable court upheld up to Supreme Court that this LPSC arises only upon payment. Number one. Number two, that this is delayed payment. So when the delayed payment is made, that is only when this would come into the bill. Lord, these are my humble.
Thank you.
So, my lord, I just one thing on facts. No. First, I want to show, my lord. We had, my lord, last page of the writ petition. Page 145.
Yes.
My lord, when they wrote to us, my lord, we said this. With reference to your above mentioned subject is being informed that joint inspection, there was already disconnection. As on 18 December 24, outstanding is 2.56 crores, principal OSD 129 such and such, and LPSC 127. Huh?
So now only the question 1 to 7. So this you are not claiming. Wait. What about the principal 129?
We won't get, my lord.
Yes. That's all.
Lord,
First line of this.
Oh, yes. The other argument which I heard Mr. Shah make is, if you see, my lord, he argued this on the first day, which is recorded in the 17th September 25, my lord, order. In the bill of August, there is an LPSC of 2.15 lakhs.
Yes.
Subsequently, this disappears. In January 23 bill, LPSC is 0. Then how can this come up? Because the answer is because there have been payments in
That's
part.
what you are telling that this after, because page 73. Page 73 you have shown nil. So you made a submission that this is the nil because that time payment was
This is new. This is only on the bank
payment
guarantee
was
amount.
made, then the LPC has come.
Yes. Only on bank guarantee amount.
May I respond, my lord? Now, my lord,
So we have submitted on the judgment earlier. My lord, this is the division bench judgment, my lord, where I read out those underlined sentences. My lord,
Yashri division.
in Jayashri Steel, from the note, if your lordship sees.
Okay, I will take it.
I read it out to your lordship. The underlined portion.
Yes.
Yes. Lordship has seen the regulation, my lord. The regulation, if I may just draw your lordship's kind attention back to the regulation once
How
more.
much time will take?
It'll take some time, my lord, because I will have to distinguish each of their judgments. Take your lordship through that.
Just distinguish that judgment.
Because I'll tell your lordship.
I hope he succeeds for my other matter.
I hope to prove my learned senior friend right.
Okay.
My lord, I have already filed a notes of arguments, which, my lord, in summary, distinguishes the judgments, my lord. But I will have to take your lordship through the facts of each of these judgments to show your lordship why they have been, the court has held in the way it has in each of these matters. Two things, my lord, at the outset. Number one, my lord, learned.
You will take some time.
Yes, my lord, sometime it will have to take. Or if your lordship pleases, we can come back any other day, my lord, also.
You come other day.
Yes, my lord. There is urgency because, my lord, I have to revive the
Any
industry.
day barring tomorrow, my lord, any other day.
Any day barring tomorrow, my lord. Any other day this week.
What my diary says. Fix
But your lordship need not fix any. If it is there at the relatively at the top, my lord, we shall take our chance, my lord. Then I fixed
the counsel for the respondent has counsel for the respondents number 2 to 5 have concluded their argument. The counsel for the petitioner intend to give reply, but due to paucity of time, the case is adjourned. Let the matter appear on 3rd December. Under the heading adjourn motion at the top.
3rd December. Very grateful, my lord.
So, tag कर देना, छोड़ मत देना. Yes.
My lord, kindly takes your lordship's last order, my lord.
My turn to report
paid?
compliance.
No, they have not. They have not. And my
They have
lord,
been able to
monthly
fulfill-
consumption of October, my lord, that is also not paid. 1.14 crores are not. We have issued another disconnection notice.
That perhaps I cannot comment on because I do not have instruction. Insofar as your lordship's order is concerned, out of 16, 11.5 had been paid. For the balance, I had got some time. I'm told my instructions are they are in the process of making the payment by EOD today. Your lordship will kindly take it up tomorrow anytime. If they do not comply, your lordship will pass.
No, my lord will pass an order.
I am directing if they are not paid. You
Very well.
Exactly.
My only instructions are that they are, but it is an unfair.
Clients are not required to take any
Absolutely.
leniency.
Very well. I completely bow down to whatever. If your lordship could kindly take it up tomorrow, then in that your lordship may pass
Another
necessary orders.
1.14 crores is already
That is-
due
that
on
is
account of
something-
October consumption.
No, no,
This is
that
not a my lord petitioner who deserves any mercy from the court.
That is not something that is perhaps correct. So I
have the disconnection notice with me. How can Mr.
that is not the subject matter.
Banerjee say all this? My lord was very kind to give them, my lord, two
Your lordship
opportunities,
was.
my lord, despite the petitioner
Absolutely.
not being entitled to any protection.
Absolutely. That I cannot have any.
What is the total due?
65, the alleged total due.
My lord, it was
65 lakhs, out of which I claim 2.32 on account of the Aptel order. Thereafter,
present due is, my lord, 5 lakhs.
present
What
due
was
is
the
5
total,
lakhs.
total due?
My lord, the installment amount was 1647,007. They had paid 1647,007.
Correct.
They had paid 1147,008. So, my lord, the amount which was outstanding was 4,99,999.
4,99,000?
999.
Yes.
Which lordships had, my lord, granted them time in terms of the 21st November order to be paid before this date, and matter was fixed at 1 p.m. today to see compliance.
Correct.
They have not paid this.
Yes.
And there is a disconnection notice further
All
on
I'm
account
saying
of
is, all
October
I'm saying
dues.
is my instructions are, this is completely unfair. It's an embarrassing position for me as well. All I'm saying is my instructions are that they are in the process of making the payment. If they do not affect the payment by tomorrow, your lordship will pass this order tomorrow.
My lord, may I pray for
That is
this,
all.
my lord, considering, my lord, what he is submitting. My lord will kindly dispose it off by giving us the liberty to disconnect after 4:30. Gives them time till 4:30. If they pay, we will not disconnect. Lordship can pass
We
this.
have sought time till EOD. It's up to, I leave it to your lordship. To be really honest, I do not have.
No, it's banking time. So I expect,
not
my
have
lord,
to
within the
discuss to
banking hours, my lord, I will get the payment.
negotiate
I will
any
not
further.
disconnect, my lord,
Any
till, my
further,
lord
may I? The only issue is the writ. The issue in the writ may be kept alive. Today we are seeking an interim order against the disconnection. But the issue in the writ, whether I'm entitled to a set off vis-a-vis the 2.5, that is a separate issue. The writ may not be disposed of. All I'm saying is, if your lordship takes it up tomorrow, if I don't ensure compliance, your lordship will vacate the order.
The total claim against the petitioner, 47,007.
It was 65 lakhs, your lordship. I have already
Only the third installment which
third
was due.
installment is due.
Was due. क्या बोला? Total due pending against the petitioner was rupees 16,47,007. In terms of the order passed by this court dated 13 November 2025. No, 12/11/2025, 12/11/2025, comma. The petitioner has paid an amount of rupees 11,47,008. And accordingly, this court has passed an interim order restraining the respondents from disconnecting the electric connection of the petitioner. On 21st of November 2025, it was informed to this court that the balance amount of rupees 4,99,999, will be paid by the petitioner within a week. And accordingly, the court has fixed the matter today at 1 p.m. When the matter is taken up today, it was informed by the learned counsel for the DVC that the petitioner has not paid the balance amount of previous 4,99,999. Counsel for the petitioner prays for a day's time to seek instruction whether the petitioner has paid or not. Not. For the interest of justice, let the matter appear tomorrow at कल के 1 बजे है. Case is adjourned till tomorrow at 1 p.m. It is made clear that by the time fixed, the petitioner will not pay the total dues of rupees 4,99,999, no further interim order will be granted.
My
Lord, I beg to appeal for the regulatory commission, Lordship.
12 बजे करता हूँ, 12 noon.
12 noon, my lord.
My profound apologies, Your Lordship, for the conduct. I'll come back.
No, inform your client, otherwise I will.
Deeply obliged. I'm deeply
One
obliged.
is item number 15.
Huh?
Item number 15, your lordships, my lord, please to direct on last occasion to take instruction whether we want to proceed with this matter or not. My lord, my instructions is that my lord, we don't want to proceed with this matter, my lord. My lord, leave
With
maybe.
Consumers Forum.
Yes, yes.
Award of the
yes,
Consumers
yes,
Forum.
yes,
You
that
want to execute in the writ application.
my lord, I want to withdraw this writ petition, my lord. My lord, liberty may be given, my lord, to file it before the appropriate forum.
Give the item number 15. Give the item number 15. Record a note. So you have instruction. You have instruction to
Yes,
withdraw.
yes.
Counsel for
On
the
telephonic information.
submits that he has instructions from the petitioner to.
Lordship, I am for the Union of India in this.
So is withdrawing your any objection?
No objection, Lordship.
Counsel for the petitioner has instruction from the petitioner that the petitioner intend to withdraw the present writ application. Accordingly, on instruction, counsel for the petitioner prays for withdrawal of the present writ petition. In view of the submission made by the counsel for the petitioner, WPA 17782 of 2025, within brackets Surajit Khan versus Union of India and others, is dismissed as withdrawn. Full stop. It is made clear that withdrawal of this writ petition will not prevent the petitioner from taking appropriate steps.
My lord, liberty, my lord.
Not prevent you to take
Yes,
appropriate
yes.
steps before the appropriate court of law.
Much obliged.
Grateful to Lordship.
No, this is that matter, my lord, where, my lord, my client had challenged an order of rejection of an insurance claim, my lord. Now, my lord, the other side has come up, my lord, on the last occasion, my lord, and made several submissions, my lord, which obviously now, considering whatever they are saying, my lord, I can understand, my lord, the scope of the writ petition gets very narrow, my lord, because it's no use, because even if your lordship sends it,
I indicated,
my lord, we
I
consider.
dispose of. If
I
any
understand.
observation,
But I
then you will be
understand.
difficult.
Absolutely, Manan. We all took a conscious decision, Manan. Manan will kindly record my submission that I want to be dedicated to the suit court and go to the suit court and file it. And if there is any, this is only I'm beseeching a lordship, that if I file anything, some kind of expedition may be granted. Manan, if it's possible, it can be expedited, Manan. This much. But that's my instruction, so I made my
If you go
submission.
to this Rajarhat, I can. But if
This
you go
is
here,
instruction, Manan. Instruction, therefore I say so.
if you go that court, it can't.
No, I'll have to go to a regular civil court, Manan. But Manan records that I've said that I'll go to the suit court and yeah, because it will only go round and round in circles, Manan.
Counsel for the petitioner submit that after taking instruction, it is decided that the petitioner will not press the present writ application and press for withdrawal of the writ application, and he will take appropriate step for filing suit before the appropriate court having jurisdiction. Accordingly, WPA number 25078/2025 is dismissed as withdrawn. However, the dismissal of this writ petition will not prevent the petitioner for taking appropriate step for filing suit or any other remedy available to the petitioner.
Very grateful, Manan. But we took a call, Manan. No use, Manan, continuing because even if I
Actually, had subsequently what they have taken the plea.
But
We
even if
don't
I
know what will be the result, but if
even
any
if I
order is
got
passed,
Manan, a favorable order of going back and again they would come back with the same thing, Manan. So that's the reason I thought.
from Sinha you got the walkover.
Mr. Sinha, I pleaded with him that please try and look into it, give us a fresh hearing. He wouldn't.
Yes, next.
Very grateful to your lordship.
I am for the petition, Lordship.
13 हो गया.
Lordship, on
Yes.
Lordship, on the last occasion, Lordship
But I
directed,
appear on behalf of the CSC.
Lordship directed me to serve a fresh notice upon the added respondent, Lordship, and to file affidavit of service.
Landlord.
Landlord. The added respondent. Lordship. The affidavit of service. Lordship, petitioner is the tenant in the said premises carrying on a business. For that, applied for a commercial connection having trade license for the said business. After the application, CSC authority issued the letter, Lordship, the last annexure, page 17. After our site inspection on Atho, you had been advised to identify in consultation with the owners, applicants, a suitable common position for shifting of the existing AC service. This is the last letter, Lordship.
AC service.
Man, this is the account service, man.
Lordship, I am a
Not
tenant.
air conditioned service.
Lordship, I am a tenant. I am not the landlord of the said premises. I am only paying for one metered connection for my.
My lord, I appreciate, my lord, but the difficulty is that, my lord, when we inspected, we found that the meter service board, which is there, my lord, the service connection, it is in the lowland. It is high risk.
It is in the
Lowland.
lowland.
It is high risk, my lord. That is the reason since an application for new connection has come, my lord, instead of putting it there and taking risks of the livelihood, my lord, we have suggested if a common position be adhered into by the landlord and the tenant, my lord, we will provide him a meter subject to shifting of the meter of the landlord. Now, that is the reason on the last occasion, my lord was pleased to direct the landlord to be made a party.
Lordship, I have made and served, Lordship. Lordship, now I am a tenant, Lordship. How I
The
can.
shifting, my lord, we cannot do it in piecemeal, my lord, until and unless there is a consent or an order from this court, my lord, we cannot.
The landlords do not agree on their shifting, Lordship. I will not get the connection anytime, Lordship.
So you do one thing. You file the report to that effect, giving the total picture also, inspection, give the picture, what is the lowland, what is the dangerous, come with a total report along with the diagram. What would be
Give me fortnight time, my lord, we will again inspect.
and where is the place to it can be shifted.
But, my lord, yes, we will find out an alternative space, my lord, let them cooperate with us, my lord.
They will cooperate and give the report and it's serve the copy to him And you also forward the copy to the landlord also. I am passing an order. If any report is submitted.
Lordship, landlord is not appearing. I have served.
That's why it's not appearing, but the report may be forwarded to the landlord.
Achha.
I will pass an order along with this report. If the landlord will come, I will pass.
But my lord, if he is not appearing, my
If
lord,
they will not appear, then the court will pass a report.
but my lord, how can we forward the report, my lord?
Now that's why you file the report,
My
give
lord.
the copy. I will direct the copy may also be forwarded to the landlord by the petitioner.
Oh, as you
And
lord.
file the affidavit of service.
I only
After receipt of the report, if the landlord is coming, then I will hear the landlord. If they will not come,
As your lordship will.
Lordship, another thing I am proposing, Lordship, the service connection is low as per the submission of the CSC. What I am saying, Lordship, it can be lifted a bit.
so that's why lifted the
For
report.
that, I am ready to willing to pay the charges.
Correct. That's why let the report clear picture should come.
Lordship.
And let it be intimated to because the landlord is not appearing.
Lordship.
So let it report be come and you also forward the report. I am passing this order.
Lordship.
If they after receive the report, they will come. They will come. If they will not come, then I will pass an order.
No,
You
no,
bear the cost.
I'll see.
You bear the cost, and the authority will shift. And I will, if they will object, then the police authority will take.
Well, I'll seek for police protection for the inspection, my lord. The next, I'll seek for police protection, my lord. Since they are not appearing.
In terms of the order passed by this court dated 18/11/2025, the petitioner has added the landlord as defendant number 3 and also saw respondent number 3 and also saw the copy to the added respondent, but in spite of service of notice, none appears on behalf of the added respondent. The petitioner has relied upon the report of
No, that is a letter, my lord, at page 70.
Letter issued by the district engineer Aura dated 11th March 2025, wherein it is mentioned that on site inspection on 11th of March 2025, the petitioner has been advised to identify in consultation with the other owners a suitable common position for shifting the existing AC service at the said premises. Counsel for the CSC, CSC submit that the existing AC service line is lower line, and if any further correction is given, there is every chance for any untoward incident. And as such, unless and until it is not been shifted, it is not possible for the CSC to provide new meter to the petitioner in the premises of the petitioner. As none appears on behalf of the added respondent, the CSC is directed to inspect the premises and to submit a detailed report before this court after serving the copy to the learned counsel for the petitioner. The learned counsel for the petitioner is directed after getting the copy of the report from the CSC, he shall forward the said report to the private respondent and file the affidavit of service on the next date fixed. It is full stop. It is made clear that even after receipt of the report by the private respondent, the private respondent failed to appear before this court, appropriate order for the past. Let the matter appear.
But I'll seek for police protection for inspection.
Let the matter appear on 17th of December 2025. Police. It is made clear that if the CSC officers find any difficulties for inspection of the premises, or the private respondent, added respondent are restraining the CSC officials from inspection of this premises, the concerned police authority, the officer in charge of directed to provide necessary police help to the officials of the CSC for inspection of the
Cost of the
premises,
police be paid by the.
inspection of the.
They are demanding for police help.
My lord, he knows it very well, my lord. It is not our duty to pay, my lord.
Connection. ठीक है?
So the cost of the police be paid.
I will decide subsequently.
My lord, we will not be able to
My
inspect.
inspection is that there will be no objection on the date of inspection.
And they are as per the court order.
My lord, the police will not go, my lord.
Why?
My lord, they will not
There
go.
is a direction of.
My lord, they will not go. My lord, I'm telling your lordship, my lord, will find it in the next day.
Okay, you pay the cost. If any cost is to be paid for the police help, the petitioner shall pay the cost for the police help if necessary at the time of the inspection by the CSC officers. Yes, next.
Item number 16.
May it please your lordship, my lord, I'm for the petitioner. My lord, as per your lordship's order dated 18/11/2025, my lord, I have made the additional commissioner of police Bangalore as a party as respondent number 10. My lord, I have served them a copy as per your lordship's directions through email as well as regular mail, my lord. Here is the affidavit of service.
Well, let him be directed to serve a copy of, after making the amended copy.
What?
Cost item.
I'll enter it in your records.
Anybody is appearing
Kumar Junior.
for the additional commissioner of police, ACP Western? No. You are appearing. Have you received any information from the ACP Bangalore?
Oh, if you put
Yes. Nobody is there. What can be done? Yes, madam.
My lord, we had already indicated that in the closure of the complaint which was lodged with the banking ombudsman, we had indicated on 30th of April that the hold was put only because of this direction. So unless and until there is a formal order of court, the bank will not be in a position to act contrary to the direction passed by the concerned authority. So if your lordship passes the necessary order, then bank would be obliged to follow that.
So I will pass an order
Yes.
directing you to defreeze the account of the petitioner.
My lord, probably, yes, the bank has to do
defreeze-
this.
Bank defreeze the account of the petitioner within 1 week from the date of the order. Before defreezing, again you inform the police authority, the ACP Bangalore. If any response was coming, then it can be solved by thing. If they are not coming, then you.
That's why, my lord, we want to, well, not kindly cease. We have served this letter. On last occasion, they did not receive, but I served it in the court, my lord. After receiving this letter, my lord, we specifically told him, my lord, this allegation, my lord, can you cease, my lord? With reference to the caption matter, you are aware that the account has been put on hold or debit freeze on the basis of the information received from the concerned authority, law enforcement authorities, and in the light of the extant guidelines. You are also well aware that hold or debit freeze in the account was not related to KYC, but due to multiple transactions in your account which are not in commensuration with your occupation or income, which very well reflects in your statement of accounts. Previously, you also were told to visit the branch and to explain the situation in this regard. However, you have not explained. Therefore, you are again requested to visit the branch during working hours in any day or in any working day, preferably upon taking prior appointment to explain the transactions. So you want to help him out. That's why you have written this letter. After we have written this letter, he has written a letter to us.
Yes, why you're not appearing?
My lord, can you see this letter, contents of this letter? He has stated that this letter was not served in the proper address. I, the advocate of the bank, made grammatical representations before the court. All these things have been stated, but he has not explained why this account, why the multiple transactions happened in his account. Nothing. He did not explain in this letter.
Now, my lord, may I be permitted to give the reply, my lord?
Yes.
My lord, kindly comes to page number 28 of my writ application, my lord. 28, 28, my lord. Annex to P3. I will elucidate before your lordship exactly what has transpired, my lord.
Yes.
My lord has it? My lord, kindly sees the date of that particular email. It is Monday, May 8, 2023, my lord.
Correct.
This was the first time that the bank had actually intimated me that a hold has been placed. And what is the amount, my lord? It is clearly written 6,700. May 8, 2023.
Yes.
I have annexed the entire email chain, my lord, the entire correspondences that has happened, that has occurred with the respondent bank, with my writ application, my lord. Now your lordship will see the entire communication is there. The petitioner being the customer of the bank, it is not the bank manager's own money. It is, they are merely a custodian of my money. They have placed a stop on the account. They haven't even bothered to explain the reason why. So for 1 year, my lord, more than a year, kindly comes to page number. My lord, page number 41, please. Annex to P5.
Yes.
My lord, kindly sees the date, that is May 31st, 2024.
Yes.
So after 1 long year, the bank manager deems fit to reply to my client's communications. He has repeatedly reiterated and asked for information regarding why that hold was placed. Not a single statement. Nowhere did the bank ever call him. And not a reply was given as to why it was blocked. Now on 2024 May 31st, the bank replies that a hold was placed based on a cyber police complaint. This is the first time that I'm getting to know as to what has happened. Not completely though, my lord. Now, my lord, kindly turns the next page, page number 43. On November 12th, my lord, 2024, after 1.5 years of that transaction having happened, it happened in 27th of April 2023, my lord, that unsolicited credit came into my account. The account was blocked. So after 1.5 years, the bank authorities deemed fit to reply stating that why it was under hold and whom to contact. If this is not deficiency of service, what is, my lord? That to avoid that, now, so that I do not go to the consumer forum and seek damages for deficiency of
Correct.
service.
That's why I was telling.
A
Why you
new-
not go to the consumers forum?
And a new narrative has been weaved, my lord. Now, your lordship, all this time, nowhere the bank cannot show a single scrap of paper or any intimation asking me to come to the bank and explain any transactions. This is the third time this matter is appearing before your lordship. On the first day, when this matter appeared, my learned colleague from the bank, presumably upon instructions, he said that he wasn't happy with the instructions. He wanted to be fair. He sought time. On the next day, that is on 18th of November 2025, when the hearing commenced, a undated letter was thrust upon me in open court, which your lordship also recorded in that letter. Now, my lord, kindly peruses this intimation, which I went ahead and served upon the bank. Now, after pursuant to that letter, that undated letter served upon me, I checked online the tracking. It shows that insufficient address, it is going back. I have annexed that, my lord, in my application, my lord, which I went to the bank manager's office and I presented myself and I gave this letter asking them as to when they had actually given me any intimation that I've appealed.
Is not going into that. Yes.
He may go and visit the bank on any
I have gone
He has
there.
requested
Sir,
My lord,
what
24th of
service you are
November.
providing?
My lord, kindly cease.
Can I put the cost upon the bank?
No, my lord.
No?
My lord, this is a fit
This
case
is
for
the way the
cost.
bank is functioning.
We have
That to SBI. My lord, to the SBI. When the account was sold?
My lord, in the month of May, my lord,
May.
2023, my lord.
Yes.
My lord,
Thereafter,
April.
you are telling that he has not come forward. He has made several correspondence with you.
But he is not visiting the bank.
Why? What is the necessity of visiting?
To explain the transactions, my lord.
What is the transaction? Who are you? Have you sent to the income tax department?
No, my lord.
Have you sent anything? Are you authority? You are the authority. If I am having so many business transactions, can you are the authority to question my transaction?
No, not at all.
Then
under the instruction of the police authority that we have indicated.
When you indicated, if they under the instruction of the police, so why you are calling him to bank?
So that we
You are the investigating authority. So then
we can cooperate with the
let the put the cost of 10 lakh rupees. You pay the cost.
My lord,
need not to go to the consumers forum.
My lord, I
My
shall
lord,
be
may I come
grateful,
back?
my lord.
My lord,
My lord, this is the need of the hour, my lord.
This is the way.
I am not making any submission.
I am also sufferer of this SBI.
I am not making any submission.
My lord, this
If you want to open the account, you will visit the house customer of the house 10 times. Once the account is open, you are the king. Then you are calling the customers to the bank.
My lord,
This is the way you are working.
My lord, may I instruct?
Tell me, you take instruction when you freehold the account. When?
My lord, tomorrow may I come back tomorrow? Tomorrow may I come back?
Otherwise, which bank? Where is the bank? Otherwise, call your manager and I put the cost from the pocket of the manager itself.
No, my lord, I will come back tomorrow. I will come back.
Showing the one paper, yes, he is not coming. Who are you to call the
and I have
customer?
been there, my lord.
Who are you to call the customer? He has not done any mischief with your bank. You are not the investigating officer. You are not the investigating agency. If the investigating agency has not stated that, record the statement and sent to you, sent to the investigating agency. Has they have? No. Then why you are calling him?
I may come back tomorrow.
It is necessary the customer should come to the bank.
May I come back tomorrow?
Every day you are sending the notification, everything, customers door service. And this is the door service.
And that too, despite me going over there, my lord, he has put the receipt over there. Receipt is there, 24th November, I've been there. And despite that, it is being submitted in open court that I haven't been there.
In this determination, all banks should be very. This is not the way. Okay, you receive the information, you freeze the account, that's all. You immediately inform that. What is the right to call the person and asking the if we made a several transaction, if you have a doubt, you send the report to the income tax authority, nothing else. That too you cannot do, even though you send to the income tax authority will take if it is illegal amount, he has not paid the tax or whatever it is, and that does not arise. Once it has been in the bank account, he cannot avoid the tax nowadays. So you take instruction when you will defreeze this account. When you will come tomorrow, the petitioner has filed the affidavit of service showing the service of notice upon the assistant commissioner,
Additional, my lord.
additional commissioner of police,
Respondent
within bracket ACP, West Sen Crime Police Station, Bangalore, Karnataka. But in spite of receipt of the notice, none appears on behalf of the added respondent. No report has been filed in terms of the order dated 18/11/2025. Counsel for the petitioner, counsel for the bank, prays for a day's time to take instruction. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear tomorrow at 12:30.
My lord, take about 12:30, my lord.
12:30.
What?
At 12:30, my lord, we'll be taking up.
My lord is fixing a particular time for this matter.
11:30.
11. Great.
I'm grateful, my lord. Extremely grateful.
Otherwise, it can be by order of court only. The
thought, but-
defreezing, yes, because nobody is taking action since 2023 is a predicament for the petitioner. I understand.
of this matter so that you can call the police authorities in presence of the petitioner.
Why?
That is for the
Still, we have
investigation
done that, my
authority.
lord. Still, we have done that.
If the authority they are so negligent after receipt of the court, they are not appearing.
Yes.
And you will do. They have not initiated any FIR. And any FIR has been sent to you.
Not FIR
Then-
has been sent, but instructions has been sent.
Instruction only hold.
Yes.
Is any proceedings has been sent to you?
No.
Any details of the FIR has been sent to you?
And that too, my lord, the hold was only for 6,700, not for the entire balance.
And to talk with the investigation.
6,700 and 6 crore rupees, they are not taking any
No,
action.
my lord. And despite that, after he submitting in the open court, I instructed my client, he went over there, they put the stamp, they did not ask even a single word about any transaction whatsoever. And
That is neither here nor there.
Okay,
We'll
come,
come
come,
back
come,
on
come.
the
Submit
next day and
Come tomorrow
yes,
with the positive
I'm grateful, my lord.
12:30. 12:30.
12.
Grateful, my lord.
Lord, in this matter, I owe, my lord, an apology to your lordship. 13th, my lord, the matter was taken up. My lord was kind enough, my lord, to direct us, my lord, to add the private respondent who was not impleaded, my lord, to implead him, my lord, in the array of the respondents. That has been done, my lord, copies have, but in my lord's copy, my lord, the correction has not been incorporated yet. My lord, in their copy, my lord, it has been done, private respondent.
Who is your advocate on record?
My lord, I am yet to see him, my lord, physically.
Lordship, I'm appearing online, your lordship. I apologize, your lordship. Due to some inconvenience, I couldn't do it. I'll do it immediately, your lordship.
আজকের মধ্যে করবে বলো তাহলে আমি মামলা করছি নাহলে না
I'll do it by tomorrow, your lordship.
But I leave it to your lordship. I leave it to your lordship. If my lord is inclined to hear me,
What is the
my lord, this is against my lord an order passed, my lord, under the West Bengal Highways Act.
Who is for the authority?
State. No, in this one.
Okay. The petition 6 days time. Petition submit that though this court has added the respondent and the note and the petition has already served the notice upon the added respondent, but due to inadvertence, the name of the added respondent not been included in the cost title. Counsel for the petitioner prays for a day's time to include the name of the added respondent in the cost title of the petition. According case is adjourned, let the matter appear day after tomorrow under the same heading.
Grateful to your lordship. You know.
Lastly, they submitted that they will be using a supplementary affidavit.
That my lord, we have my lord prepared. Copy daingi to main tab. I'll supply my lord my copy to me.
Next.
Item number 18.
My lord, I beg to appear on behalf of the petitioner, my lord.
My lord, I appear on behalf of the CSC in this matter.
Well, I am for the state respondent.
My lord, I have served the respondents, my lord. My lord, it is coming denial of an electricity connection.
What is your grievance? Electric connection?
Yes, my lord.
Where is the report?
My lord, no report was circulated to my lord. Probably it will be no report circulated, my lord.
My lord, may I submit in respect of the order, last order, my lord?
May I just make my humble
Last order, my lord, I humbly submit, this order has been wrongly recorded, my lord.
That's why I am searching.
Yes, my lord, we have also searched, my lord, this is wrongly recorded, my lord. There was no direction for inspection, nor we have inspected earlier. There was no direction, nor we have put in any report, my lord. My lord, let this order be clarified in today's proceedings, my lord. And my lord, now if he wants to submit, my lord, my learned friend can submit.
My lord will take up page 75 once.
Yes.
My lord, this is the order, my lord, which has been passed by the authority rejecting my prayer for new connection. Now, my lord, there was an unauthorized construction in respect of the property in question. Now, my lord, that demolition order was the subject matter of a separate writ petition filed before this honorable court.
Yes.
That demolition order was the subject matter of a separate writ petition filed before this honorable court. No, that has been disposed of by the honorable court, setting aside the demolition order and remanding back the matter before the authority to take a fresh consideration. As regards to one floor is concerned, my lord. Now, my lord, rest of the building, my lord, we have a sanction plan. I have annexed the copy of the sanction plan also, my lord. I'll show your lordship, my lord.
Then what has happened then?
Now, my lord,
now, my lord, the premises in which you want the electric connection, that is the illegal construction, or that is coming under the that is coming under the sanction plan.
My lord, there is a sanction plan in respect of G+2 story.
Correct.
One floor extra has been constructed.
Correct.
Now, my lord, I am seeking electricity connection in respect of the authorized portion as of now.
That's why I'm asking authorized person that which portion?
G
In the
plus
second
2,
floor?
as per the sanction plan, my lord,
Ah.
whichever is there in the sanction plan, I am seeking electricity connection in respect of that.
I may be wrong, but the own sanction plan has been annexed with this writ petition.
My lord,
And
kindly
our
please
in
page 65.
Page 65.
Yes, my lord.
Yes.
This is my building permit issued by the Howrah Municipal Corporation, my lord.
Building permit, yes.
building permit.
Page 65 is the building permit. Who are you? What is your name?
My lord, Matara Constructions, my lord.
Your Matara Construction.
And my lord, the
G+2
This has been given to whom? Pritikana Baduri and Bhaskar
yes,
Baduri.
but the landowners, my lord, the landowners,
They are the landowners.
I have made them parties in the writ petition, my lord. Now, my lord, your lordship will kindly takes up page 69 once. My lord has got page 69. My lord, this is the notice of self-demolition for unauthorized construction of ground floor to first floor deviation from sanction plan and second floor without sanction plan at premises number such and such. This was the, my lord, subject matter of the writ petition.
Yes.
Now, my lord, kindly takes up page 70, the very next
Page 70.
page, very next page.
Yes.
Now, my lord, this order was challenged before the Honorable Court. Now, my lord, paragraph 3, my lord, may I read it? In my considered view, since the petitioner is the person responsible for the construction, he ought to have been given prior notice by the corporation before issuing the demolition order in terms of Section 177 of the Howrah Municipal Corporation Act 1980. The demolition order dated July 15, 2025 is set aside. The corporation shall be at liberty to initiate a de novo demolition proceeding after affording an opportunity of hearing to respondent number 9 and 10, comma, the petitioner and any other interested parties, if any. Till now, my lord, no proceedings have been initiated. Now, my lord, in the meantime, my lord, we applied for the electricity connection, which is at page 72.
That is rejected.
That has been rejected by page 75.
Page 75. Yes.
Yes. Now, my lord, over here, my lord, the ground for rejection is that pendency of the consideration before the Howrah Municipal Corporation.
Yes.
Now, I will kindly come, my lord, at page 69. The subject portion, my lord.
Yes.
Notice of self-demolition for unauthorized construction of ground floor to first floor. Deviation from sanction plan and second floor without sanction plan. Means from ground
The
floor
total
to
second floor will go and first and second floor
and
the deviation.
yes, man. Until and unless we get a clearance from the HMC, man. How can we give?
So you do one thing. I am passing an order directing the joint inspection by the CSE.
Well, in respect of, man, if my lord passes, man, I have to abide by.
Just a minute. And the municipal corporation, along with the plan, if the place where he wanted the electric connection, if it is coming under the deviation of the sanction plan or unauthorized construction, then you submit the report.
Manad, may I submit? Sir, I mean, second, Manad, may I submit? It happens to be a standalone building with G+2 construction.
Correct.
Manad, we will provide one what we do? We provide one supply. And at the ground floor, my lord, there is a meter box where we give the meters for the individual flats.
Correct.
Manad, in respect of the inspection, Manad, it is Manad, the HMC can do. We will only see, Manad, whether it is feasible and it is risk-free to give the.
That's why I am telling the inspection. They will give that with regard to the any unauthorized construction or deviation, which
then Manad,
where the petition is an occupation. If it is a deviation, there is no problem. If it is no deviation in occupation, then you have to submit whether that portion, any loop meter can be provided from the service line.
Then if they come up with the report, then after that we can do. Why
I want to expedite. So both go and I will both go and inspect. And if it is found that it is a deviation and illegal occupation, your report is not required. If it is found it is not illegal and he is an authorized occupant of the premises and the area is coming under the sanction plan, then you have to see whether the any loop.
No sanction plan is annexed, only
Yes,
the building permit is there.
Okay, let me see this. Yes.
Sir, they have issued that notice.
after our inquiry and investigation here, found that there is severe deviation outside. And these deviations may cause also the demolition of the portion of the building occupied also.
So how many persons are in occupation over there? How many persons are in occupation?
Again, now my only one thing, my lord. So far as the deviation and the another construction of the state code is always there.
That is no building
But
plan.
they were when a self demolition, my lord. They have defaulted. They should have demolished that portion.
Correct.
Now, without self demolishing this portion, they are coming that electricity connection will be given.
Correct.
That they are already defaulted under section 170.
Who are you?
But may I make a humble submission?
Who are you?
I am the person who has constructed. Now, my lord,
You want the electric connection.
my learned friend said,
Why you want? You are the. You are
but
the
I have put flats in over there as per my joint development agreement. Now, my lord, may I make one humble submission? My learned friend said that I didn't carry out
So
the
this
self.
is developer area which you want the electric
Yes.
connection.
Now, my lord, in respect of my learned friend said that I didn't carry out the self demolition order. That has already been set aside. So question of carrying out the demolition does not arise. Now, my lord, kindly see it was set aside on 24th of July. 5 months they did not took any steps. Now, my lord, here the corporation jumps up by coming and saying that we will inspect. Let them carry out the order passed by Justice Chondo. If I am unable to, they will not be able to satisfy this court. They will not be able to satisfy this court, my lord, there is any deviation. I candidly admitted before your lordship that there is one floor extra, but there is no deviation in respect of the G+1 floor.
This court is not only with regard to the deviation of any.
Yes, my lord.
Only this court is with regard to the your occupation which you want the electric connection.
G+1.
If how many connection you applied for?
One.
One connection.
So that if that portion which you want the electric connection, if it is a deviation, then we'll see to that. If the municipal authority has taken.
And only thing, let municipal authority file a report, after that we will take, so because my instruction, we have already inspected, and during inspection we've gathered from the local that there is a illegal construction, and
That is there.
let the municipal authority go and inspect. We will do it after that.
And my lord, in respect of the deviation is concerned, if this is the self-demolition notice, if I ought to have carried out this, then my lord, this would have reflected my nature and extent of deviation. Nothing is
That's
mentioned.
why if the report comes, automatically it will, what is the deviation with
Yes.
regard to your part?
Yes.
The court is not concerned with the other
My lord,
part.
they couldn't file any
Let they
report
come-
before the coordinate bench
Let
also.
they come the report before
Very
this
well,
court.
Very well.
The grievance of the petitioner in the present date application that the petitioner has applied for grant of electric connection, but the same was rejected by the CESC on the ground that the municipal corporation, Kolkata Municipal Corporation, Kolkata Howrah Municipal Corporation has issued notice of self demolition of unauthorized construction of ground floor to the first floor, deviation from sanction plan, and second floor without sanction plan. The counsel for the petition submitted the demolition notice issued by the Howrah Municipal Corporation was set aside by the coordinate bench of this court in WPA 16718 of 2025, dated 24th of July 2025, giving liberty to the municipal corporation for initial de novo demolition proceedings after affording an opportunity of clearance. He submitted that his court passed the order on July 2025, but till date the municipal corporation has not started any de novo proceeding for demolition of the alleged unauthorized construction. This court find counsel for the petition submitted the petition in which the petitioner intend to have electricity connection is not constructed of deviation of the sanction plan issued by the corporation. Full stop. In full stop. Learned counsel appearing for the CSC submit that CSC already inspected the premises, but it was informed that the building in question has been unauthorized constructed with building has been unauthorizedly constructed, and also there is a deviation of the sanction plan. And as said, the CSC has not provided the electric connection. The Howrah Municipal the learned advocate appearing for the Howrah Municipal Corporation submitted a 15 days time may be given so that the Howrah Municipal Corporation will visit the premises and inspect the premises and will ascertain whether the premises in which the petitioner intend to have electricity connection is having any deviation of the sanction plan, or whether the said premises is constructed unauthorized without any sanction. In view of the above, the municipal authorities are directed to inspect the premises of the petitioner after notice to the petitioner within a week from date, and if the petitioner received any notice, comma now I am fixing a date.
May I make one humble submission?
Otherwise they will say.
My lord will fix a date and time, my lord. The petitioners will be present.
Inspect the building in question, the premises in question where the petitioner intend to have the electric connection on 8th of December 2025 at 1 p.m. and the petitioner is directed to be present and to identify his occupation of the premises wherein the petitioner intend to have the electric connection, and the petitioner shall cooperate with the municipal authority for inspection of the premises in question. Full stop. After completion of the inspection, comma, the municipal corporation shall submit the report before this court on 11th of December 2025 after serving the copy to the learned counsel for the petitioner as well as the CSC.
My lord, one more prayer, my lord. If my lord may kindly please to clarify the earlier order dated 18th of September.
Let the matter appear on 15th of December 2025 under the same heading. The learned counsel for the CSC submit that in the order dated 18 September 2025, it is recorded that the report is filed and kept with the record, but there is no report filed by the CSC. Accordingly, it is stated that no report has been filed by the CSC.
Nor any direction was first earlier.
The inspection
in 11th you have to submit the report to them and returnable date on 15 December.
I'm grateful, my lord.
The CSC officials will also be present.
No, we are.
That report come.
My lord, item number 19, my lord, I am for the petitioner.
Yes.
Here, my lord, I have challenged the 100-point roster, my lord, on the last occasion, my lord. It was taken up when it was taken up by the coordinate bench, my lord, the AG was assured that they will come up with a solution because admittedly, my lord, there is some discrepancies. My lord, AG's presence is also necessary, my lord.
Yes, my lord. Here, my lord, I think there is no dispute. We found there is some latches in 100-point roster regarding the reservation of disabled person, my lord. But regarding come before your lordship with solution by learned advocate general, my lord, can it be taken up on Friday, my lord? Friday, basically, my lord, if it
come
is
with the correct, if there is any latches or there is any dispute, to correct with the correct list on that day.
For this, my lord, I think he needs to talk with the department. At least, my lord, all department involved in this issue, my lord.
Say, your lordship, what is the issue, my lord? Your lordship knows after the 2016 PWD Act, my lord, 4% seats are to be reserved. And it is an horizontal reservation. But my lord, what the 100-point roster has done for locomotive disability, 32nd vacancy has been reserved as PWD-SC. PWD-SC. What it means, unreserved locomotive cannot get the benefit. A person with differently abled, my lord. I stand corrected, my lord. My lord, that is an SC, 32nd vacancy marked as SC person with disabilities, my lord.
What happened, my lord, in
That
100
I have challenged that. If it is an horizontal,
But
it
the
should be
agenda-
unreserved.
What happened, 100-point roster, my lord? If we, my lord, divide it
Second,
with
and my lord,
20
the
vacancies.
women department,
Yes. 25 vacancies in the last block, my lord, there is no reservation. On the other hand, in the third block, my lord, there are two, my lord, reservation. This is basically the discrepancies.
How many posts? How many posts? Sanction posts are there?
No, my lord,
My lord,
it's not.
sanction.
They are not challenging any sanction post, any appointment, any my lord, nothing, my lord. They are challenging the my lord the latches in the 100-point roster.
100-point.
And my lord, interestingly, my lord, our department, that is Department of Women, Child Development and Social Welfare, has in fact supported us and wrote to the Labor Department that they have committed a mistake and that 32nd vacancy should be an unreserved one. That is also annexed.
That is at page 136.
35.
Read everything, my lord.
My lord,
But
page
I
136, if your lordship kindly reads last paragraph. Page 136.
First paragraph, my lord. দেখেছো আমি পড়েছি
তুমি তো প্রিপারেশনই আছে
But এটা solution একমাত্র sitting এত সোজা নয়. We have to rectify this.
And because of this, my lord, what is happening? We are all unreserved candidates. We are failing, unable to avail the benefit of reservation, my lord, as a person with disabilities.
32 and 42
Page
are the same
131 টা বার করো একটুখানি.
And my lord, this your lordship has gone to seen page 136. Now kindly come to page 131. My lord,
Here-
kindly see 32nd vacancy. It should be unreserved, but it is marked as SC.
Schedule caste. 12, 32, 42.
My lord.
Yes.
70. And 33.
Yes, my lord. In third block, there is two reservation, but in last block, my lord, there is no reservation.
And admittedly, it should be unreserved, the 32nd one for locomotive.
Then 42 is correct.
What is any
Only 32
otherwise others are correct, my lord.
Only 32 is the problem.
32 is the problem.
So you have added the scheduled caste persons.
Yes. Which is differing, my lord, other persons, it should be unreserved because it is horizontal.
Should be unreserved. Check it.
Yes, my lord. This is gazette notification. We need to sit with the department. So,
Correct.
my lord, I think a little bit time, my lord.
My lord, in the meantime, what is happening, my lord, everybody, recruitment authority, SSC or primary, are following this 100-point roster, and already one of our candidature has been rejected by the School Service Commission that you are not an SC candidate, so you will not get the benefit of this reservation. My lord, everything depends on this writ petition, my lord. So if it is on Friday, my lord, I have no problem. My lord, kindly take it up on Friday so that it can be solved, my lord. Otherwise,
Friday date আছে কি? Time আছে কি দেখো? Friday at 2 p.m.
my lord. Friday at 2 p.m.
As per the submission made by the council for the made on behalf of the Advocate General, the case is adjourned. Let the matter appear on 5th of December 2025 at 2 p.m.
Deeply
Next.
চেষ্টা খুব চেষ্টা করো।
Item number 20.
We could start with the matter, my lord. Here also learned advocate general is appearing, my lord. Can it be taken off Friday, my lord?
What is the matter? Why the
May I
advocate
just
general-
indicate to your lordship,
What you are challenged?
we have challenged the levy of facilitation fees for the movement of export consignment from India to Bangladesh through West Bengal. Well, several notifications have been issued by the state government, purportedly in the exercise of rule-making power, which is not so. And my lord, we are also there is an order already passed by the Honorable Division Bench taking up PIL matters, where my lord, the challenge was thrown at that stage. The PIL was dismissed, but on the ground for want of locus standi. but it was also leave was also granted to the aggrieved party to approach this honorable court by way of appropriate petition. A submission was advanced on behalf of the state by the learned Advocate General that this levy and this system is optional. And so, my lord, the interim order which we are now seeking is that just an enforcement of the, my lord, the submission made on behalf of the state for the time being. It has been specifically recorded in the order passed by the Honorable Division Bench. Division Bench order ta ache. Kindly take this order passed by the Honorable Division Bench disposing of the PIL. Kindly take, my lord, paragraph 4 of the Division Bench order. একটা copy সুমিতা আমাকে দরকার নেই
Annex করা আছে দাদা আপনার petition
না নেই বল
Annex করা
নেই kindly take, your lordship will find this queue management system is optional. So, my lord, all we want for the time being is that the stand taken by the state, my lord, state cannot take a different stand right now. So let it be optional for the time being.
My lord, this writ petition has been dismissed, my lord.
Yes.
On the point of locus standi, my lord.
Yes.
I don't think, my lord, any submission made in this writ petition, my lord, is, my lord, enforceable. That apart, my lord, kindly take this matter on Friday. My lord, that point of time, probably the writ petitioner challenging imposition of parking charges, my lord.
No.
Today is not a question
No,
of
it's
parking
not.
charges.
No.
This is a different type
No.
of
My learned,
government, my lord, to the person who are, my lord, transporting their goods from India to Bangladesh. My lord, here
my lord,
I see in their representation, my lord.
well, I appeared in the matter. I know what happened in the matter. My lord, it was the facilitation fee itself was under challenge.
They have to say something.
that I understand, my lord.
They are asking, my lord, then let it be, my lord. First, my lord, kindly hear my learned Advocate General, then my lord, my lord. I don't think the submission made in the matter where matter has been dismissed.
And when you will have
Friday, my lord?
Friday, both the matter, how it can be.
Then, my lord, kindly keep it on Monday, subject to election.
Yes, my lord.
Monday.
As per the prayer made on the
Advocate General submission.
Let the matter appear
Sin Mukherjee করেছে তার
on.
আমাকে কেন
My
দিচ্ছ?
lord, it is a very
On.
He says that the erstwhile Advocate General has made
I-
submission, not the present one.
On 8th of December, under the same heading.
Monday, your lordship has posted. Okay.
Grateful, my lord.
Yes, an urgent motion.
May I please your lordship? My lord, on the last occasion, my lord, lordship, my lord, directed to, my lord, serve, my lord, the non-appearing respondent since, my lord, the track report was not there. Was it, my lord's direction, my lord?
You're for the bank.
My lord, the respondents, my lord, non-appearing respondent have been served, and my lord, the track report is there. All of them have received, my lord.
Non-appearing respondent, what are the non-appearing respondent?
2, 3, 4, 5.
2, 3, 4, 5.
There were 4 months.
HDFC Bank officer in charge.
Each another police station and my lord, the GST commission.
Yes.
All of them have received it. My lord, track report is also there.
Yes.
The order was also, my lord.
What you have prayed for?
My lord, may I, my lord? My lord, my challenge, my lord, in this writ petition is twofold. My lord, one, my lord, what the respondent number 3 has done by issuing a notice under section 94 of the BNS, they has, my lord, directed to debit freeze my bank account, my lord, which, my lord, in my most respectful submission, they cannot do because section 94 doesn't give them that power, my lord. One. And second, my lord, in case, my lord, the dispute, my lord, so far as, my lord, the GST amount is concerned, it is 1,81,000. Now, my lord, my entire bank account has been debit freeze. Now, my lord, I cannot do my business. Now, my lord, that amount, my lord, I have stated that I didn't have any transaction that was a fraudulent, my lord, ITC that was transferred to my GST portal. Now, my lord, subsequently, my lord, I have reversed that also. Even, my lord, assuming the investigation is going on, by, my lord, the latest, my lord, judgment passed by the Rajasthan High Court, only the amount in dispute, my lord, that can be debit freezed and I can be allowed to, my lord, operate my bank account because more than amount is lying there. I cannot do my business. That's the current account, my lord. It's my business account. Well, if your lordship kindly takes up that judgment, my lord, it will also create a bill.
Where is the notice?
My lord. My lord, the notice is at page 19, my lord.
Yes.
This is, my lord, issued by the respondent number 3. Now, my lord, there is a FIR against one Siddhi Vinayak. I have nothing to do with that. They have made some fraud. Now, my lord, in course of the investigation, they have found, my lord, I'm not, my lord, wasting court's time reading, my lord, for the purpose of investigation. You are hereby directed through this notice to provide the following within 7 days from the receipt of the summons. CAF of the following account number, such and such. The second one belongs to me, my lord. 5020012501755. This is my bank account. I am only concerned with this account, my lord.
Which one? Which one?
My lord,
50200.
Item number 1, second bank account number.
Okay.
That is, my lord, I am only concerned, not with other, my lord.
Yes.
Now, my lord, from this, now, my lord, on the last, at the last line, it says, kindly load the, now you are, point number 3, you are either directed to debit freeze the above mentioned account. Now, my lord, in my most respectful submission, if your lordship kindly takes up section 94 of the BNS, it doesn't give him that power, my lord. Well, 94 says that he can summon for documents, for investigation, whatever document, electronic, non-electronic, whatever documents he can summon for. But that doesn't give him the power to debit freeze my bank account. Now, Mala, he doesn't.
Section 94?
Section 94, Mala. Because Lordship will see, Mala, this notice is
BNS.
under section 94.
BNS.
BNS. Starts with summons to produce document. Has your lordship got it, my lord?
Yes, sir.
Says, whenever any court or any officer in charge of a police station considers that the production of any document, electronic communication, including communication devices which is likely to contain digital evidence or other thing is necessary or desirable for the purpose of any investigation, inquiry, trial or other proceedings under this Sanhita by or before such court or officer, such court may issue a summons or such officer may by a written order either in physical form or in electronic form require the person whose possession or power such document or thing is believed to be to attend and produce it or to produce it and the time and place stated in the summon or order.
Yes.
Subsection 2. Any person required answer merely to produce organ thing shall be deemed to have complied with the requisition if he causes such document thing to be produced instead of attending personally to produce the same.
Correct.
Nothing in this section shall deem to be affect section 129, 130 of the Bharatiya Sakho.
You are appearing for bank.
Now, my lord, from this notice, my lord, lordship will not find, my lord, what are the allegations against me. First of all, there is no FIR against me. Now, if your lordship kindly comes to page 25. Now, my lord, this is the notice issued by the respondent number 2. Here, my lord, they spells out what has actually happened. Addressed to me, my lord. I'm reading, my lord. In an ongoing investigation of Messrs. Siddhi Vinayak Trade Merchants undertaken by this office, it has been noticed that the said firm has passed input tax credit to your firm amounting to 1,83,934.
Which page? Which page?
Page 25, my lord, of the writ application.
Yes.
Here, my lord, the GST commissioner in this notice, he spells out. Why, my lord? I was, my lord, called for to produce the documents. In an ongoing investigation of Messrs. Siddhi Vinayak Trade Merchants undertaken by this office, it has been noticed that the said firm has passed the input tax credit to your firm amounting to rupees 1,83,934.80. In this regard, you are requested to submit the following documents. Now, my lord, following documents was called for. Now, my lord, I had replied to this notice. If your lordship kindly comes to page 28.
I have stated in that notice categorically, my lord, that I never had any transaction. So question of producing the invoice doesn't arise. My lord, it was an absolute fraudulent transaction done by that Siddhivinayak. I have nothing to do with it. Now, my lord, apart from that, if your lordship kindly comes to page 31, apart from my reply, immediately thereafter, my lord, running page 31 of the writ application.
Yes.
My lord, I reversed that input tax credit that was, my lord, fraudulently, my lord, given to my GST account. I have reversed that. Now, my lord,
No, so how, who has paid this amount?
by that Siddhivinayak.
So how you revert?
Through the GST portal. It has been stated, my lord, reasons, because it is form GST DRC 83. It's been all done online, my lord.
In whose account you were revert?
My lord?
In whose account the amount was reverted back?
He must be knowing it, my lord, because I did not know. There was no, my lord, transaction with me. They have just done it. They have just sent that. Investigation is going on. I have reversed that.
Correct.
Now, my lord, what I was suggesting, my lord, now, my lord, what they have done, they have, my lord, freeze my entire bank account. Amount involved, my lord, even, my lord, is 1,83,000 and odd.
Correct.
So, my lord, by that recent, my lord, Rajasthan High Court judgment, my lord, if your lordship kindly takes up that judgment once, where, my lord, the Rajasthan High Court had held.
Reference.
Sorry. Learned counsel, my lord, here, my lord, it was a cyber crime case. Now, my lord, if your lordship kindly takes up from paragraph 4 onwards. Per contra, learned counsel for the respondent bank submits that the bank account of the petitioner has been freezed in pursuant of the complaint number such and such and such and such. Learned counsel for the bank submits till the matter is pending investigation, the bank account of the petitioner may not be closed and he may be directed not to discontinue the bank account until the investigation is completed. Learned counsel for the petitioner is agreeable. In view, the submission may be this writ petition is disposed with a direction to the respondent bank to defreeze the bank account number such and such, and he may be allowed to operate the transaction in his bank account, freezing only the amount of rupees such and such which is allegedly involved in the fraudulent transaction. So, my lord, here, my lord, so far my writ petition is concerned, my lord, if your lordship once again comes to page 25. The fraudulent transaction which reflects in my GST portal, my lord, has been stated by the GST commissioner is 1,83,934.80. My lord, let the bank debit freeze that account and remaining account, my lord, I may be allowed to, my lord, continue because I have to do my business, my lord. I cannot pay salary to my staffs. Even, my lord, I cannot run my business, my lord. My entire bank account, that's a current account, my lord.
So with regard to this letter 25, have you given the report?
Malad,
Submitted report.
I have given Malad the reply, Malad. I shown you lordship, Malad, page 28.
Yes.
I stated that categorically. I cannot give the because there is no transaction. That was a fraudulent transaction. It was transferred fraudulently to my GST portal. And Malad, that investigation perhaps is still going on. That is why, Malad, in order to show my bona fide, I am still saying that okay, 1,83,000 and odd maybe
yes, what is the
and I may be allowed to continue with my remaining bank account.
What is your contents?
And we have just acted upon on the notice of annexure P2, which they have annexed. The notice, yes, technically in 94 they cannot do it, but if you come to annexure P3, that is a notice which was sent to them. It shows that they are required for the purpose of investigation. They might.
Malad, I am ready and willing to, Malad, cooperate.
Let me finish. I have not interjected. Malad, we act upon the instruction of the investing authority. We have nothing to do with the petitioner, neither with the investing authority. In terms of the notice of 94, it might be 106, which would be more appropriate, but a technical thing. But if Malad comes to page number 20A and it's a P3, which the petitioner has not shown to your lordship, is that they are required for the purpose of investigation. Now, I suggest that the FIR should be brought into the record. what is the actual amount.
But the authorities are not
And the reply which they have sent to the GST commissioner, not to the investigations, that will clear the cloud, whether at all they are required for, whether they have appeared in as per this notice, or they have complied this notice, or they have been exempted from appearing for this notice. Or they are no more required in the investigation.
Perhaps lawsuit
Probably that will clear the cloud whether this account still requires to be freezed or not. It should come from the investigating agency.
I asked this question to myself, why the entire account has to be freezed, lawsuit kindly comes to page 21 once.
Yes, petitioner has filed the present application praying for the freezing of the bank account of the petitioner lying with the HDFC Bank Manikala branch, being current account number 5250 20000 20000 125 20 175 175. Counsel for the petition submit that in terms of the notice issued by the officer in charge PS Itanagar, the respondent number 1 bank has freezed the account of the petitioner. No, respondent number 4 and 5 have freezed the account of the petitioner. Police. Counsel for the petition submit that the Assistant Commissioner CGST and CX Itanagar had issued a notice to the petitioner directing the petitioner, informing the petitioner that investigation of Messrs. Siddhi Vinayak Trade Merchants is going on, and it was noticed that an amount of rupees 1,83,934.80 has been illegally transferred in the account of the petitioner. Counsel for the petitioner submit that the petitioner has given reply to the investigating agency, but the petitioner also reverted back the amount of rupees 1,83,934 in the account of the Siddhi Vinayak, but till the bank has freezed the bank account of the petitioner, due to which the petitioner is not in a position to operate the bank account, which is the business current account of the petitioner. This court find that the petitioner has issued the notices upon the other respondents, particularly the respondent number 3 and respondent number 6, that is the officer in charge Itanagar Police Station and Itanagar Police Station, district Pampure, PAPUMPARE, Arunachal Pradesh 791111, and officer in charge Bartulla BURTUL Police Station 1 Raja Raj Krishna Raj Street, Krishna Street, Kolkata. In spite of receipt of summons, none appears on behalf of the respondent number 5, 3 and 6. This court find that the appearance of this respondent number 3 and 6 is necessary for disposing of the present date application. Accordingly, the respondent number 3, that is the officer in charge Itanagar Police Station, district Papu Mampre, Arunachal Pradesh, and the officer in charge Bartulla Police Station 1 Raja Raj Krishna Street, Kolkata, are directed to appear before this court in person along with the case diary of the present case and to submit a report before this court. Submit a detailed report before this court in seal cover. Within a period of 2 weeks from date, let the matter appear on 17th of December 2025 under the heading adjourn motion at the top. Full stop. Adjourn motion at the top. The petition is directed to communicate this order. The petitioner, the office of the Registrar General of this court is directed to communicate this order to the respondent number 3 and 6 for compliance.
In the
The
meantime,
petition is also directed to communicate the same to the respondent number 3 and 6 and to file affidavit of service on the next date.
in the meantime, my lord, let them, my lord, keep that 1,80,000. But I
Come,
already
let-
allowed, my lord, I cannot, my lord, run
For
my-
17 days you have waited, let come on 17.
Well, till, my lord, till 17 December, Lakshmi will kindly allow me, Lakshmi will kindly direct them, my lord, to allow me to do my business, keeping that 1,83,000. I'm not saying that I will run away with, and I will not
The
close that account. That is my business. account.
Counsel for the
Lakshmi will
petition
kindly
submit that
appreciate, my lord.
the disputed amount is rupees 1,83,000.
My lord, I tell you, Lordship,
1,83,000.
1,83,934.80.
But the bank has freezed the total. Bank has freezed the total account of the petitioner.
And the investigating agency has not indicated the amount.
Petitioner. Thus, the petitioner prays for allowing the
I
petitioner
do
to
not
operate the
understand
bank
why-
account by keeping
my lord, football
the
purpose of
amount of
bank will be
1,000
served by
File a read on the
bank.
next.
Sir, it is my money.
934
You will file a read
as account
on the
freeze.
next day of the
But
bank.
this court find that
Of course,
it
it is my money, sir.
not proper to allow the petitioner to operate the bank account unless the police report is come on record.
My lord, Lordship has,
It come on record.
Lordship has directed, my lord, the bank. My Lordship has.
No, I am not directed. Let the police report come. I have recorded your submission.
My lord, it on 17 December. My lord, let it, my lord, appear at the, my Lordship will kindly appreciate my predicament. I cannot run.
That at the top, let come on 17. Let the police officers come with the report.
I shall serve notice, or Lordship has directed the officer.
I already office and you also saw.
My lord, I'm grateful.
Before your
Yes.
lordship takes up the original side, lordship, item 23,
Ah.
your lordship may kindly take it up anytime tomorrow, lordship.
Yes, tomorrow it will come up.
Adoption by the CWC.
It will be tomorrow only. ये तो एफिडेविट रखो नहीं सुनेगा no appellate sites.
My lord, may I have my lord's leave to mention, my lord, item 38 of my lord's list. My lord, this was a witness action. It's a specially assigned suit. My lord, this was fixed at 3:45 p.m. today. My lord, since because of the change in determination, my lord, the time tag has gone. I'm praying, my lord, if the matter could be taken up any day, if a time could be fixed for witness action.
January.
I appreciate, my lord, any day because it's a witness action. That's the only reason I'm praying, my lord. Item 38,
Who is
any
the other side?
other side, my lord, Miss Shomali Mukhopadhyay was appearing. Defendant's witness was being
It's
cross-examined.
going on. Na cross examination going
Yes,
on.
my lord. Only the time tag has gone. I'm praying for any day. I'll intimate again, my lord, if any day can be fixed.
कब होएगा कुछ है कोई डेट है 5th January. Item number 38. The counsel for the plaintiff submit that the case is at the stage of witness action for cross examination of
the
the
defendant's witness.
defendant witness.
My lord, examination chief is about to conclude. Examination chief, last order.
And the examination chief is about to complete. Accordingly, prays for fixing a specific date and time so that the defendant can examine the witness. In view of the submission made by the counsel for the plaintiff, let the matter appear on 5th of January, 3 p.m. for witness action.
Deeply obliged. And I'll intimate also. Obliged.
Off and complete. The record will be filed.
Yes.
I'm a person, my case 779 has been listed, but it is hovering on 40, 60 numbers and 200 numbers. I just want a fixed date on 12 so that come out with this as quickly on.
कौन सा मैटर देखो Today is it fixed today?
I don't.
It is not in the. Who is for that? You are appearing for your plaintiff in person. In person. And what about the other? Who is for the other defendants?
The other defendants, I've informed them, I've given them served them, and the affidavit service is ready with me. If you inform me, I'll serve the report.
So why you want the upgradation?
Hovering means last 1 month it's creating worry.
It will come up tomorrow.
Not tomorrow, sir, on 12th, sir.
Okay, 12th में
Again,
12
I've got other things.
12 तारीख को रखेंगे.
On a fixed date on 12th, sir.
अच्छा, 12th is a Friday.
Friday.
12th Friday. It is a non-commercial or commercial?
So if it's
Read
coming
matter.
tomorrow, it's okay, fine.
Then 11th.
Okay, fine, sir.
11th.
Much honored, sir. Obliged.
Yes. The respondent number 7 is directed to pay 50% of the total principal dues of rupees 3,68,194 and rupees 1,64,654 being the additional security deposit and reconnection charge of 600 to the CSC Limited within 24 hours from date. The remaining balance of 50%, that is 3,68,194 of the total principal dues shall be paid in 2 equal installments within 45 days from date. The respondent number shall continue to pay the monthly electrical charges to the CSC Limited as per the bill raised by the CSC Limited without any default. If the CSC Limited is found that the respondent number 7 is in default of paying the current monthly electrical charges as well as the 50% of the total principal dues, the CSC shall be at liberty to disconnect the HT commercial connection of the respondent number 7. As regard the outstanding due of the petitioner is concerned, the first writ petition, this court has not gone into the disputed question of fact. It is the civil suit is pending, but the respondent number 7 is directed immediately when the respondent number 7 electric connection is restored within 24 hours. She will restore the electric connection of the petitioner and the petitioners are continuous pay the electrical charges to the. And with regard to the other dues, that will be decided by the civil court.
Hands are not empty now.
Great.
My lord, my lord.
My lord, I'm appearing for respondent number 3, my lord.
My name has not been recorded in 27/11.
अरे उसका नाम ले लो, जजमेंट में लिख दे किसके लिए ले लो, तो पिन कर, तो पिन कर.
Your Lordship, I beg to appear for the petitioner. I have written instruction that the petitioner does not wish to proceed with the instant matter. I appear for the respondent number
Which
2, Your
one? Which
Lordship.
one?
3 and 4,
My
both.
lord,
Both.
Yes,
my
Your Lordship.
lord, I'm appearing for respondent number 3.
The counsel for the petitioner has handed over the written instructions from the petitioner dated 14th of November 2025, wherein the petitioner has instructed the learned advocate on record that for taking appropriate steps for review of the present review application, for withdrawal of the present review application, being review number 38 of 2025. In view of the submission, in view of the communication dated 14 November 2024, 2025, the counsel for the petitioner pays for withdrawal of the review application. Consider the submission made by the counsel for the petitioner. Review number 38 of 2025 is dismissed as withdrawn. Interim order, if any, stand vacated. The written instruction dated 14 November 2025 be kept with the record. Same, 38, 39. 3 and 4 both.
Obliged, my lord.
Therefore, Your Lordship.
Next.
May it please your question. Beg to appear on behalf of
Lord,
the
on a
petitioner.
lighter note,
yes,
my lord, he is complaining that I have now appeared in the matter. But my lord, I must tell your lordships, my lord, I won't take more than 5 minutes. My lord, from your lordship's last order, my lord, I'm not seeking any adjournment or anything on that ground. Just to inform your lordships, my lord, the matters in the list today in the Supreme Court, item 58 or something is going
No,
on.
63 is there, item 58 is running
It is
off.
going on, my lord. So, my lord, I'm just.
We are on
so that-
caveat already.
Yes, they have, my lord, from the last order. But my lord, I have only one very simple point. My lord, kindly have a look at your lordship's order. I'm not, my lord, going to come and ask for time to file or anything. But my lord, one jurisdictional issue, my lord, your lordship will kindly decide, kindly take the order of 17th April 2025, which is an annexure to my lord GN 5 at page 29.
Yes.
My lord, kindly have a look at para 8 at page 30. My lord, the issues, my lord, your lordships have framed. My lord, paragraph 8, kindly take the first issue.
Yes.
My lord, whether the election is in correct form, election petition is in correct form and maintainable. Now, my lord, just consider two provisions of the Act. My lord, kindly take the Act, my lord, section 81. Because, my lord, the matter can end here and now, my lord. Kindly, my lord, take subsection 1, my lord.
I have just a preliminary objection to take regarding their application. They have now filed the same petitioner, the same respondent number 6, my lord. Now, my lord, upon amendment of the cause title, he is the respondent number 5. But the person has now filed another GA. It's essentially seeking rejection of plaint. My lord, as I understand from chapter 6, my lord, if I read rule 3 along with rule 11, item number 10, it has to be done by way of, my lord, a master summons. Here, my lord, it is just a notice of motion, my lord. I do not know how the department accepted it, my lord. But kindly takes, my lord, the original side rules.
Okay, let Mr. Mukherjee
Yes, my
complete.
lord, that can always.
Let
My
Mr.
lord. My lord, kindly take, my lord, section 81,
Yes.
1, my lord. An election petition calling in question any election may be presented on one or more grounds specified in subsection 1 of section 100 and section 101 to the High Court. Now, kindly mark the words, by any candidate at such election or any elector. So, my lord, the section, my lord, and then, my lord, the rest. Now, my lord, what is important is the presentation has to be by the candidate. Now, my lord, kindly come to, my lord, section, my lord, 84. Sorry, my lord. Kindly come to section, my lord, 86, my lord. Subsection 1.
Yes.
My lord, kindly take 86.1. The High Court shall dismiss an election petition which does not comply with the provisions of section 81 or section 82 or section 117. Now, my lord, in this case, there is no endorsement in the fiat that it was presented, my lord, by the candidate or by the advocate in the presence of the candidate. Number one. Number two, my lord, there is no order, my lord, on record, my lord, recording, my lord, the presence of the candidate, my lord, at the time of, my lord, moving of the election petition. Now, my lord, this is a mandatory requirement, and, my lord, the Supreme Court has held, my lord, that if this is not done, my lord, then, my lord, the petition has to be dismissed.
Correct.
Kindly take, my lord, 2009, 8 Supreme Court cases, 736.
2009, 8 Supreme Court cases, page 736. What a side note, you have to note. Thank you.
My lord, kindly take, my lord, paragraph 14 once. My lord, a close look at section 81 reveals that the two remaining subsections after the amendment of so-and-so deal with two distinct but subsection 1 deals with necessary requirements of any petition challenging an election, and subsection 3 deals with additional requirements. Subsection 1 has 5 components. Kindly take 2. My lord, the petition must be presented by the petitioner. Then, my lord, after, my lord, so I am, my lord, only complaining of this because there is no endorsement to the effect that it was presented, my lord, by, my lord, the petitioner, or in the presence of the petitioner by her advocate. Then, my lord, therefore, all these 5 requirements are extremely specific and clear. This inference is further strengthened by 86.1, which provides that the High Court shall dismiss an election petition which does not comply with the provisions of 81. Then, my lord, this court on previous occasions had the chance to interpret, my lord, this is Limitation Act, my lord, all that, special, my lord. Then kindly come to 19. Para 19 to 25, my lord. Kindly see. One can discern the reason why the petition is required to be presented by the petitioner personally. An election petition is a serious matter with a variety of consequences. Since such a petition may lead to the vitiation of a democratic process, any procedure provided by an election statute must be read strictly. Therefore, the legislature has provided that the petition must be presented by the petitioner himself, so that at the time of presentation, the High Court may make preliminary verification which ensures that petition is neither frivolous nor vexatious. In this context, earlier decisions of this court regarding interpretation of 81 must be understood, and Shivsadan Singh was a case where, my lord, in form, my lord, it was filed, my lord, by the advocate. But admittedly, my lord, the presence of, my lord, the petitioner was, my lord, noted. And, my lord, kindly see, my lord, the quote from there, my lord, of Shivsadan Singh, my lord, paragraph 4, my lord, which is quoted in para 20, the last line of that, last sentence. Therefore, in substance, though not in form, it was presented by the petitioner himself. Hence, the requirement of law was fully satisfied. Then, my lord, kindly come to 21. It is to be noted that in Shivsadan Singh, it is not in dispute that the petition was presented to the registry in the immediate presence of the petitioner. In other words, the officer authorized by the High Court had an opportunity to verify him, but in the case on hand, admittedly, it was presented only by the advocate and the petitioners were not present before the registrar. In view of this, same decision is not helpful. This is because petitioner therein had in substance complied with the provision. Then, my lord, para 24. The challenge to an election is a serious matter. The object of presenting an election petition by a candidate or elector is to ensure genuineness and to curtail vexatious litigation. If we consider subsection 1 along with other provisions in 2 and 3, the object and intent of the legislature is that the provision of 81(1) is to be strictly adhered to and complied with. In view of the endorsement, there has to be an endorsement here, my lord, by the registrar that the election petition was presented only by an advocate and not by the election petitioners. We accept the reasoning of the High Court in dismissing the election petition. We further hold that as per subsection 1 of section 81, an election petition is to be presented by any candidate or elector relating to the election personally to the authorized officer of the High Court, and failure to adhere to such course would be contrary to the said provision, and in that event, election petition is liable to be dismissed on the ground of improper. Now, my lord, may I answer my learned friend's question also? My learned friend is right. If it was an Order 7, Rule 11, it might be in the nature of that. But, my lord, in an Order 7, Rule 11, what is examined are the statements in the plaint. So, my lord, what would be examined are the statements in the petition. Here we are concerned with the presentation of the plaint and presentation, my lord, of the petition. That I can bring, my lord, to the notice of the court, my lord, even without an application. And your lordship's aware, my lord, now the Supreme Court has also held, my lord, your lordship's dealt with, my lord, in Yamini Manohar, my lord, that, my lord, even without there being an application, orally, my lord, court can examine, my lord, its own, on an oral prayer, court can examine, my lord, its own jurisdiction. And, my lord, your lordships quite rightly have framed, my lord, maintainability as the first issue. My lord, my lord, this, so, my lord, this goes to the root of the matter. Your lordships, my lord, will examine, my lord, whether there is an endorsement. If there's none, that's the end of the matter. Because they have to prove, my lord, that, my lord, it was, my lord, presented before the registrar. And this proof, my lord, is not of the case, my lord, in, my lord, the, my lord, election petition, but, my lord, proof by endorsement that, my lord, it was presented, or by an order of court recording the presence of the petitioner at the time of initiation.
Yes.
My lord, those are my submissions.
But I'll just
May I have your lordship's kind leave, my lord? I stuck to the time, my lord, I said.
Expressing gratitude to my esteemed senior friend, my lord, I'll just, my lord, be responding to his queries. My lord, first of all, my lord, in terms of, my lord, the submissions made, it has been admitted it is not an application under Order 7, Rule 11, but an application of special nature filed under, my lord, the Representation of People's Act. So, my lord, here the moot point that has been raised is regarding presentation. Now, what has not been placed before your lordship are, my lord, the rules which are, my lord, regulating this procedure. Rule 20 clearly provides. Now, here, my lord, in the petition, the case was made out as if, my lord, the petition had to be presented before the honorable judge taking up this election petition, and the party has to be present in person. But, my lord, Rule 20 implicitly makes it clear, my lord. Yes. ফাইলে এরকম ওই ফটোকপির একটা ভার্সন আছে।
মোটা হয়ে গেছে। Dealing with these bulky files, now in the appellate side, I find there is nothing in the record.
Well, this is an application, I reiterate, for the sake of prolixity of a special nature. Rule 20.
Yes.
Rule 20 states, page 8, my lord, of the rules. Upon an election petition by any candidate or by an election relating to an election being presented in accordance with the provisions of the Act, these rules before the registrar original site, High Court at Calcutta, within the times prescribed by subsection 1 of section 81 of the Act, such petition shall be deemed to have been presented before the High Court at Calcutta under section 81 of the Act. Now, my lord, the Act and the rules contemplates of, my lord, 3 stages. First is, my lord, presentation, followed by scrutiny, and thereafter registration. Whereafter, my lord, it is placed before the honorable judge taking up election matters. Where, my lord, that is, my lord, rules, my lord, kindly take Rule 23, page 10. First is presentation, then registration. After registration of the election petition, the registrar original site shall cause the petition to be scrutinized according to the provisions of section 81, 83, 84, and 117 of the Act, as well as these rules, and shall submit a report of such scrutiny for directions of the judge. The matter shall appear in the daily cause list of the judge within 2 days after registration, as aforesaid, and thereafter on such dates as ordered by the honorable judge.
Yes.
Thereafter, my lord, Rule 24, if the judge is satisfied that the election petition is not liable to be dismissed under subsection 1 of section 86 of the Act, he shall direct issue of notice to each of the respondents to be sent per registered post with acknowledgement due. So, my lord, these are the stages. Now, my lord, kindly appreciate. First is, my lord, presentation before the registrar, High Court, Calcutta, not before the judge concerned. This is one. Second is, my lord, the report has to be placed, my lord, on record, which is to be considered. That is, my lord, the first step, the stepping stone for initiation of, my lord, action under the election laws, my lord. So, my lord, this is at a stage prior to service being directed. It is a matter by and between, my lord, the department and the honorable judge taking up the matters. Now, here also, my lord, 2009-8 Supreme Court cases, my lord, which was cited by Mr. Mukherjee. Now, here also, my lord, the registry had put up an objection. The registry, the facts, I was just looking at the facts. Here, my lord, the para 1, the first para, and the fourth para, it states about an objection going from the registry. And the honorable judge accepted that and dismissed on the basis of the report. That is, my lord, the report under Rule 23. 23 though.
Rule 23.
That is the, yes. Yes. Now, my lord, kindly takes your lordship's order dated 31st of July, 2024. That is the first order. My lord had considered the report, and upon being satisfied, my lord, thereafter directed steps to be taken under Rule 24.
31st of July.
31st of July. Orderটা দেখো। কি নেই? আমার এটা দে, ট্যাবটা দে। এই পিটিশন হার্ড কপিটা দে। হার্ড কপিটা দে। না, আমাকে সফট কপি দিয়েছে। वो 31 जुलाई तो अपने एनेक्स नहीं होते ना।
ये मतलब रिपोर्ट है क्या, शुरू वाला रिपोर्ट है? 18 जुलाई का रिपोर्ट, 18 जुलाई।
I'll just place the order. Yes, yes.
Order is here.
My lord.
The order is at page 14.
Which one?
Order. 31st July order is at page 14 of the application.
Hard copy do not.
Refuse করেছি।
No, no, refuse করেনি। তাই নিতে soft copy পেলাম কেন?
24.
Page কত? 14।
There is reference of a report of 18th of July, my lord.
Yes,
His
yes, yes,
lordship order.
yes, yes. First contention is, my lord, it is essentially by and between the department and the court, where, my lord, the parties, because that stage does not arise. They are trying to reopen a stage which has already been crossed upon satisfaction. There is recording of satisfaction, 31st July, on the basis of the report dated 18 July. If the report states that the petitioner has presented it, their contention initially was in another matter also. They are arguing another election petition before Justice Shugato Mojumdar. They are arguing that no, the petitioner has to come physically and present it to the honorable judge concerned. That is presentation. There I had shown, my lord, rule 20. They said then, my lord, they should file an affidavit.
नहीं, ये तो वहाँ का डिपार्टमेंट, हम लोग का डिपार्टमेंट का रिपोर्ट। 18 जुलाई, ये तो सब्सिक्वेंट है।
This is a scrutiny report in terms of Rule 23. So let's waiting. And we kindly, my lord, see, my lord, if it records compliance of section 81(1) of the RP Act. If that is there,
yes,
my lord, then kindly, my lord, read it with para 7 of their petition, of their application. GA5. Their case is furthermore, there is page 8, my lord.
yes.
Their case is furthermore, there is nothing on record to show that the petitioner was also present in person before the registrar original site and/or the election petition was presented in compliance with the Act and rules framed thereunder. Even the video titled 31st July 2025, court number 38, live streaming of court proceedings, as available on the official YouTube channel of the High Court at Calcutta, clearly shows that the petitioner was not personally present before this honorable court at the time when the election petition was being presented. So it's on a complete misconception. But rather, my lord, it's a deliberate misconception to delay, my lord, to procrastinate the proceedings, my lord, the disposal of the election petition. He could have jolly well taken this point in GA3. He did not. He tried his luck. Now he has filed an SLP against that. Now, my lord, immediately this application.
Yes.
And if they are so concerned about the rules, about the technicalities, my lord, since, my lord, my esteemed senior friend, my lord, appearing on behalf of the applicant, or rather the frivolous applicant, I will say, my lord, submitted that this is not essentially an application under Order 7, Rule 11, but a special application, my lord, under the election laws, but kindly takes Rule 19. Insofar as presentation of election petitions are concerned, it has to be presented before the registrar or any person authorized. Rule 19 speaks about applications. Applications makes it, my lord, implicit. It has to be presented before the concerned honorable judge, and the party has to be present in person. A copy of every application made by any party to the election proceeding or by any person desirous of being made a respondent, and a copy of the statement and particulars of notice referred to under proviso to subsection 1 of section 97, recrimination petition, that is, my lord, in the form of an application as prescribed to Rule 10 shall be served on the other party or parties to the proceedings, or his or her, their advocate or advocates, if any, before any such application or notice is presented to and moved before the judge. So it has to be presented to and moved before the honorable judge. My question is, my lord, I am, my lord, adopting their ground. Where is the person, my lord? Where is this Miraj Molla, my lord? It has not been presented, my lord, in terms of Rule 19. And that apart, my lord, I will be renewing, my lord, my initial submission. First is, my lord, it has to be done by way of a master summons, my lord. Rule 3, read with Rule 11, 10, serial number 10.
Rule 3.
Read with Rule 11, serial entry number 10 of the original side rules, my lord. But it's chapter 6, my lord. Rule 3, read with 11, entry number 10. Yes.
Entry number?
Entry number 10, my lord. I'll just read out the rules, my lord. Rule, my lord. Rule 3 prescribes the mode of proceeding in chambers on any application which may be made ex parte shall, except with where otherwise ordered or prescribed, be by petition, or where such notice is required to be given, shall, unless otherwise ordered or prescribed, be by summons. Such summons shall be prepared by the party obtaining it or by his advocate acting on the original side, and be signed by the registrar or master. Where affidavits are intended to be used, notice thereof shall be endorsed on the summons. It kindly takes Rule 11. Speaks about, my lord, the business to be disposed of in chambers by a judge. States that the business to be disposed of in chambers by a judge shall consist of the following matters, in addition to matters which are under any other rule or by statute may be disposed of in chambers. Entry 10 speaks about, my lord, the admission and rejection of plaints. But I just wonder, my lord, how the department accepted it, my lord. So, my lord, I will just be garnishing, my lord, my submissions by saying, first of all, my lord, this is a frivolous petition which has been filed to prejudice, my lord, the disposal of the election petition. He could have taken this point in GA3. He chose not to. He had taken a calculated chance upon dismissal, my lord. Now this application has been filed. First of all, this application is not in form. It has to be done by way of a master summons. Read with Rule 19. He is not presenting it personally before the honorable judge, which has to be done in case of applications. Third is, my lord, he is trying to espouse a cause which is essentially and strictly by and between the department and the honorable judge, because the stage contemplated of in terms of the election rules, Rule 20, read with Rules 23 and 24, are at a stage before direction of service. There has to be a satisfaction which has to be recorded in terms of Rule 23, the report, the scrutiny report, which has to be placed before the honorable judge. Rule 24 comes thereafter. The honorable judge applies his mind and thereafter passes further orders. Now they are trying to retract, go back in time and do something which they are otherwise prevented from doing, my lord. The judgment also, my lord, I am relying on their judgment, the one they cited to show, my lord, that there also the objection was put up by the registry. It was not by any of the candidates or respondents, my lord. So, my lord, on a holistic consideration of the fact situation, my lord, this frivolous application ought to be dismissed, my lord, in limine, and my lord, I will be praying for some exemplary costs, my lord. Grateful to your lordship.
Before he ends,
My lord, I am being led by
before
Mr.
he ends, but I've just come across, if your lordship permits me,
Mr. Mukherjee.
There are a couple of orders of this honorable court, where presentation has been done of election petitions and what orders are passed by learned honorable judges, may I just rely on them and can hand over to them where specifically says orders of presentation, presentation, how presentation is recorded in lordship's orders, that it is presented by the petitioners, that is a general norm, if your lordship kindly allows me, না না দেখো আমাকে দেখাও এক একটা করে দেখিয়ে দাও কোথায় দেখাও.
Oh, he is referring to Mamata Banerjee versus Shubhendu Adhikari, where, my lord, initially, my lord, they had appeared, then they had taken the point before the honorable judge that the honorable judge had personal interest, he could not take up the matter, etc., etc. Thereafter, my lord, they were slapped with, my lord, a cost of 5 lakh rupees, my lord. And there, my lord, this point was never agitated. Rule 20 was never agitated.
Let's show me.
দাও আমি দেখতে পাচ্ছি না এটা কোথায় কোথায়
Mr. Ray,
yes,
what is the object of appearing of the person in petitioner in person at the time presentation of the plate?
the
What is the object?
the object
What you, as per your
this is my personal opinion, if your lordship wants,
the your submission, the petitioner was not present in person, so that's why the presentation of plaintiff is not void and the suit is to be dismissed. This is the
my case is more on the basis of the judgment of the Supreme Court.
Correct.
So
what is the object of the present appearing a person presently?
Should be of the court on the date when it is presented, because there is a time period which your lordship has also found that time periods are supposed to be mandatory in nature,
Para 24.
In para 24,
of 2009 judgment.
Genuineness and to curtail vexatious litigation.
Para 24.
That is a genuine petition and not subsequently someone coming in and doing the needful,
Para 24.
This is also there, if your lordship finds in 2009.
Judgment.
The judgment which Mr. Mukherjee just now, my lord, handed.
They're referring to 2009-8 SCC, page 736.
Para 24.
24 is
এটা প্লেস করে
object of present here.
Yes.
আচ্ছা
The object of presenting the application
candidate
to ensure the
ensure genuineness and to curtail vexatious litigation.
Correct.
If we consider subsection 1 along with the other provisions, the object and intent of the legislation, the provisions of 181(1) is to be strictly adhered to and complied with.
Correct.
And Malad will kindly see paragraph 19, Malad.
I was not present before the Honorable Court on 31st of July. I presented the petition before the registry. That is my case.
And presentation is
yes.
But one can discern the reason why the petition is required to be presented by the petitioner personally. An election petition is a serious matter with a variety of consequences. Since such a petition may lead to a vitiation of democratic process, any procedure provided by an election statute must be read strictly. Therefore, the legislature provided the petition must be presented by the petitioner himself, so that at the time of presentation, the High Court may make preliminary verification to ensure that the petition is neither frivolous nor vexatious. So the court will also have a right at that point of time, which I believe, my lord, it's not said in something that even your lordship can question at that point of time.
That's correct.
But the point is, my lord, afterwards it has been held that this is mandatory. This is a mandatory nature. Now, my lord, two things, my lord. I've heard. Yes, I'll show, my lord, rule 20, my lord. First of all, this judgment says 81(1) means presentation before the High Court. It has to be before the High Court. There are several orders where High Court has, if the election petition comes, it's presented before the court itself. It's not with the registrar. The registrar undertakes the regular work which the registrar has to undertake in original site manner. That has been included in Rule 20. And that does not say that registrar will look into 81(1) presentation. It's not incorporated. It is not incorporated. Now, my lord, registrar looks into two or three things. One is, my lord, your lordship, in this case also, my lord, there is an allegation of corrupt practice.
there is an allegation of corrupt practice. When that allegation of corrupt practice, your lordship knows better than me, it requires a separate affidavit. And with regard to the other parts of the application, then that requires separate affidavit. Then, putting in the security amount. These are the things which the registrar will see.
Now we can take otherwise. Okay, you have not raised this point of maintainability, and point of maintainability can be raised at
Any point of time.
No problem. Point of law can be raised at any point of time. Now you are raised. If in the meantime the petitioner present before the court and given the evidence, what would be the effect of that?
The time period, your lordship has only held in my case, that I'm also facing on the same point, Your lordship has found that there is a time period, 14 days. I'm relying on your lordship.
Not 14. I am not on that. I am telling, as per this, if the petitioner presence is not mandatory, and if the petitioner not present, then it is to be dismissed. Correct, no problem, because the object is that court has to ascertain the genuineness of the party, whether the genuine party has filed the election petition or not. That is the only object.
No, I'm not looking to the object. Kindly does not take me, Miss Malad. I'm not looking to the object only, Malad. This judgment, also your lordship's order, Malad. Both says there's a time period fixed. Presentation has to be done within a time period. That time period is no more there. That has expired.
When?
45 days.
It is not your case that it is the election petition was filed after the time period.
I could not.
It is not the case that the election petition was filed after the time period. This is not your case.
No, that is what I'm on. Kindly appreciate my submission, Malad. Filing of an election petition has two contingencies.
Correct.
One is it has a time period. Another is it has to be presented in person.
Correct.
Without that, there is no filing.
Correct.
So the time period will not stop running.
Filing in the court, it is mentioned. What is the?
Let us see. Let us see the language, Malad, of 81(1), Malad.
Yes.
And that is also what the Supreme Court says.
Yes.
The Supreme Court judgment also says the same thing. But let us come to 81(1), Malad.
Yes.
Kindly, Malad. Supreme Court. An election petition calling in question any election may be presented one or more of the grounds specified in subsection 1 of section 100 and section 101 by any candidate at such election or any elector within 45 days from but not earlier than the date of election of the returned candidate, or there are more than one candidate. So, this is the 45 days. Now, kindly see. 81(1), present. May be presented. So, the first question is, it has to be presented.
Correct.
Now, this has been, it has to be presented within 45 days.
Correct.
So, today, 45 days started running. Let us, for hypothetical situation, let us find that register is not the right person. Your lordship is the right person,
No, that's why. An application and petition calling a question of may be presented on one or more ground. May be presented.
Yes.
On more and on ground.
Within 45 days.
Prescribed under section within 45 days.
Yes.
Correct. Presented means what? What is the meaning of
that is what I want, presented means what the Supreme Court has said in person.
Come to the Supreme Court order.
Yes, kindly, Supreme Court though. Supreme Court 2009.
Para 1 and para 4.
14.
When it kindly comes to 14 once.
14?
14 of that judgment, 2009-8 SCC,
Yes.
At 14. A close look at section 81 reveals that the two remaining subsections after the amendment introduced by the Act of 47 deal with two distinct but interrelated issues. Subsection 1 deals with the necessary requirements of any petition challenging an election. So presentation becomes part of it. And subsection 3 deals with additional requirements as the petition presented. Subsection 1 has 5 components.
Correct.
2 is the petition must be presented by the petitioner, and 4 is it must be presented in the High Court.
High Court.
And it must be presented within 45 days from but not earlier than the date of election of the return candidates.
Correct.
Now, Malad kindly sees is further said by section 86(1), which was that the High Court shall dismiss an election petition does not comply with the provisions of section 81.
Correct.
Now, Malad kindly sees Straight away, para 19, I have shown your lordship
Yes.
a few minutes back, my lord.
Strict construction 16.
When it kindly comes to once, sorry, my lord. No, it doesn't. Then my lord will kindly come to once. Para 19, my lord. Para 20 in this context, earlier edition of this code, in interpretation section 81(1) must be understood in sure Shadon. The High Court has found that the matter as a fact, election bill was presented to the registry by an advocate's clerk in the immediate presence of the petition. Therefore, in substance, though not in
Yes,
form, it was
kindly see. The High Court has found as the fact that the election petition was presented to the registry by an advocate clerk in the immediate presence of the petition. Therefore, substance, though not in form, it was presented by the petitioner himself. Hence, the requirement was fully satisfied.
Manat kindly sees thereafter, Manat, para 21 onwards, Manat. It is to be noted that in Sure Shadon Singh's case, not in dispute, the petition was present to the registry in the immediate presence of the petitioner.
Correct.
In other words, the office authority, Manat, I am not aware of what is the report of the registrar. So, Manat, your lordship will know better than
That I will see, yes.
So, I cannot comment on that.
Yes.
In other words, the officer authorized by the High Court had an opportunity to verify him, but in the case on hand, admittedly, it was presented only by the advocate and the petitioners were not present before the registrar.
Yes.
In view of the same, the said decision is not helpful to the applicant's case. So it was on a factual basis whether the person was before the registrar or not.
Correct.
Now the rules of that court, Malad, obviously provided for that the registrar can do the needful. Malad, I will just place the rules of this court, Malad, and we'll see whether that has been given to the registry, that power to for presentation of election petition, Malad. Then Malad kindly sees. Para 24, Malad, and 25, Malad, holding that it has to be personally present before the authorized officer. Now, Malad, my learned friend says that the registrar is the authorized officer. So, Malad, then the registrar must have said it is presented in terms of section 81. That must be the finding, Malad. Whatever I have come to understand, Malad, the registrar has found that the petition is in form. That is it. I don't know whether it is recorded that someone was present. Now, Malad, kindly comes the rules.
Court has it.
Malad has it. The rules your lordship has. Sorry. And before I go there, one single point, may I just take over first, but that's an easier point. One of the question of master summons and notice of motion. But first of all, Malad, original side rules, Malad, first of all, there is gallows judgments.
I am not going into that technical aspect. I am not going.
That is the case.
That
Let us then come back
in the open court, I am telling that I am not going into that technical aspect.
Because that is, and Malad, it talks about plaint. This is not a plaint, Malad. Even 2009 says so. Now, Malad kindly sees rule 19, Malad. Oh, no, 20.
19 goes against you.
1920 both.
1920 both, Malad. May I just say? A copy of every addition made by any party to the election proceedings or by any person desirous of being made a respondent, the copy of the statement or particulars and notice referred to in the provisions of subsection 1 or section 97 in the form of an application as prescribed by Rule 10 shall be served on the other parties of proceeding or on his or their advocate once the application notice is present and moved before the judge. So, Malad, proceeding and application or notice is presented to and moved before the judge. So, Malad, the election petition itself is the application. It needs to be moved before a judge. And why is that, Malad?
Naturally, it has to be moved to the judge. Without moving the judge, how the notice will be issued?
Malad, I'm on that, Malad. Malad, your lordship will kindly see 81(1) couples two things together. So it is, Malad, kindly excuse my French, Malad, but it would be undesirable that for presentation, certain things go to the registrar, and on the same breath, on presentation, your lordship will have to see whether it fulfills the grounds And for that, it will come to your lordship, my lord. So, my lord, that interpretation, to give that interpretation, then we have to divide the meaning of High Court. So that is something which, on those cases, well, those specifically given by the High Court rules. But I am trying to find out, kindly see now Rule 20, upon an election petition by any candidate of an election relating to an election being
Presented in the accordance with the
presented in accordance with the provisions of the Act, these rules will the registrar original site within the time prescribed by subsection 1.
Correct. Such petition shall be deemed to be the
Within the time prescribed by subsection 1 and
before the
such
High Court.
petition shall be deemed to have been presented before the High Court at Calcutta under section 81.
Correct.
Now, my lord, kindly see, upon and by any candidate of an election relating to an election being presented according to provisions, these rules before the registrar
Correct.
within the time within the time prescribed by subsection 1.
Correct.
So, my lord, there has to be a presentation. He is saying there is a presentation. Now, my lord, that has to be first recorded in the registrar's order. That there is in a presentation on that day, the person was there. One. Second is, my lord, when the petition is being filed for your lordship, my lord, your lordship knows better than me, my lord, where, my lord, the Act says something, and this is in excess of the Act, but the Act should prevail. Now, if your lordship, my lord, holds also that the registrar has the power, the registrar must then record that he was present and it's under the 5 grounds under the provision. That needs to be there.
That's why the 2009 volume 8 starts where from it starts. It starts from the objection raised by the registry. Petitioner was not present.
Because there the registry has been granted that power.
No, kindly see. That's why the registry
has been granted that power.
Paragraph 1, the presentation so and so upheld the objection of the registry that there was no proper presentation of the electorate in terms of section 81.
But I agree. So therefore, I say, my lord, the registry must have found it.
Okay. Anything further?
Better.
Anything
I
further?
think things are better now. I've just been told I've not got the order, my lord.
This was I'll tell your lordship what was
Yes,
happening,
yes.
my lord. I was held back, my lord. A submission has been made before the Honorable Supreme Court that they had actually filed the application on the 22nd of September, but the Honorable Court has wrongly recorded it as 24th. Now, my lord, a stay has been issued. I am told, my lord. I just received a message, my lord. My lord, let us wait.
Better than me, my lord.
Let us
I'm
wait.
here as an officer of your lordship's court, my lord. I cannot make arguments like this, my lord. I've been just instructed. I'm just saying.
Arguments, my lord, showing decisions, my lord, while replying, my lord.
So stay, no?
I don't know. I've been told.
It has been stayed for 2 weeks, my lord.
I've just been told, my lord.
Record an order. It is informed from the bar that the SLP prepared by the private respondent number 6 and the applicant against the order passed by this court dated.
It was dated.
Dated 26/11/2025. The Honorable Supreme Court has stayed the proceeding of the election petition.
That's
Stay of the order.
My lord, what I'm getting from here, my lord, I'm finding that, my lord, again, my lord, on instruction, that the records have been called for by a sealed cover and stay of all further proceedings. But, my lord, obviously, I'll get that by tomorrow, my lord. If your lordship wants to keep it tomorrow, I can come and inform. Tomorrow, with the information.
Get official letter also.
They were present. Mr. Sham Diwan was. They were on caveat, my lord.
But the proceedings have been stayed. I am told, my lord.
You will say the same thing.
And the Supreme Court stayed
ठीक है, हमको तो
the
आटके रख
proceeding
दो, है ना?
of the present election petition being
हैं,
EP
वहाँ से क्यों है? नोट
of
क्या है भाई?
2024 for the period of 2 weeks.
After 2 weeks, that will be returnable.
In view of the above, let the matter
Boले,
out of the list for the present
with liberty to mention.
liberty to mention by the parties after notice to the parties.
Very grateful.
You have wasted my 1 hour.
My lord, kindly keep it in mind, my lord, when we come back, my lord, regarding my submissions regarding cost. The records have been directed to be transferred. Records have been directed to be transferred because the entire SLP rests on the premise, my lord, that it has been filed on 22nd.
But I've been told
that that will be better if it is decided.
Yes.
So which date it will be taken as a filing case? It is the
yes.
Because that in our original said that I have faced in that determination also. Which
They affirmed it on the 22nd, but it was filed on the
because
24th.
of that, in the commercial, that
Commercial
written
statement.
statement.
Indian statement. Still going round and round with it.
Grateful to you, Lord.
Very grateful, and I'm sorry.
Thank you, no problem.
In item number 6, Mr. Thakkar was to give reply.
Yes.
We had concluded our submissions.
Yes.
In the interregnum, your lordship, what has happened is your lordship has already vacated the interim order that was operating against all defendants as against the defendant number 6 and 7 by your lordship's order dated 16th 9 2025. Your lordship is pleased to vacate
Yes.
subsisting order of injunction as against all the defendants,
6 and
only
7.
against 6 and 7. Because, and the insofar as the other defendants are concerned, the hearing could not conclude because Mr. Thakkar was to conclude with his reply to our.
Correct.
It is at that stage. Only one indulgence, your lordship. I had the benefit of producing your lordship's order. Now, the findings at 29 to 32 completely covers us as well, because our involvement in the entire transaction was at a lesser footing, and each and every reasoning that has been given covers us. But subject to Mr. Thakkar's reply,
Not subject to appeal also.
appeal, I'm not aware of any appeal. Till date, there is no appeal.
8, 9 and 13, 14. But we have the same footage. Well, if one of the transactions find out has
But we
I would even urge
we are
that
in
we
the
are at a
process
slightly
of
better
that is
footing.
that is all I can say. We're in the process of, but because it's a foreign company, so there are a lot of other
Maybe,
issues.
maybe.
as
I'm
well.
not
So
saying that.
as
I'm
on
not
date, there
saying
is no
anything.
appeal.
All I'm saying is your lordship's reasoning that subsists as of date completely covers us. In any case, Mr. Thakkar was to give reply. So my only indulgence was let the order be not be extended in the interim. He's
Yes.
very surprised.
So when ready?
Mr. Thakkar was here just a while back. Till just a while back, he was here.
My only request is your lordship, given the fact that we have been suffering this order for a while now, any short date, let them conclude this side of the holidays.
Huh?
Let them conclude so that we also
Yes,
have a
yes.
nice Christmas. Merry Christmas.
But we were there to ready to argue today, but the previous
No, no,
matter
no,
had taken a.
I have no
Mr. Thakkar was
insinuation.
there.
Mr. Thakkar was
Mr.
here.
Thakkar was there, but his matter has got called.
The counsel for the plaintiff raised for adjournment. Recording case is adjourned.
But otherwise, I would have started. But because of this order, I am not wanting to take any risk.
For the plaintiff submit praise for action of the interim order.
Now, Mr. Gupta has to surmount your lordship's reasoning.
5th of December 2020. Accordingly, interim order is extended till 19th of December 2025 or until further order, whichever is earlier. Let the matter remain in the list. Remain in the list.
Some precedence may be given, your lordship, subject to you as it comments, your lordship. Very well, very. We'll take our chances.
But only thing Mr. Thakkar would is not there tomorrow. So if it is taken up, I shall pray for. Otherwise, let it remain in the list. In case it is taken.
Is extremely competent.
But after this order, my lord, I am not wanting to, my lord, take any risk. But I have the benefit of a senior. Let him.
Let us all take our chances, your lordship.
Otherwise,
We'll
I
come
could have
back.
started. Otherwise, I am ready. But after this order, my lord,
I'm
Again allowing me to go through all the talk.
Grateful.
Okay,
Deeply
thank
obliged.
you.
Chief, item number 7 is the plaintiff's application and order 7, rule 11, my lord.
Yes.
Lordship may recall this concerns section 22 of the Hindu Succession Act, my lord.
Yeah.
Property of joint property, aunt and nephew, my lord. Nephew has sold it to a third party without the aunt's consent, my lord. The aunt is asserting a right, my lord, of preemption under section 22, my lord.
Yes, yes, yes.
My lord, we had concluded, my lord, the plaintiff defendants were
My counsel, Mr. Kushal, ask.
I was stuck in other court. My lord, a brief recapitulation. My lord, this is an application filed by my learned senior friend's client.
Yes.
The defendants, my lord, where they have prayed to pass an order on judgment upon admission. Now, my lord, the suit which has been filed by them, my lord, is under my lord section 22 of the my lord
Hindu sector.
Hindu Succession Act.
Yes.
Now, my lord, I have argued on the last occasion that first of all, my lord, the plaintiffs and the defendants do not fall under the category of class 1 heirs. Now, my lord, why, my lord? That if my lord sees the array of parties, and my lord, fact, my lord, accept the plaint for a moment. My lord may take a note of, my lord, of the fact that the property originally belonged to Vidyut Vikas Basu and my
Anima
lord,
Bose.
Anima Basu.
Yeah.
My lord, they both have two daughters,
Correct.
Shutopa and Shubrata. Now, my lord, from Shutopa, my lord, who died on 4th of September 2020, my lord, his son Supriyo Ghosh and husband Satyonarayan Ghosh were left behind. Supriyo Ghosh is the defendant number 2 here.
Correct.
And my lord, the plaintiff is my lord
Subrata Singh.
Shutopa. So therefore, my lord, under if my lord takes up the Hindu Succession Act in the category of class 1 heir, my lord, son, daughter, widow, mother, son of a predecessor, daughter of a predecessor, son of a predecessor daughter, daughter of a predecessor daughter, my lord, and so on. So, my lord, Subroto, my lord, is not the class 1 heir of Supriyo. My lord, Supriyo's class 1 heir would be, my lord, his son, daughter, widow.
Original, the owner is the Vidyut and Animo.
Yes. Yes.
Both died,
Yes.
leaving behind two daughters.
Yes.
That is the Sutapa and Subroto.
Yes.
Correct.
Yes.
Subroto is here.
Subroto is here.
Sutapa died,
Sutapa
leaving
died.
behind two legal heirs.
Yes.
Correct. So that is Supriyo is the.
My lord, an aunt cannot be a class 1 heir under no imagination of Hindu Succession Act.
Aunt means?
Aunt means Subroto. My lord, Supriyo's aunt is Subroto.
Subroto.
Yes.
Subroto is the daughter of the original owner.
Absolutely, my lord. Suppose, my lord, from my father, we are 3 brothers. Now, my lord, my son would be the, my lord, nephew of my other brother, my lord, or the, my lord, uncle.
From where from you counting the relationship?
Yes, contain the relation is, my lord, if my lord takes up the provision now, section 22.
Preferential right.
My lord, preferential right to acquire property in certain cases.
Correct.
Where, after the commencement of this act,
Yes.
an interest in any immovable property of an intestate.
Correct.
My lord, this is very, very important. Or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon 2 or more heirs specified in class 1 of the schedule. We are pausing here for a moment. So, my lord, who is, my lord, dying intestate here?
Who?
My lord, the question
died?
is one who dies intestate. The property devolves upon class 1 heir.
Correct.
My lord, suppose, my lord, Subroto dies.
Hmm.
My lord, Subroto's heir would not be Supriyo. Subroto's son and daughters will not what be the class 1 heirs.
Correct.
Similarly, if Supriyo dies, my lord, his class 1 heir would be different.
Now you
Now, my lord,
you
now carrying forward.
come to serially. Come
Yes.
to serially. Vidyut and Anima, there are 2 daughters.
Yes.
Correct.
2 daughters are class 1 heir.
That are class 1. So here the Subrata is the plaintiff.
Subrata is the plaintiff.
He is the
He
class 1 heir.
Yes.
So there is no difficulty on
He is
that.
class 1 to Shutopa. Subroto is class 1 to Shutopa. My lord, it has to be in relation to the person who is selling the property. My lord, it is not in relation to the, my lord, branch of a tree, my lord, relating back to any stage.
Correct.
So, my lord, if I am selling today my share, my lord, the class 1 heir of mine has to come before the court. The provision is that.
Kindly read the 22.
Yes. Devolves upon 2 or more heirs specified in class 1 of the schedule.
Correct.
And any one of such heirs. So, my lord, such heirs relate to the class 1 heirs.
Proposes to transfer
Proposes to transfer his or her interest.
Correct.
So, my lord, when Supriyo is proposing to transfer, then my lord, class 1 heir of Supriyo has to come. So, my lord, class 1 heir of Supriyo is not Subroto. My lord, am I clear, my lord?
Class 1 of the schedule, any one of such heir proposes to transfer
Yes.
his or her interest in the property or business.
Yes.
The other heirs shall have the preferential
Yes.
right to acquire
Yes.
the interest proposed to be transferred.
Yes.
So now come directly.
Yes.
So this originally belongs to Vidyut and
Vidyut and Anima.
Death,
Two
Subroto
daughters.
and Sutapo.
2 daughters.
They are the legal heirs of class
Yes.
1 legal heirs.
Class 1 legal.
Subroto alive.
Alive.
Sutapa died.
Died.
Correct. Now Subroto intend to sell the property. Correct.
Correct.
Sutapa, so he is having the right of class 1 here of the Anima, Vidyut and Anima.
My lord, here is the, my lord, I join an issue. My lord, when the right.
No, that I am coming
Yes, yes,
to.
yes.
I am coming to your question.
Yes.
So he has a right of the 50% of the share of the Anima and
Yes, yes, that is by law of succession she has.
Succession she is
She
having
has.
a right.
She has a
Now Sutapa. Now the Subroto died. Subroto wanted to sell the property.
Yes.
Correct. Now your case is Sutapa is no more.
No more.
Sutapa is no more. Now Sutapa's legal heir is the Supriyo.
Supriyo.
Defendant number 2. Correct. So you, as per your case, the Supriyo is have a preferential right in terms of section 22.
It is their case. My lord, I am the defendant. I am appearing
So
for
what
defense.
is your right? What you are claiming?
My lord, I am not claiming any right. Subroto, the plaintiffs, are saying that I have a preferential right. My lord, why they are saying preferential right? Because I belong to the class 1 here.
Correct.
Now, my lord, the question is, my lord kindly turns to my lord her pleading, my lord, in the plaint. বলছি but kindly comes to my lord page or paragraph 6. First, while being seized and possessed of the said premises, said Vidyut Bikash Basu died intestate on 3rd of June 2005, leaving behind his widow, namely Anima Basu, since deceased, and 2 married daughters, namely Sutopa Ghosh and Subroto Sarkar, being the plaintiffs herein, who inherited the property jointly by operation of law.
Correct.
Correct.
No problem.
Subsequently, Anima Basu, widow of Vidyut Bikash Basu, also died intestate on 20th April 2014. On her demise, the 2 married daughters, namely Sutopa Ghosh and Subroto Sarkar, inherited the said premises as her legal heir and representative. Her surviving as per Hindu Succession Act. No problem to this. The plaintiff and the said Sutopa Ghosh thus became joint owners of the said suit premises, being the residential dwelling house. Then Millard kindly turns to paragraph. Shupata Ghosh consequently died intestate on or about 4th of September 2020, leaving behind her husband Satyonarayan Ghosh and 1 son Supriyo Ghosh, being the defendant number 2 herein. On August 2021, second, Satyonarayan Ghosh also died intestate, leaving behind his only son Supriyo Ghosh, being the defendant number 2 herein, as the only legal heir and legal representative, him surviving. Thus, on the demise of Sutopa Ghosh and Satyonarayan Ghosh, the plaintiff along with the defendant became joint owners. Millard marks this. Millard, they become joint owners is something else. And class 1 heirs are something else. Milord, joint tenor by operation of law, suit for partition, everything, Milord, I am accepting. But to come under 22, Milord, he has to be in the class 1 heir.
Correct. Thus, the demise
Having-
of Sudapra, Satyanarayan, the plaintiff along with the defendant number 2 become joint owner.
Joint owner. So, Milord, he says he is joint owner, not the class 1 in plain. So, Milord, his plain case is not class 1.
Okay.
So, therefore, Milord, he continues with the joint ownership and then, Milord, takes up, Milord, 44 of the Transfer of Property Act in his pleading that who purchased it, he cannot enter into the possession of the suit premises.
Correct.
Because it's a dwelling house.
Correct.
Now, therefore, Milord, if the plain case is on joint ownership, not on class 1 heirs, Milord, then I respectfully submit, Milord, in Order 12 Rule 17, Order 12 Rule 6, petition, Milord, he cannot change a pleading and say, Milord, I belong to class 1. And if he says so also, Milord, I say, Milord, class 1 is or heir is always according to the schedule of the death of the deceased person. So, Milord, if I die, Milord, it's the class 1 heir whom I leave. Milord, it's not the heir who's my father left. But kindly visualize the situation, what I'm saying. Milord, my father has left 3 sons. One of the son dies. So, Milord, son's legal heir, Milord, will fall into the class 1, class 2, class 3 heirs. Not the father's legal heir who are surviving with the deceased legal heirs of the son. Milord, my brother cannot be the first class heir of my son. Cannot be, because that is not the Hindu succession.
Correct. That's correct. There is no.
So, therefore, 22, when it says such heirs referred in class 1, Milord, kindly read the provision slowly, Milord. I read it very slowly. Where, after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon 2 or more heirs specified in class 1 of the schedule, and any one of such heirs, so Milord, heirs belonging to class 1, proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred.
Okay.
But yes.
So your question is that they cannot treat it as their case is not as a class 1 here. Even they cannot treat the class 1 here if it is not the preferential right.
Absolutely. So, Milord, they do not fall under 22.
Okay.
Milord, on the last occasion, I have handed over 2 decisions, Milord. If my Lord,
Yes, I have.
One Kerala, if my Lord takes up, Milord, just for recapitulation, will not take much time. One Kerala and one of our High Court.
Yes.
I have got the High Court, Milord, our High Court decision. Milord.
Yes, got it. When section 22 applies, no?
Yes.
Yes, I take a note of it.
Yes, Milord, there also, Milord, I referred just, Milord, paragraph 10, just for my Lord's recap.
You have taken note of it.
Mr. Roy Chaudhury's submission, the applicant must also be an heir of class 1. So that was upheld, and Milord, 17, 18.
Okay.
My Lord has taken note, paragraph 20 also, Milord. And this refers to a Kerala decision where, Milord, I would only now, Milord, join this Kerala decision which I have already handed over. Milord, my Lord will read this decision. Milord, I am not troubling with reading with the decision. Milord, here a transfer has happened. Milord, kindly marks the word of section 22(1). Milord, it's a case where there is a proposal of transfer. At that stage, a preferential right comes in. So, Milord, that stage has crossed. Milord, there is a sale done. So, Milord, it is no more at proposal stage. So, there is no applicability of 22(1) per se. So, Milord, and Kerala and our High Court says so also. Milord, the suit, Milord, which he has prayed for, if my Lord looks into the prayer, or Milord, I read it for my Lord, declaration that the transfer of right, title and interest by the defendant number 2 in favor of defendant number 1 in respect of his 50% undivided share in the property being premises number such and such, virtue of deed of conveyance dated such and such is illegal, unsustainable and bad in law. Milord, he is not claiming a preferential right in the suit. Milord, he is saying, you cancel this deed because I have a right. So, Milord, he is not coming under, Milord, my next submission is under 22.2. Milord, if Milord takes 22.2, the consideration for which any interest in the property of the deceased may be transferred under this section shall, in absence of any agreement between the parties, be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all costs of or incident to the application. So, my lord, 22.1 is filed in a way of an application before the court. It cannot be registered as a suit. But under the civil rules and order, an application is registered under this case.
Claiming preferential right.
Claiming preferential right. So, my lord, this 22.2, my lord, which was in the meantime, my lord has seen the orders where my lord has proposed that whether they want to buy at that price. This 22.2 has no
cost is to be
application. So, my lord, if this 22
that 22.2 is the subsequent to the conditions.
Absolutely.
If it is agreed by the parties under 22, then the 22, then the 2 will be the conditions.
Absolutely. So, my lord, if it's at the proposal stage, my lord, he comes to the court that I have a preferential right, kindly direct them to sell me. Now, court appoints somebody to say that this is the figure, are you ready to buy? If he doesn't agree, I have a right to sell to third party. So, my lord, since there is already a sale occurred, so, my lord, there is no question of applicability of 22.2 as well. Now, making this submission.
Yes.
Now, my lord, 3 would be important, my lord, to strengthen my argument. 22.3.
Yes.
If there are 2 or more heirs specified in class 1 of the schedule proposing to acquire any interest under this section, that heir who offers the highest consideration for the transfer shall be preferred. So, my lord, it is always between the class 1 heirs. When nobody excluding the class 1 heirs can come in.
Yes.
Now, my lord, so therefore, my lord, today actually the suit, my lord, which requires a trial, my lord, I say, my lord, and this our High Court and Kerala says why it requires a full length trial, because court has to examine whether I have flouted the condition of 22.1 or not. It's not a suit under 22.1, but court has to examine the conditions have been flouted or not. That's why it is registered as suit, and the prayer is seeking cancellation of that deed, not seeking a preferential right to sell me the share.
Yes.
Apropos this, my lord, in his pleading, my lord, he himself has stated, my lord, initially he was aware that I was going to sell the property. That is, my lord takes the plate.
Yes.
Paragraph 12. Since beginning of year 2020, the defendant number 2 approached the plaintiff with a request to agree to sell the premises as a whole. He was facing financial difficulty. It is pertinent to mention that defendant number 2 is presently aged about 47, is unemployed and dependent upon the funds inherited from
Paragraph 12.
Paragraph 12 of the plaintiff.
That is missing.
What has got?
The J5 file J2, na?
Yes, my lord.
Page 32, 33.
Oh, my lord is looking at the amendment application. From that, my lord.
Okay, I am okay. Because in that there is no the paragraph is missing.
Very good.
प्रिंट नहीं है क्या? शूट नहीं है?
Yes, my lord. Internal page 5 of that application will also do. Same cleaning is there.
Page 5.
Yes, internal page 5, Roman 12. Instead of paragraph 12, it's Roman 12.
Yes.
Volume 1.
Yes.
Since the beginning of the year 2023, the respondent number 2 approached the petitioner with a request to agree to sell the premises as a whole, as he was facing financial difficulties. It is pertinent to mention that the respondent number 2 is presently aged about 47 years, is unemployed, and is dependent upon the funds inherited from his parents. So, my lord, the plaintiffs were aware, my lord, the other co-sharers were, my lord, going to sell the property. And, my lord, he approached the plaintiff that, look, if we sell together, it would be better. So, my lord, first is, my lord, this requires evidence. Why I say and trial? Why I say this? Because I can show, my lord, on this statement on oath made by them that we have offered them, my lord, with regard to the sale, and that point of time they have shown displeasure not to buy the property. My lord, this is a part of trial. My lord, I cannot prove at this stage, but my lord, I make this submission because there are statements that she was aware, the plaintiffs were aware of a sale which is going to take place. So, my lord, he doesn't come at that stage before the court under 22(2), doesn't file an application that they are proposing to sell, I want to buy it.
Okay.
So they miss their bus at that stage. So, my lord, today by this application, this order 12 rule 6, my lord, my another submission is actually, my lord, an application under order 22, section 22 rule 2. Because if my lord sees the prayer, my lord, he's saying kindly see, takes up prayer E in the application. My lord, in the alternative deed of conveyance dated such and such be declared null and void, and the plaintiff petitioner be directed to pay 30 lakhs. So, my lord, he is actually, my lord, under 22(2) at this stage. My lord, what he cannot get directly, my lord, he cannot get it indirectly.
Yes.
My lord, this is one part. My lord, second part is, my lord, with regard to the, my lord, 44 of the Transfer of Property Act, my lord, where they are saying judgment upon.
How much time will it take?
My lord, more 10-15 minutes, not more than that. My lord, keeps it tomorrow, my lord, I will finish it.
May be taken up day after tomorrow. A suit is fixed and after this.
I have no problem. My lord, any day. My lord.
And counsel for the defendant has argued the matter at length, but due to paucity of time, not be completed. Let the matter appear on 5th December. 5th. Yes.
Item number 5, the written note of argument might have directed to submissions.
Which one?
Subject, item number 5.
Of the appellate side?
Yes, for the petitioner. I am just submitting with along with the judgment.
तो दे दो फाइल में लग
Along with the judgments with along with the judgments that Mr. Basu relied upon.
तो कौन सा मैटर? आइटम नंबर 5